That is
There is a public interest litigation is going on.
up to that date. Next.
Serial number 20, can it be, but after 2 weeks, 2024 matter?
2024 matter.
I requested my learner.
After vacation, we will have. that.
ಆಗ್ಬೋದು. One small submission, Lordship, ಅದರಲ್ಲಿ connected with 31 of 23 ಅಂತ ಇದೆ. It's 31 of 22.
ಅಲ್ಲಿ ನೋಡು 31 of 22 ಮಾಡ್ಬೇಕು. ನಾ
ಅದೇ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ.
22.
ಅದು 22 ಮಾಡ್ಬೇಕು. Call after vacation at the request of both persons.
Deeply obliged.
Entry ಮಾಡ್ರಿ ಇದೇನೋ
No, my,
ನಿಮ್ಗಿದೆಯಾ?
ಇದೆ.
ಏನಿಲ್ಲ.
Your Worship, CM 36, Your Worship.
ಹಾ
I may be permitted to withdraw the appeal, Your Worship.
36 ಹೆಸರು ಹೇಳಿ ಮತ್ತೆ ನೀವು ಯಾರ್ದಾರ ಅಪೀಲ್ ವಿಡ್ರಾ
Udupi Nirmitike.
ಹಾ
I am appearing for the appellant, Your Worship.
ಹಾ
I am permitted. Yes, Your Worship.
ಎರಡನ್ನು
36.1 also.
36.1 ಮಾತ್ರ
Both appeals.
ಗೊತ್ತು ನೋಡಮ್ಮ ಮೆಮೊ ಹಾಕಿದಾರನು ಮೆಮೊ ರೀಡ್ಸ್ ಆಸ್ ಅಂಡರ್ disposed of as having been withdrawn in terms of memo. ಅಲ್ಲಿ ಯಾರು ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ಫಾರ್ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಯಾರನ್ನ ತೋರಿಸಿದಾರ ಅವ್ರು ತೋರಿಸ್ಬಿಡಿ. ವಿಡ್ರಾವಲ್ ಇದ್ದಲ್ಲಿ ಗೌರ್ಮೆಂಟ್ ಲಾಯರ್ಸ್ ಅಂತ ತೋರಿಸೋಕೆ ಅವರಿಗೆಲ್ಲ ಬಹಳ ಕಡಿಮೆ ಇದನ್ನ ಮಾಡಿರ್ತಾರೆ ಇವರು ಫಿಕ್ಸೇಷನ್. ಓಕೆ ವರ್ಕ್ ಮಾಡ್ತಾ ಇಲ್ಲ ನಮ್ಮ ಸಿಸ್ಟಮ್ ವರ್ಕ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಓಕೆ
Serial number 34, my lord.
34
Seeking for a short adjournment, my lord.
ಯಾವ ಇಯರ್
2022, my lord.
22 ಇಲ್ಲ ಮತ್ತೆ ಅಡ್ಜರ್ಮೆಂಟ್ ಕೇಳಿದ್ರೆ ಹೆಂಗೆ?
Next week it may be taken up, my lord.
After vacation at the request of reluctantly adjourned. Call after vacation at the request of. Yes. Memo reads as under permitted to be.
Lordship, if it is not too inconvenient,
Ah.
I request for a hand delivery of the order.
And delivery.
I have to upload it.
ಬೇಗ ವಿಡ್ರಾಲ್ ಒಂದ ದಿವಸ ಮಾಡಿರ್ತೀವಿ
Yes.
ನೋಡ್ರಿ ನಾವೆಲ್ಲ ವಿಡ್ರಾವಲ್ ಇಮಿಡಿಯೇಟ್ಲಿ ಅಪ್ಲೋಡ್ we upload every order and go home.
Yes.
Barring very important matters. We'll do that.
Grateful.
Okay.
Lords, I'm appearing for the respondent. My lords, in both serial number 2 and 2.1, the SC has settled the matter under the Vivad Se Vishwas scheme, my lords. In serial number 2, I have filed my memo with all the supporting documents. In serial number 2.1, I'll shortly file it, my lords. I've informed the standing council that both matters are settled and therefore they may have to
Settled.
withdraw.
We'll dispose of them.
Yes, my lord.
It is submitted by the learned counsel appearing for the assessee and not much disputed by the panel counsel appearing for the revenue, that lists in these, in separate order, my brother.
Please.
Lists in this appeal has been settled under Vivad Se
Vishwas.
Vishwas scheme. And therefore, the same be accordingly disposed of. First, ordered accordingly. And appeal is disposed of. Separate order ಮಾಡಬೇಕು.
Please.
Grateful.
Okay.
My lord, there are 5 appeals of the same assessee, my lord. So all the and acknowledgement I'll just produce, my lords. Just sent, maybe after two weeks, my lords.
After 2 weeks.
2 weeks, my lords.
ಮತ್ತೇನದು steps ಏನಂತ ಏನದು?
I've taken hand summons also, my lords, that we are serving, my lords.
You are serving.
Yes, yes, my lords. The 5 appeals, my lords, I'll get all the 5 things connected, my lords.
Good. Call this appeal along with other connected matters, list of which would be furnished by the panel counsel. First up, ಅಲ್ಲಿ call ಇದೆ ಅಲ್ಲ, call after vacation along with so and so. Okay. In the meanwhile, steps to be taken. Yes.
Your
Ah.
Worship, seal number 4 and 10 are connected, my lord.
4 and 10,
Yes, my lord. 122 days delay, my lord.
Mr. Nageshwar Rao? Kelta illa. Not audible.
Sir, I'm
Rao
sorry.
Saab.
My apologies, my lord.
All right, all right.
I have filed written submissions. My lords may kindly consider them. That is my request.
Yes, delay. First,
122, my lord.
one put pustaka kodi.
Please.
Rao Sahib kodi.
My lords, I don't want. I am grateful for that.
Pustaka kang helbadu. You are not supposed to say.
I
Pustakastha
accept.
kriya
I
vidya. You
I
say
accept
like-
it. I accept it. My apologies. I accept.
Prakadi. Appeal is filed after booking a delay of 122
22, my lord.
days. First off, an application supported by an affidavit accompanies the appeal, seeking its condonation. First, the assessee has filed his objections to the application, resisting it, telling that delay is long and explanation offered is not plausible. First, Mr. Rao, appearing for the assessee in his usual vehemence, opposes the application, saying that delay has created a kind of right in favor of his client, and that should not be readily taken away. First, next one. Having heard the learned counsel appearing for the parties and having perused the papers.
My lords, if I may say one sentence,
Yes.
because we generally get educated when we come to the court also.
No, we also get educated.
Yes, my lord. That is the reason I am
Correct.
pointing this out. Kindly see in most of these applications that we are condoning. It is the court's prerogative. I have no quarrel with that.
Correct.
But the application is a cyclostyled application, doesn't give any reason. One, the affidavit is first filed, improved, and still doesn't give reasons. That is the reason we are opposing this.
Additional affidavit is filed, my lord.
But the application is silent. So my lords will have to consider someday. In one of the cases, my lord observed, application is the one which is filed in time. Therefore, for the improvement of affidavit cannot be counted for number of days.
All right.
Because we generally get some education, we get enlightened when we place this before the court. I am placing it before the court. I am not arguing any.
Correct.
I am leaving it to the court. I am just bringing facts because otherwise my lords will have to peruse all the facts.
Correct.
That
We
is the
come after reading, Mr. Rao Saab.
My lords.
We have no other business than reading the files.
I
Because
leave it.
no person, no friends like you come to house to say hello to me.
My lords, I am sorry. I'm sorry.
Therefore, generally when we say perused means we have actually read the papers and that.
But
And both we are fast readers also.
very well, my lord.
Very little time we take for reading.
Very well, my
Less
lord.
than 1/4 of what usually others will take. Next paragraph. Having heard the learned counsel for the parties and having perused the appeal papers as well as the application along with affidavit and additional affidavit, we are inclined to grant it prayer for condonation of delay because it is not very long. Semicolon. Secondly, some plausible explanation is offered for the delay, although there is lot of scope for more plausibility. Plausibility, as rightly pointed out by Mr. Rao. First. Thirdly, much older matters than these are languishing in the court cupboards. And therefore, we assume that had the appeal been filed in time, it is not that it would have been taken up for consideration and disposed of by this point. First off, after all, in all civilized jurisdictions, the prayer for condonation of delay is liberally considered subject to all just exceptions. And ours is also a civilized jurisdiction. First, in the above circumstances, application having been favored, delay is condoned, subject to the condition that the revenue shall present, which book you will present
Lordship,
to library? One to our Rao Sahab also, Robin Sharma's monk who sold his Ferrari.
yes, my lord.
That book is necessary because much of your time you are spending on law and life is elsewhere. This is what Denning says in his The Family Story.
Yes, my lord.
His another book is Beyond Law.
Yes, my lord.
Out of 7 books, and that give that book. You give one book to Rao Sahab and Nodama. The revenue shall present one book by Robin Sharma entitled The Monk Who Sold His Ferrari. It is translated to Kannada also.
Yes, my lord.
Ferrari ಮಾರಿದ ಫಕೀರ ಅನ್ಕೊಂಡು ಒಬ್ರು ಟ್ರಾನ್ಸ್ಲೇಟ್ ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನೆಲ್ಲ ಓದ್ಬೇಕು. ಅದರ್ವೈಸ್ ಬರೀ ಡ್ರೈ ಲಾ ಜೊತೆ ನೀವು ಲೈಫ್ ಅನ್ನು ಕಳ್ಕೊಂಡ್ಬಿಡ್ತೀರಿ. ಲೈಫ್ ಈಸ್ ಎಲ್ಸ್ವೇರ್, ವಿಚ್ ಲಾರ್ಡ್ ಯಾರು ಟೆನಿಸನ್ said, where is the life we have lost in living? Where is the wisdom we have lost in knowledge? Where is the knowledge we have lost in information? Of course, one author added, where is the justice we have lost in laws? To that. The American Jewish Supreme Court Judge Aaron Barak added this line to that poem. Lord Byron's poem it is. Lord Byron's poem. Anyway, that's all.
Please.
And 2 books to our association library.
Lordship.
You also read that. It's a very good book.
Yes, my lord. Skill number 10 is also connected with this, my lord.
10 also.
10 also.
Nodama. Same application. Ali, give some other book.
Please. my lord.
Give Law and the Legal Reasoning by Julius Stone. One of the finest books. Okay?
Yes, my lord.
Third library, on the High Court library, the other library.
Yes, my lord.
All right?
Yes.
All right. But we have noted Rao's contention
Yes,
that
ma'am.
again, we cannot mindlessly condone delay in every appeal because you are the union government.
Yes, my lord.
That also you have to keep. And on the 100 days, 125 days, you can understand. Rest of the things, because we don't want to give that impression that wherever you file application, we will allow condonation of delay. No, that we will not do. Yes.
Your lordship, in this case, I could not find this book, my lord. Idea of Justice, I am giving.
Idea of Justice by Amartya Sen.
Yes,
Nobel Prize
Actually,
Peace, you
like,
don't find it.
I am
Day
giving
before
another-
yesterday, I bought one to present to a judge.
Yeah, the next
Which one you are giving?
Your lordship, Jivana Dharma Yoga.
Jivana Dharma, DVGs.
Yes,
DVGs, Jivana Dharma Yoga.
yes, ma'am.
Bhagavad Gita Tatparya.
Yes, ma'am.
It's a good book. But what is the price of that book and price of this book? 925.
Yes, ma'am.
Ah,
ಅದು 500 ಇದೆ.
howda? Ah, very good. So don't ask remaining amount from our pocket. All right, Nodama. The compliance is done by presenting the book.
ಇದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟ್ರ್, ಇದ್ರಲ್ಲಿ ವಾಲ್ಮೀಕಿ ರಾಮಾಯಣ ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
Kuempus, best. He has written another book, Janapriya Ramayana,
Please, ma'am.
and another epic, Ramayana Darshanam.
Yes, ma'am.
One of the best, great author, Kuempu,
Yes,
Kannadada Kampu.
yes, ma'am.
Very good, all right. ಅವನ್ನೆಲ್ಲ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿಬಿಟ್ರೆ ಮುಗಿಯಲ್ಲ, ಓದ್ಬೇಕು.
ಓದ್ತೀನಿ ಸರ್.
ಹ್ಮ್,
ವೆಕೇಶನ್ ಅಲ್ಲಿ ಓದ್ತೀನಿ ಸರ್.
ಓದ್ಬೇಕು. ವೆಕೇಶನ್ ಅಲ್ಲಾದ್ರೂ ಓದ್ಬೇಕು. ಹಾ.
My lord said, outward, my lords, Huli Mavina Mara in this matter.
ಹುಳಿ ಮಾವಿನ ಮರ ಬೈ
Lankesh,
ಲಂಕೇಶ್.
Lankesh, my lords.
ಹಾ,
They
ಕೊಟ್ರಾ?
ran out of publication, my lords. I'll produce any other book, my lords.
ಹೌದಾ?
Yes, my lords, I'll produce any other book.
ಓಕೆ. ಅವ್ರದ್ದೇ ಇನ್ನೊಂದ್ 2-3 ಪುಸ್ತಕ ಕೊಡಿ. ಪಾಪದ ಹೂವುಗಳು ಅಂತ ಒಂದಿದೆ. ಚೆನ್ನಾಗಿದೆ ಅದು.
I'll produce, my lords.
ಈ ಪುಟ್ಟಣ ಕಣ್ಗಳನ್ನ ಮಸಣದ ಹೂವು ಇದೆಯಲ್ಲ, ಅದರಲ್ಲಿ ಕೆಲವು ಪಾರ್ಟ್ಸ್ ಅನ್ನ ಪಾಪದ ಹೂವುಗಳಿಂದ ತಗೊಂಡಾರೆ. ಮಸಣದ ಹೂವು ಫಿಲ್ಮ್.
Yes, my lords.
ಅದನ್ನ ಒಂದ್ 2-3 ಕಾಪಿ ಕೊಟ್ಟು. ಒಂದ್ 5 ಕಾಪಿ ಕೊಟ್ಟು.
Yes, my lords.
5 ಕಾಪೀಸ್ ಮಸಣದ ಹೂವು ಬೈ ಪಿ ಲಂಕೇಶ್. ಓಕೆ, ಟು ಲೈಬ್ರರಿ. ಪಾಪದ ಹೂವುಗಳು. ಮಸಣದ ಹೂವು ಇದೆ, ಬಟ್ ಪಾಪದ ಹೂವುಗಳು. ಮಸಣದ ಹೂವು ಐ ಥಿಂಕ್ ರಸು perhaps. Yes.
But this is below monetary limit, my lords. This will have to be dismissed.
ನೋಡಮ್ಮ, monetary limit, standard order. Registry to send a copy of this order to the assessee. Yes. 9, Vikram Balaji. Yes, Lakshmi Narayana.
This is
Yenidu.
select list of sub-inspector without publication in the final list and without publication in the official gazette.
Objections, sir? ಹಾ. ಎಷ್ಟು ಹಿಂಗ್ಯಾಕ್ ಆಗ್ತಾ ಇದೆ ಎಲ್ಲ KPSC ಇಲ್ಲಿ ಸೆಲೆಕ್ಟ್ ಲಿಸ್ಟ್ ಅದು ಸಬ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ every recruitment is landing in the court. KPSC ಅಲ್ಲ KEA ಆ ಕಮಿಷನರ್ಸ್ ಲೆವೆಲ್ ನೇ ಮಾಡಿದ್ದು, ಪೊಲೀಸ್ ಕಮಿಷನರ್ಸ್ ಲೆವೆಲ್ ನಲ್ಲಿ SP ಲೆವೆಲ್ ನಲ್ಲಿ ಮಾಡಿದಂತ ಸೆಲೆಕ್ಷನ್ ಅಲ್ವಾ? ಹಾ,
ಸೆಲೆಕ್ಷನ್ ಇದು ಸೆಕೆಂಡ್ ಎಕ್ಸಾಮ್ ಆಯ್ತಲ್ಲ, ಒಂದು ಎಕ್ಸಾಮ್ ಕ್ಯಾನ್ಸಲ್ ಆಗಿ
ಈಗೇನು ಇದನ್ನ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಲೆಟರ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಟಾಗಿದೆ. ದೇ ಆರ್ ಅಂಡರ್ ಗೋಯಿಂಗ್ ಟ್ರೈನಿಂಗ್ ಆಲ್ಸೋ.
Training. Last time ತಾವು ಡೈರೆಕ್ಷನ್
Let
ಕೊಟ್ಟಿದ್ರಿ.
them go on training, but no posting.
No posting.
ಕರೆಕ್ಟ್.
ಕೊಟ್ಟಿದ್ರಿ.
ಕೊಡಂಗಿಲ್ಲ.
ಅದು ಹೇಳಿದ್ದಾರೆ.
ಅದ್ ನೋಡಿದೀವಿ ನಾವು ಪೇಪರ್ಸ್ ಎಲ್ಲ. ಬಹಳ ಬಹಳ ಹೊಲ್ಸ್ ಮಾಡ್ತಾ ಇದೀರಿ, ತುಂಬಾ ಹೊಲ್ಸ್ ಮಾಡ್ತಾ ಇದೀರಿ. ಓಕೆ, ಬಹಳ ಹೊಲ್ಸ್ ಮಾಡ್ತಾ ಇದೀರಿ, ಹಂಗೆಲ್ಲ ಮಾಡಬೇಡ್ರಿ. ಮುಂದಿನ ಜನಾಂಗ ಸಹಿಸಲ್ಲ. ಏನು ಎಲ್ಲ ಮುಟ್ಟಿದಲ್ಲೆಲ್ಲ ಹೊಲ್ಸು, ಹಿಂಗಾದ್ರೆ ನಾವ್ ಹೆಂಗ್ ಕೆಲಸ ಮಾಡ್ಬೇಕು? ಯಾವ್ದೋ ಒಂದ್ ಇತ್ಲಾಗ ಆಯ್ತಪ್ಪ ಅತ್ಲ, ಐ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಎಲ್ಲಿ ಕೈ ಹಾಕಿದ್ರ ಅಲ್ಲಿ ಹೊಲ್ಸು, ನಾವ್ ಮಾಡೋದ್ ಹೆಂಗ್ ಕೆಲಸ? ಮತ್ ನಾವ್ ಹಿಂಗ ಬಿಡಕ್ ಬರ್ತದ? ಬಿಟ್ಕೊಂಡು ಹೋಗಕ್ ಬರಲ್ಲ. ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ವಿ ಹ್ಯಾವ್ ಟು ಡ್ರಾ ದ ಲೈನ್.
ಮಾಡ್ಲೇಬೇಕು.
We have to draw the line. We cannot going. Yes, Mr. AAG, you appear for KPSC.
No, my lord,
You are
sir.
not KPSC.
KPSC is not a party here.
Not
So-
connected to KPSC.
This is by the recruitment cell itself.
Okay.
Statement filer.
File ಆಯ್ತು, copies
Lords,
ಮಾಡಿದೀನಿ.
if my lords may see the order passed by my lords on the last date of hearing.
You came running to the court.
Please.
Sit down, we'll pass over.
No, my lords,
You're all right.
I'll manage. Lords, on the last date of hearing, my lords have noted
Correct.
their submission, my lords, that this appointment orders were issued without the final select list being published. Thereafter, my lords, I had made a submission, my lords, by placing the recruitment rule before my lords, pointing out, my lords, what is the legal position. And my lords permitted us to file a statement explaining the circumstances under which, my lords, we have issued the final select list. Issued the appointment orders without the final select list.
You
My lords-
admit that you did not draw the final list.
No, my lords, it is admitted fact. My lords, under the rule
Which
position,
in fact means final selection list is not drawn.
it is not drawn, my lords.
It is not
A
drawn.
proper-
One second, we'll go step by step.
Please.
We do not much know service law. Of course, we don't know much, and we don't much know, at least I don't much know of other laws also.
Please,
But we want to know from your side.
please.
We have great respect for you, for your standing, your
Yes.
acumen, your fairness. Yes. Can there be appointment sans selection list?
My lords,
What's the law on the point? What the apex court said?
my lords, everything will depend on the rule position.
Okay. If the rule provides,
Please, my lords.
if there is an indication that without selection list appointment can be done, definitely it can be.
Please, my lords.
Whether rules do provide here that way?
The rule do not certainly provide here that way, my lords. My lords, if the rule, if the law provides, my lords, that the thing has to be done in a particular manner, it has to be done in that manner or not at all, is the, my lords, the basic settled principle.
So you admit that rule does not provide for issuing appointment orders without drawing final selection list. Do you agree this proposition of law?
Certainly, my lords, I will, insofar as the legal position is concerned, that is the admitted legal position. But
Slowly. The second one is
please,
whether your rules provide invariance.
it does not provide in variance, my lords. But I'll just place it this way, my lords. The rules, my lords, provide for a provisional select list, my lords, to be published. Thereafter, my lords, the rules provide for a medical examination with regard to the physical standards, because it is a PSI civil matter. The physical standards are provided in the rule itself. So a person who does not qualify, my lords, in the medical examination, after the medical examination is concluded, we have to publish in terms of the rules, a revised provisional select list. Here, there are three,
Provisional select list, revised
Provisional
provisional
select
select list, then Final
Then the
selection.
final select list. After, my lord, suppose some people, my lords, do not qualify in the medical test.
They go.
Then they go out. I can also, my lords, pull in the other persons who are down in the merit list so that I can do a revised provisional select list. Thereafter, my lords, I have to conduct an inquiry with regard to the suitability and antecedents of the candidate. That and with regard to the Sindhutva aspects also. After that, my lords, I publish a final select list. So in the rule position, we have.
When Sindhutva is taken before appointment.
Please.
Under the rules itself, which you said.
Please, my lords, under the rules itself, it is before the appointment. Now here, my lords, there are two intervening circumstances, my lords, that have happened in this case. First one, my lords, is that the original notification was done, my lords, in terms of the earlier 371 J circular, my lords, of 2022. Thereafter, before the final select list, my lords, was published in terms of the 2022 circular, which my lords are dealing with, my lords, in a different combination. Now, my lords, though in this batch of petitions, there is no any interim order, my lords, to that extent, because the matter, my lords, is at large. Government, my lords, has taken a decision that whatever interim order was obtaining there, that whoever will be displaced in terms of the earlier list, so the same principle was followed.
Where are your rules? What is the
Minutes.
role of the government in this recruitment process?
My lords, I passed on the rules, my lords.
Rules, buddy. Rule, let us see the legal rule position.
Please, my lords.
ಇದು ಬರೀ amendment rules ಕೊಟ್ಟಿದೆ.
ಇಲ್ಲ, my lord, ಇದ್ರಲ್ಲೇ ಎಲ್ಲ ಇದೆ. Entire thing is available.
Who is the selecting authority?
My lords, selecting authority, my lords, is the ADGP recruitment.
ADGP,
Recruitment, the Additional Director General of Police recruitment.
he will do that.
He will do that.
All right. Then who is the appointing authority?
Lords, appointing authority, my lords, is the concerned commissionerates and the DGPs, my lords.
And the
And
SPs.
no, my lords, I'll just point out, my lords. And it is the Deputy Inspector General of Police, the ranges of different ranges.
Of various ranges.
Please.
How many ranges are there in Karnataka?
Lords, we have
5, 6.
two commissionerates, I'm sorry, my lords, 3 commissionerates,
Bangalore, Hubli, Dharwad,
7
Mysore.
Southern range, my lords, Southern, Eastern, Central, Western, Northern, and Ballari range, my lords, and Northeastern range.
7 ranges.
Please.
Each of the ranges is headed by a DIG,
DIG, my lords. And wherever there is a commissionerate, it is by the commissioner.
commissioner.
Please.
Commissioner is also of equal cadre.
Commissioner, my lords, same rank.
Huh?
It is the same rank,
Same cadre.
same rank.
Ah.
Lords,
Once, slowly, we have to go methodically. What is the role of the government in this recruitment? Just show it.
Lords, in the recruitment rules, in the context of the recruitment rules, my lords,
In the
The-
text and context.
in the
both.
text and context, my lords, we have used the word selection authority.
So government has no role to play.
Lords,
Please answer the correct question. Whether rules assign any role to the government. Turn the pages again and again, then answer responsibly. Whether government has a role to play or government is consciously kept out of the scene itself. These rules are made under 1978 Act. Mr. Lakshminarayan?
yes, please. Civil service.
So government consciously, while promulgating the rules, kept itself out of the scene. Just see and answer the question.
Please,
No
please.
hurry.
Lords, I would say the word government is conspicuously absent. What we can say is, the word used is a selection authority. Lords, the second page, my lords, the selection authority, my lords, is,
You said that.
No, it is headed by the, we have what is called as a recruitment cell, my lords, of the ADG, headed by the ADGP. The selection, page number 2, my lords, the selection authority is a committee,
Where there is no government.
headed by, my lords, ADGP recruitment and, my lords, other members.
Members error.
Members ಅಲ್ಲಿ,
ADGP and less than that, members, they cannot be from secretary level at all.
please, my lords, it is, apart from that, we have the Commissioner of Social Welfare, apart from the police authorities, we have
all right.
Commissioner of Social Welfare,
So
Director
you,
of Backward.
now you are answering the question.
Please, my lords,
When we put questions,
please.
answer should be in such a way that it will not give rise to another question.
Please.
Otherwise, we go on, we cannot undertake cross-examination.
ಅದಕ್ಕೆ
Perhaps we would have done it better
Please.
if that were to be desirable. It's another thing.
Please.
So government has no role to play in the scheme. Texted, you used the word context. We are asking you whether in text, even in text, there is no role assigned to
Text.
the government as such.
Selection authority, appointing authority.
ಬರ್ಕೊಳ್ಳಿ. ಅಲ್ಲಿ ನೋಟ್ಸ್ ಮಾಡ್ಕೊಳ್ಳೋಣ. ಎಲ್ಲ ರೆಕಾರ್ಡ್ ಆಗ್ತಾ ಇದೆಯಾ ಕೋರ್ಟ್ ಆಫೀಸರ್? ಓಕೆ. Learned AAG, Mr. Ruben Jacob, representing the government and its officials, having turned the pages of rule book, submits and repeats that the selection authority is designated and that government has no role to play in the text and context of N rules.
Lords, this is the
Karnataka, in Karnataka, the Karnataka State Police, including ministerial services, recruitment, amendment rules 2009. Original rule ಯಾವುದು?
2004. ಅಲ್ಲ, ಕೆಳಗೆ.
Amendment bit recruitment rules 2004 as amended from time to time. Now we are asking you,
Please.
did the government play any role in this?
Lords, the selection authority wrote to the government for permission, my lords, to issue appointment orders in the without issuance of a final select list, in the context of the fact that the procedures prior to the provisional select list and the final select list were completed in respect of in respect of most of the candidates, in view of the vacancies that were available, and we cannot fill these vacancies because it's a police inspector vacancies through contract or outsourcing. And in view of the extent vacancy position, my lords, permission was sought from the government.
How long vacancy position was continuing?
Please, my lords, we have stated that also.
Yes, just give from which date to which date, what was the vacancy position? Where was the urgency? Wherever so many vacancies do occur or exist, have you taken up the same consistent stand in rest of the departments? All those things you have to answer.
My lords, it's a police department.
That's why. In the comparable, this, okay.
Essential.
How many vacancies when they accrued?
Please, lords, statement also ಕೊಟ್ಟಿದ್ದೀವಿ, sir. There is a statement.
You have stated that.
I have stated.
Just read it so that people will be
Please.
interested to know the proceedings of the court nowadays
Please,
because of so many things that are happening.
please.
Yes.
Lords, Annexure R1 is a statement. I'll read the corresponding pleadings. Para 17 minutes. Page 6.
Kindly answer our question.
Please, my lords.
What was the vacancy position? And how long it was lasting?
Please. Lords, can I read the paragraph?
ಯಾವ್ದು paragraph ಎಲ್ಲಿದೆ?
Para 17 minutes.
17 ಆ?
ಹೌದು. Page 6, my lords.
3,835 the cadre strength,
Please, my lords.
correct?
Please.
1,835. Who fixes the cadre strength? Government.
Government.
Which section, which rule?
My lords, it is the C&R, cadre and recruitment rules, my lords.
Which provision?
Vacancy position.
And ಮಗ್ಲಲ್ಲಿ ಕೂರ್ಸ್ಕೊಂಬಿಡಿ ಅವ್ರನ್ನ. You take his assistance.
Lords, we have the rules, my lords, I'll just place.
ಅವ್ರನ್ನ ಮಗ್ಲಲ್ಲಿ ಕೂರ್ಸ್ಕೊಳ್ಳಿ, so that you can take.
Please, please.
ಎಲ್ಲ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಸಂಬಂಧ ಪಡೋದು, they cannot be on your fingertips. You can take his assistance.
Please,
You can let him give his name and designation.
please, I will have it. It's going to
And
get.
tell him, if he lies to the court, something will happen to him.
Please,
Yes.
please. As
So
per
cadre strength is 3855.
3835,
Vacancy position.
my lords, vacancy position, as on 1/1/25,
No. When did you issue the appointment orders? On that date, what was the vacancy position? That is relevant factor.
please, my lords, in 25, my lords, we issued,
The sheet 20.
we issued in the month of
Vacancy position is
vacancy position as on 1/1/25, I have given because the appointment orders were issued thereafter.
1/1/2025.
Please, my lords.
What was the vacancy position?
My lords,
3047.
3047 were in working, 788 was a vacant position,
788. 700.
88.
How long this vacancy was lasting?
My lords, the last recruitment was in 2019-20, where 500 PSIs.
You just warn him, warn your fellow, what I have said. Ask him to sit here. If he makes one false statement, he will not go home.
I have informed.
Yes.
My lords,
ಅವ್ರದ್ದು
ಇದು-
ನೇಮ್ ಅಂಡ್ ಡೆಸಿಗ್ನೇಷನ್ ಕೊಡಿ.
please.
ಅಷ್ಟು ಇಸ್ಕೊಂಬಿಟ್ರೆ ಸರಿ ಆಗ್ಬಿಡುತ್ತೆ. ಇಸ್ಕೊಳ್ಳಿ.
Yes, para 18 ಅಲ್ಲಿ ಹೇಳಿದ್ವಿ, last major recruitment was in
No,
2019-20.
we don't know all that.
Please, my lords.
788 vacancies. ಎಷ್ಟು ದಿವಸದಿಂದ ವೇಕೆನ್ಸಿ ಹೀಗೆ ಇತ್ತು? ಮೇ ಬಿ ಲಿಟಲ್ ವೇರಿಯೇಷನ್ ಆಗ್ತಿರ್ತದೆ.
Please, my lords.
ಡೆತ್ಸ್, ರಿಟೈರ್ಮೆಂಟ್, ಟರ್ಮಿನೇಷನ್,
Please.
ರಿಸಿಗ್ನೇಷನ್ ಇದೆಲ್ಲ ಆಗ್ತಿರ್ತದೆ.
Please.
ಹಂಗಾಗಿ ಈ 788 ಎಷ್ಟು ದಿವಸದಿಂದ ಇತ್ತು?
Lords, it would have accrued from 2019-20 was the last appointments that were made. So from
ಅವಾಗ ಎಷ್ಟು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗಿತ್ತು?
500.
ಎಲ್ಲರೂ ಕಂಪ್ಲೀಟ್ ಆಗಿತ್ತ? ವೇಕೆನ್ಸಿ ಇರ್ಲಿಲ್ವಾ? ಉಳ್ದಿತ್ತ?
ಇಲ್ಲ ಉಳಿದಿತ್ತು.
ಎಷ್ಟು ಉಳ್ದಿತ್ತು?
I'll get it. My lords, 500 PSIs were appointed, my lords, in 1920.
2020.
ಹೌದು.
2020.
My lords may take it as 2020.
500 PSIs.
PSIs.
Net 500.
ಹೌದು. And this notification
ಅವಾಗ 500 ಅಪಾಯಿಂಟ್ ಮಾಡಿದಾಗ ಅವಾಗ ವೇಕೆನ್ಸಿ ಏನಿತ್ತು?
ಅವಾಗ 540, my lords, on 21/1/21, I have advertised 545 vacancies.
21 ದಲ್ಲಿ.
21 ದಲ್ಲಿ. So that is the same recruitment, my lords, that is going on till now.
ಇದು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಯಾವ ನೋಟಿಫಿಕೇಶನ್ ಇಂದ ಆಗಿದೆ ತಾನೆ?
ಇದೇ notification.
2020.
21.
21. Date of notification?
21/1/2021. 21/1/2021.
21.
Please, my lords.
Why they asked permission of the government? Which
Lords.
law provides for that?
Lords, under the transaction of business rules, my lords, these departments, my lords, function under the home department. Any decision, my lords, of the department, my lords, has to be by the concerned secretary.
Where is that? Then it amounts to assigning role to the government.
My lords,
If
here,
if there is conflict between transaction of business rules
please, my lords,
and these statutory rules, which will prevail?
my lords, there is the permission that is sought.
Where is the provision that while making appointment, permission of the government has to be secured?
If you're doing it as per the rules, you don't need a permission.
That's what we are asking you.
Please, my lords,
No, we want to know
please, my lords.
whether others were also involved in this or only this is done. Apparently, it appears to be contrary to law.
Apparently.
Apparently, it appears that way. Do you want to take corrective steps or you want us to do that? Compel you to do that? Now we have seen the selection list is the heartbeat of recruitment process.
Please.
Without that, I don't think that any rule with my limited exposure, I also do not know. Perhaps you have to enlighten us. Can there be appointment sans final selection list is the question.
Please, let's, in the rule provides a particular procedure, my lords, in which has to be followed prior to issuance of the appointment order. Now, the rule also provides for the role of the selection committee, the role of the appointing authority in the rule itself.
Correct.
Now, if in terms of the rule being operated as it is, now, my lords, there is no question of the government interfering if the rule is being operated as it is. But, my lords, here was a situation, an exceptional situation, my lords, where the appointing authority, my lords, and the selection authority felt some appointments have to be made. So they sought for the permission of the state government as to what to do.
Letter, where is that letter?
Really this.
R2.
Allow R2 minutes.
How Director General and Inspector General is concerned with these rules? How DGP is concerned with these rules? What is the role assigned to him?
It's not in the context of the rules, my lords, but in the context of the hierarchy, my lords, of the functioning of the department.
Where is the hierarchy? Now they are a persona designator.
Please, my lords.
The selection committee is a persona designator.
Please.
Can it take things from outside? Not permissible. Otherwise, why we need the rules at all?
My lords,
The
The-
promulgating rules is
please.
to put the things in order in such a way
Yes.
that it will give least discretion to the operation agencies. And it does not permit extra departmental agencies.
Please.
That is the object of rules. This is what at least
The selection committee is.
C.K. Allen writes in his Law in the Making.
Please.
The purpose of law is that only, to curtail the powers of whoever, public power. They said selection committee would comprise of officials below DGP, IGP, correct?
Please, my lords.
DG, IGP. Where is the role assigned to this Director General and Inspector General of Police in the rules?
Lords,
Where is the role assigned to the government? Not only it does not stop there, it goes beyond that.
lords, in the departmental hierarchy, if something has to be written to the government,
We
ಅಲ್ಲ ADGP letter ಇದೆ, reference number 2 ಅಲ್ಲಿ.
are asking him now.
Please.
Why ADGP involved the DGP? Where is the role? Why and in turn DGP involves the state government? State government in terms rights to central government. Central government in terms rights to ICJ, UNO, Security Council. Can we go that way? Rules operate in a particular sphere. Merely because hierarchy, then where is the meaning of having a persona designator?
Lords, the history of this case is this: when earlier we had held a recruitment, examination was held, my lords. Provisional select list, my lords, was announced. Then thereafter, my lords, the government got information with regard to certain malpractices, my lords, in the recruitment cell. Then, my lords, a CID inquiry was constituted. Based on the interim report, my lords, government intervened and passed the government order, my lords, cancelling the recruitment, ordering for a re-examination.
Where is power to the government to cancel?
Lords, that was, my lords, that was also part of canvas in the earlier round of litigation, where the persons in the provisional select list challenged that government order, ordering for a re-examination. Then, my lords, KIT, my lords, upheld those government orders, and thereafter, my lords, this honorable court, my lords, in a coordinate bench has also upheld that order, and Supreme Court has dismissed the SLPs.
Whether the government's role is discussed in those judgments?
My lords, and not only that, this honorable court went ahead and said the government has to assign this exam to another agency in the particular facts and circumstances of this case. So this honorable court, in fact, directed the government to ensure that the examination is conducted through another agency. So therefore, the government, my lords, was monitoring this. Thereafter, though in the rule context, KEA is not at all involved, government passed one more order, my lords, in terms of the order passed by this honorable court, assigning the exam function to the KEA. KEA then did its examination. So therefore, my lords, in the context, my lords, of the history of the present case, my lords, they would have written to the.
Where is that judgment?
Lords, it is part of paper. 6534.
91, page 91, volume 1.
Yes.
Yeah.
It's in one of the paper books. I'll just point out.
ಕಾಪಿ ಇದೇನೋ ರವಿ? Whether government's authority to do. Have you read that judgment?
In fact, I think he had also appeared.
He appeared in that.
Appeared.
Government's role ಬಗ್ಗೆ ಏನಂತ ಹೇಳಿದ್ದಾರೆ? Which paragraph deals with power of the government to intervene in this? It was not raised at all.
No, it was not raised in the context, my lords, of the abdication of powers, or rather in the context, my lords, of it not being provided in the statutory scheme. But the decision of the government to hold a re-examination was under challenge.
That
It
is
was,
upheld.
it was justified and upheld.
Courts, writ courts uphold things for many reasons.
Please,
Which you have seen.
please.
Lord Radcliffe's judgment, which is referred in AR 1992, Supreme Court page 111, where they have referred to, Apex Court has referred to Lord Radcliffe's judgment as referred by Wade and Forsyth, and said the courts grant relief, deny relief or grant relief for so many reasons. Unless law is declared.
I cannot use it as a precedent, my lords, for that point. I
Just
cannot
as
use
an event you will.
event. It is in the context, my lords.
You are
In
right.
fact, the final direction I'll read, to ensure fair re-examination, the state government shall entrust the process of re-examination to an independent agency without charging any fresh fee to the.
So
candidates.
everybody proceeded on the assumption government has a role. And nobody brought to the notice of the court that this is the rule position. Rules are as clear as Gangetic waters. Nobody argued that. I assume we have
Illa,
not read that judgment.
That was in the. That was in the
was not
context,
the-
my lords, but that was in the context where the head of recruitment cell, that is the ADGP was the main accused in that.
He himself was the.
Because OMR tampering took place, my lords, in the recruitment cell.
Law ನಾವು ಅನ್ಕೊಂಡ್ಕಿಂತನೂ ಹೊಲ್ಸಿದೆ ಅಂತ ಆಯ್ತು. ಇದ್ರಲ್ಲಿ ಅಂತದೇನಿಲ್ವಾ?
ಇದ್ರಲ್ಲಿ ಇಲ್ಲ ಸೊ ಇದ್ರಲ್ಲಿ ಇದು ಎಕ್ಸಾಮಿನೇಷನ್ KA ಕಂಡಕ್ಟ್ ಮಾಡ್ತಾರೆ. Marks have been forwarded. Then, my lords, we are now, my lords, actually their main contention, my lords, may I just point it out? This was a subsequent event which has been raised by.
ಏನಾಯ್ತಾ ADGP ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಏನಾಯ್ತು? ಹಾಗೆ ಮುಗಿದಿರ್ತದೆ, ಅಕ್ವಿಟಲ್ ಪಕ್ವಿಟಲ್ ಹೋಗಿರತ್ತದು. ಅವರೇ ಅಕ್ಯೂಸ್ಡ್, ಅವರೇ ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಏಜೆನ್ಸೀಸ್, ಅವರೇ ಪ್ರಾಸಿಕ್ಯೂಟರ್ಸ್, ಅವರೇ ಜಡ್ಜ್ ಬಿಡ್ತಾರೆ.
Charge sheet has been filed. He was in custody, my lords, for long. My lords, there are two aspects of the fraud.
ಎಷ್ಟು ವರ್ಷದಿಂದ ಪೆಂಡಿಂಗ್ ಇದೆ? We want to know. Let people know
Please.
how long the case is going on. ನಾವು ಏನಿಲ್ಲ, ಈಗ ಜನರಿಗೆ ಹೇಳ್ತೇವೆ ನಾವು ಅಷ್ಟೇ. ನಮ್ಮ ಆರ್ಡರ್ಸ್ ನಾವು ಏನ್ ಮಾಡ್ತೇವೆ, ಉಳಿದಿದ್ದನ್ನ ಜನರಿಗೆ ತೋರಿಸ್ಬಿಡ್ತೇವೆ ನಾವು ಏನೇನ್ ಮಾಡ್ತಾ ಇದೀರಿ. ಇಡೀ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆದ್ಮೇಲೆ ಮುಂದೇನಾಯ್ತು?
I'll get the.
People should know.
Please.
People should know. ಯಾಕೆ ನಾವು ಆನ್ಲೈನ್ ಇಟ್ಟೇವಿ ಅಂದ್ರೆ ನಮ್ನೂ ನೋಡ್ಬೇಕು, ನಿಮ್ನೂ ನೋಡ್ಬೇಕು, ಏನೇನಾಗ್ತದೆ ಎಲ್ಲಾದ್ರೂ ಟಿವಿಯಲ್ಲಿ ತೋರಿಸ್ಬಿಡೋಣ ಎಲ್ಲಾ ಜನರಿಗೆ. ADGP is an accused. ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಪ್ರೋಸೆಸ್ ನಲ್ಲಿ ಕಾನ್ಫಿಡೆನ್ಸ್ ಬರೋದು ಹೆಂಗ್ ಜನರಿಗೆ? ಅಂಡ್ he was in the custody for long ಅನ್ನೋದು ನೋ ಸೋಲೇಸ್.
No, thereafter.
No solace.
Please, my lords, status with regard to the charge sheet and what is the status of the trial, I'll just find out.
ಈಗಲೇ ತರಿಸಿ ಇಮಿಡಿಯೇಟ್ಲಿ. ಅದೊಂದು ತೋರಿಸಿಲಿ, ಪೇಸ್ಟ್ ಮಾಡಕ್ ಬರುತ್ತಾನ ನಮ್ ಜನರಿಗೆ.
Lords, there was a
ಎಲ್ಲರಿಗೂ ನೋಡುವಂಗೆ. ಹೌದು,
there was a provision where, my lords, you could one scanner was there where you could keep the paper and it would come up in the screen.
ಎಲ್ಲರೂ ಓದ್ಬೇಕು. ಅದು ಒಂದೇ ದಾರಿ ನಮಗೀಗ. ಜನರು ಪೀಪಲ್ ಶುಡ್ ನೋ.
Please.
ಎಲ್ಲ ಜನರು ಮೆಜೆಸ್ಟಿಕ್ ನಲ್ಲಿ KR ಮಾರ್ಕೆಟ್ ನಲ್ಲಿ ಇರೋರು, ವೆಜಿಟೇಬಲ್ ವೆಂಡರ್ಸ್, ಅವ್ರಿಗೆ ಗೊತ್ತಾಗ್ಲಿ ಏನ್ ನಡೆದಿದೆ, ಅವ್ರು ಯಾಕೆ ಒದ್ದಾಡ್ತಾ ಇದಾರೆ, ಇವ್ರು ಯಾಕೆ ಮೆರೀತಾ ಇದಾರೆ ಅಂತ ಜನರಿಗೆ ಗೊತ್ತಾಕೋತ್ ಹೋಗಿ, ಅಷ್ಟೇ ನಮ್ಮ ಉದ್ದೇಶ.
Lords, it
ಬೇರೆ
was,
ದಾರಿ ಇಲ್ಲ ನಮ್ಗೀಗ. ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ, ಕಂಪ್ಲೈ ಮಾಡಿದ್ರಿ, ಅಷ್ಟರಿಂದ ನಡೆಯಲ್ಲ. ಜುಡಿಷಿಯಲ್ ಪ್ರೊಸೆಸ್ ನಿಂದ ಆ ರೀತಿ ಪ್ಯೂರಿಟಿಯನ್ ಜುಡಿಷಿಯಲ್ ಪ್ರೊಸೆಸ್ ನಿಂದ ನಮ್ಗೆ ಏನೂ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ನಾವು ಜನರಿಗೆ ಹೇಳ್ಬೇಕು, ನೋಡಿ ಹಿಂಗಾಗ್ತಾ ಇದೆ ನೀವು ಮಾಡಿದಂಥದ್ರಲ್ಲಿ, ನಿಮ್ಮ ಅಧಿಕಾರಿಗಳು, ನಿಮ್ಮ ಸರ್ಕಾರಿ ಅಧಿಕಾರಿಗಳು ಹಿಂಗ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ನೋಡ್ಕೊಳ್ಳಿ ಅಂತ ನಾವು ಹೇಳ್ಬೇಕಾಗ್ತದೆ ಜನರಿಗೆ. ಯಾಕಂದ್ರೆ ನಾವು ಬರೀ ಇದೊಂದು 2 ಕೇಸ್ ಮಾಡ್ಕೊತ ಕೂತ್ಕೊಂಡ್ರೆ ಉಳಿದೋರ್ ಗತಿ ಏನು? ಇದು ಒಂದ್ ರೀತಿ ಅಜಿಟೇಷನ್ ಟೈಪ್ ನಡೀತದೆ. ಫಾರ್ ಎವ್ರಿ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಒಂದು ಡೆಡಿಕೇಟೆಡ್ ಬೆಂಚೇ ಬೇಕು. ಹೌದು, ಹೆಂಗ್ ಮಾಡೋರು ಕೆಲಸ, ಹೆಂಗ್ ಮಾಡ್ಬೇಕು? ಉಳ್ದೋರ್ ಏನ್ ಮಾಡ್ಬೇಕು? ಕಾಯ್ಕೋತ್ ಕೂತ್ಕೊಂಡವ್ರು. ಅವರಿಗೂ ಅಷ್ಟೇ ಸಮಸ್ಯೆ ಇರ್ತದೆ. ಯಾರ್ದೋ ಮನೆ ಹರಾಜ್ ಆಗ್ತಿರ್ತದೆ, ಟ್ಯಾಕ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಇನ್ನೊಂದು ಏನೋ ಒಂದು ಮಾಡ್ತಿರ್ತಾರೆ, ಇದೆಲ್ಲ ಇರ್ತದೆ. ಹಿಂಗೆ ಹಾಕೋತ್ ಹೋದ್ರೆ ಹೆಂಗೆ ಎಲ್ಲಾದ್ರೂ ಸಮಥಿಂಗ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಡನ್ ಅಲ್ಲ. ಎಲ್ಲಿಗೆ ಒಂದ್ ಕಡೆ ವಿ ಹ್ಯಾವ್ ಟು ಡ್ರಾ ಲೈನ್ ಅಲ್ಲ. ಬಿಫೋರ್ ವಿ ಗೋ ಟು ಫ್ರೆಂಚ್ ಲೈಕ್ ರೆವಲ್ಯೂಷನ್, ಆ ರೀತಿ ರೆವಲ್ಯೂಷನ್ ಆಗ್ಬಾರ್ದು ಅಂದ್ರೆ ಏನಾದ್ರು ಒಂದು ಲೈನ್ ಡ್ರಾ ಮಾಡ್ಬೇಕಾಗ್ತದೆ ಅಲ್ವಾ? ಇವರು ಗೌರ್ಮೆಂಟಿಗೆ ಬರೋರು, ಇವ್ರು DGPಗೆ ಬರೋರು, DGP ಗೌರ್ಮೆಂಟಿಗೆ ಬರೋರು, ಆಮೇಲೆ ಗೌರ್ಮೆಂಟ್ ಇವ್ರಿಗೆ ಬರೀತು. ಬೇರೆ ಈ ಸರ್ಕ್ಯೂಟಸ್ ವೇ ಆಫ್ ಡೂಯಿಂಗ್ ಥಿಂಗ್ಸ್ ಇದೆಯಲ್ಲ, ವಿಚ್ ಡಸ್ ನಾಟ್ ಫಿಟ್ ಇನ್ ಟು ದಿಸ್ ಲೀಗಲ್ ಫ್ರೇಮ್ವರ್ಕ್. ಅದನ್ನ ಸಸ್ಟೈನ್ ಮಾಡೋದು ಹೆಂಗೆ ನಾವು? ಆಯ್ತು, ಅದಷ್ಟೆಲ್ಲ ಹಾಕೊಂಡು ಮುಂದೆ ಸೆಲೆಕ್ಷನ್ ಪ್ರೊಸೆಸ್ ಇನ್ನೊಬ್ರಿಗೆ ಕೊಟ್ರಿ ನೀವು.
Please, only to hold the examination.
ಹಾ, ಮಾಡಿದ್ರು
Please.
ಅವ್ರು ಮಾಡಿ ಆದ್ಮೇಲೆ ಸೆಲೆಕ್ಷನ್ ಲಿಸ್ಟೇ ಡ್ರಾ ಮಾಡ್ಲಿಲ್ಲ, ಫೈನಲ್ ಸೆಲೆಕ್ಷನ್ ಲಿಸ್ಟ್. ಬಹಳ ಅರ್ಜೆನ್ಸಿ ಇದೆ, ಎಲ್ಲಾ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಖಾಲಿ ಇದಾವು, ಹಂಗಾಗಿ ಜನರನ್ನು ತುಂಬಿಡೋಣ ಅನ್ಕೊಂಡು ST ಬಸ್ ನಲ್ಲಿ ಬರೀ ಎಲ್ಲರೂ ಕೂತ್ಕೊಳ್ರಿ ಅಂತ ಮಾಡ್ತಿದ್ರು, ಪ್ರೈವೇಟ್ ಬಸ್ಸಸ್ ನಲ್ಲಿ ಹಿಂದೆ ನಾವು ಚಿಕ್ಕವರಿದ್ದಾಗ. ಆ ರೀತಿ ಮಾಡ್ದಂಗ ಹಂಗ್ ಮಾಡಕ್ ನಮ್ಗಲ್ಲಿ ಸೆಲೆಕ್ಷನ್ ಡ್ಯೂ. ನಮಗೆ ರೈಟ್ ಟು ಬಿ ಗವರ್ನ್ಡ್ ಏನು? ರೈಟ್ ಟು ಬಿ ಗವರ್ನ್ಡ್, ABC ಆಫ್ ಪಾಲಿಟಿಕ್ಸ್ ಬೈ ಫೇಮಸ್ ಆಥರ್ ಯಾರು, ಹಾರಾಲ್ಡ್ ಲೆಸ್ಕಿ, ದ ಗ್ರಾಮರ್ ಆಫ್ ಪಾಲಿಟಿಕ್ಸ್. ಏನ್ ಹೇಳ್ತಾನ ನಾವು? ವಿ ಹ್ಯಾವ್ ರೈಟ್ ಟು ಬಿ ಗವರ್ನ್ಡ್ and we have right to be less governed. Means proper officers are appointed, not any substandard people without hanಗಾಗಿ ಸೆಲೆಕ್ಷನ್ ಪ್ರೊಸೆಸ್. ಯಾಕೆಂದ್ರೆ ಅವ್ರಿಗೆ ಅನೇಕ ಪವರ್, ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡೋದಿರ್ತದೆ, ಸೆಲೆಕ್ಷನ್ ಮಾಡೋದಿರ್ತದೆ, ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡೋದು, ಡಿಸ್ಮಿಸಲ್ ಮಾಡೋದಿರ್ತದೆ. ಅಲ್ಲೊಂದು ಫೇರ್ ಪ್ರೊಸೆಸ್ ಆಗ್ಬೇಕು. ಅದನ್ನ ಯಾವಾಗ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತದೆ? ರೂಲ್ಸ್ ಅನ್ನು ಫಾಲೋ ಮಾಡಿದ್ರೆ. ಇವ್ರನ್ನ ನೀವು ಅಪಾಯಿಂಟ್ ಮಾಡ್ತೀರಿ, ನಾಳೆ ಅವರೆಲ್ಲರೂ ಆಕ್ಷನ್ ತಗೋತಾರೆ, ಅದಾದ್ಮೇಲೆ ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾರೆ ಕೋರ್ಟ್ನಲ್ಲಿ. ಯುವರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಈಸ್ ಅಂಡರ್ ದ ಕ್ಲೌಡ್, ನೌ ಇಟ್ ಹ್ಯಾಸ್ ಬೀನ್ ಸೆಟ್ ಅಸೈಡ್, ದೇರ್ ಫಾರ್ ಡಾಕ್ಟ್ರಿನ್ ಆಫ್ ಡಿ ಫ್ಯಾಕ್ಟೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ವಿಲ್ ನಾಟ್ ಸೇವ್ ದೆಮ್ ಅನ್ನೋ ಕಂಟೆನ್ಷನ್ ತಗೊಂಡ್ರೆ ಮುಂದೆ ನಾವೇನ್ ಮಾಡ್ತೀವಿ? ಮತ್ತೊಂದು ಲಕ್ಷ ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಆಗುತ್ತೆ, ಮತ್ತೊಂದು ಲಕ್ಷ ಕೇಸ್ ಬರ್ತದೆ.
Please.
ಧರ್ಮಪಾಲ ವರ್ಸಸ್ ಚೀಫ್ ಜಸ್ಟಿಸ್, ನಮ್ ಕರ್ನಾಟಕದ ಇದೆ ಧರ್ಮಪಾಲ ವರ್ಸಸ್ ಚೀಫ್ ಜಸ್ಟಿಸ್. Correct.
I'll just respond to that submission. Lords, we will initially, my lords have in fact said that if the government could take any corrective action, we
ಅಲ್ಲ,
can.
ಗೌರ್ಮೆಂಟ್ ಹೆಂಗೆ ಇಷ್ಟೆಲ್ಲ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ಮೇಲೆ
Please.
ವಾಟ್ ಕರೆಕ್ಟಿವ್ ಆಕ್ಷನ್ ಗವರ್ಮೆಂಟ್ ಕ್ಯಾನ್ ಟೇಕ್?
No, in the context.
ವೆರಿ ದಿ ಪವರ್.
No, my lords, I'll just put government in the sense, my lords, including
Officers.
the officers, including the.
ಬಟ್ ಇದೆಲ್ಲ
recruitments.
ಯಾಕೆ ಆಯ್ತು? ಒಬ್ಬ ಯಾರು IGP ನ DIG ನ ಜೈಲಿಗೆ ಹೋಗಿದ್ದ ಯಾರು?
ADGP recruitment.
ADGP, Additional Director General of Police was sent to custody. We can say custody. ಅಲ್ವಾ? ಇಷ್ಟೆಲ್ಲ ಆದ್ಮೇಲೂ ಸಹಿತ
Please.
ಮುಂದೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಅನ್ನು ಇಶ್ಯೂ ಮಾಡಿದ್ರು.
No, this is.
ಇದಕ್ಕಿಂತ ಮೊದಲೇ
That was in 2002, my lords.
2002
2002 ಅಲ್ಲಿ
ಆಗಿ
then government, this honorable court upheld the decision.
interested it to the Mr. Ramesh. It was
Lords, that
interested.
examination was scrapped. An examination where the malpractice was held, there are two frauds that were discovered. A Bluetooth fraud, second thing is OMR tampering. OMR tampering, my lords, happened at the recruitment cell itself. That is where the Bluetooth fraud, there is a separate gang for that, my lords, for which again investigation has happened. CID has filed reports in respect of that.
Triple ಏನಾಗಿದೆ ಅದರಲ್ಲಿ?
I'll give you the status, my lords. There,
ಅದೆಲ್ಲ ಸ್ಟೇಟಸ್
I'll give the status. I'll give. But my lord, thereafter, government, it was decided, my lords, this honorable court also directed that the new the examination should be conducted by a separate agency this time. So, my lords, KEA, we have assigned the function, my lords, of holding the exam to the Karnataka Examination Authority.
Correct.
Karnataka Examination Authority has held the examination and, my lords, sent us the merit list. On the basis of that, my lords, further proceedings have taken place with regard to the provisional select list. After the provisional select list, before appointment orders are issued, though, my lords, there are two things that come in between: intervening factors of publication of a provisional select list and a final select list. The intervening substantial compliance with regard to medical examination, with regard to inquiry regarding suitability and Sindhutva, everything is
Everything is done except drawing the final select.
except because there, the understanding of the authorities is there could be only one final select list. In view of interim orders that are operating in other cases and in view of also interim order operating in this case, instead of doing piecemeal final select list, it will get delayed. Government imposed that condition. Now, my lords, my lords, on the last date of hearing, my lords have passed an order stating that they can continue to undergo training, but they should not be giving posting orders. That was the order, and they were,
ಟ್ರೈನಿಂಗ್ ಪೀರಿಯಡ್ ಎಷ್ಟಿತ್ತು?
my lords, 2 years.
2 years.
2 years.
ನಾವು
But
ಕೇಸ್ ನಾವು ಮಾಡೋ ಕೆಲಸ ನೋಡಿದ್ರೆ
please,
ನಮ್ ಫಾಸ್ಟಿಗೆ ಒಂದು 7 ವರ್ಷ ಬೇಕಾಗ್ತದೆ.
Yeah.
ಸೊ ಟ್ರೈನಿಂಗ್ ಶುಡ್ ಗೋ ಆನ್ ಫಾರ್ 7 years.
no, my lords, I'll put it. I'll just, I understand, my lords, where my lords are coming from. The main grievance of the original applicants or the petitioners herein is not with regard to this event. My lords. This is a subsequent event that has happened, which, my lords, in fact, they have been using, my lords, to say, to bring to the notice of the court, and certainly we are bound to answer. Their main contention is as against the KEA with regard to evaluation of 2 papers. One is with regard to key answers. Another one is with regard to, my lords, a double and triple evaluation.
Yes.
So that aspect, my lords, has to be considered. In the meantime, this development has taken place. Now, my lords, the fact that the position, what was the extant position, I have placed it before my lords. My lords had permitted us to explain the circumstances in which we have issued this appointment orders, where we have placed this statement. Now, my lords, I would just put it this way, my lords. The training, the appointment orders, my lords, were issued in the month of January. It has been, my lords, another 3 months. I personally, my lords, would feel, I'll put it to the authorities concerned, that it is not too late in the day to take some action so that the main matter could be heard, my lords, instead of this issue taking up the attention of the court. Please, my lord. If I may request, my lords, to grant me some time to come back to my lords on this aspect of the matter. Because my lords have already asked us to notify everybody who has been given an appointment order.
Yes.
We have notified everybody, all their signatures, my lords, because they were in the training centers, physically also notified, and their signatures have been taken because they have also put on notice that the matter is before this court. Lords, may I just seek a week's indulgence from my lords to come back to the court with regard to what to do instead of, my lords, agitating on the legality of otherwise of, my lords, my appointment orders. Because at the end of the day, my lords, again, it is like giving a hope that if the state is defending again, it is giving a hope that my appointment orders are valid.
Valid.
And it
Already they are halfway through in the training.
no,
They are halfway through.
ಇಲ್ಲ,
in the
ಒಂದು
training.
2-3 months ಆಗಿದೆ.
3 months.
2-3 months ಆಗಿದೆ. If anything could be done, it is better it is done right now. As an officer of the court, I'm saying that, and I will advise my client accordingly. So kindly give me a short accommodation, my lords. I'll come back to the court.
ಇವ್ರು ಕೇಳೋಣ ಏನಂತಾರೆ, ಸ್ವಲ್ಪ ಏನು ನೀವೇನಾರ ಹೇಳಿಕ್ಕಿದೆಯಾ? ಇವ್ರಂತಾರೆ ಏನ್ ಮಾಡ್ಬೋದು, ವಿಲ್ ಎಕ್ಸ್ಪ್ಲೋರ್ ಅಂಡ್ ವಿಲ್ ಕಮ್ ಬ್ಯಾಕ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಮತ್ತೆ ಈಗ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಮುಂದಿನ ದಿವಸದಲ್ಲಿ ಅದೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ನಾ ಕೇಳಲ್ಲ, ಅದ್ರ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿರ್ತೇವೆ ನಾವು ತಲೆಯಲ್ಲಿ. ಅದಕ್ಕೆ ಈಗಲೇ ಮಾಡ್ಕೊಂತೀರೋ ಅಥವಾ ಅವರು ವಾಪಸ್ ಬಂದ್ಮೇಲೆ ಮಾಡ್ಕೊಂತೀರೋ? ಇಟ್ ವಿಲ್ ಲೀವ್ ಇಟ್ ಟು ಯು. ಇಫ್ ಯು ಆರ್ಗ್ಯೂ, ವಿಲ್ ನಾಟ್ ಪರ್ಮಿಟ್ ಯು ಟು ರೀ-ಆರ್ಗ್ಯೂ ದ ಮ್ಯಾಟರ್ ದಟ್ ವೇ.
ಅವ್ರು ವಾಪಸ್ ಬಂದ್ಮೇಲೆ
ದೆನ್ ಯು ವಿಲ್ ನಾಟ್ ಆರ್ಗ್ಯೂ, ನಾಟ್ ಟೇಕ್. ಆಮೇಲೆ ಆಯ್ತು, ಹಿಂಗೆಲ್ಲ ಕಾನೂನು ವೈಲೇಟ್ ಮಾಡಿದಂತ ಪೊಲೀಸ್ ಆಫೀಸರ್ಸಿಗೆ ಹಂಗೆ ಬಿಟ್ಬಿಟ್ರೆ ಹೆಂಗೆ? ಇದು ಆಯ್ತು, ಇದನ್ನ ಸರಿ ಮಾಡ್ತೇವೆ, ಕರೆಕ್ಟ್. ಇದು ಕಳ್ಳ ತನ್ನ ಗುಡ್ಸ್ ಅನ್ನು ವಾಪಸ್ ಕೊಟ್ಟಂಗೆ. ಏನಂತ? ಆಲ್ ರೈಟ್, ಸ್ಟೋಲನ್ ಗುಡ್ಸ್ ಐ ಆಮ್ ರಿಟರ್ನಿಂಗ್, ಐ ವಿಲ್ ಗೋ ಆನರಬಲಿ. ವಿಲ್ ಯು ಲೀವ್ ಹಿಮ್ ಟು ಗೋ ಆನರಬಲಿ?
Charge sheet was filed.
ಮತ್ತೊಂದು ಅದೇನಾಯ್ತು ಅಂತ ಗೊತ್ತಾಗ್ಬೇಕು ನಮಗೆ.
That is in respect of the
ಚಾರ್ಜ್ ಶೀಟ್ ಯಾವತ್ತು ಫೈಲ್ ಆಯ್ತು?
I will
ಟ್ರಯಲ್ ಬಿಗಿನ್ ಆಯ್ತೋ ಇಲ್ಲೋ?
ಹಾ.
ಯಾಕಾಗಿಲ್ಲ?
please.
ಯಾರ್ಯಾರ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಯ್ತು ಅದ್ರ ಕಾಪಿ ಬೇಕು.
I will
Because
please.
that will cast shadow
Please.
on this matter. It's not that
I'll do
we want to monitor that, etc. But we want to, we will, at least we can tell the concerned in the judicial level itself. It is like this, whether fault lies with the prosecutors or with the trial judge, or unnecessarily adjournments are being granted or secured. These things we want to know. We have to tell the concerned here, our leader, we have to tell this is happening. Otherwise, who will inform them? Nobody will inform. Well, just ಬೇಕು ಹಂಗೆ ಪ್ರತಿ ಸಾರಿ ಎಕ್ಸಾಮ್ಷನ್ ಅಪ್ಲಿಕೇಶನ್ ಅಜರ್ನ್ಮೆಂಟ್ ಆಗ್ತಾ ಇದೆಯಾ ಅಥವಾ ಏನಾದ್ರೂ ಆಗ್ತಾ ಇದೆಯಾ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ನಲ್ಲಿ?
I'll give the status.
ಕ್ಲಿಯರ್ ಕಟ್ ಕೊಡಬೇಕು. ಎಲ್ಲರದು ಯಾರ್ಯಾರಿದ್ದಾರೆ ಇಲ್ಲಿ, ಯಾರ್ಯಾರಿದ್ದಾರೆ ಅವರು ಹಂಗೆ ಟೈಮ್ ತಗೋತ್ ಹೋಗೋದಲ್ಲ. ಎಲ್ಲರೂ ಒಂದು ಸ್ಟಾರ್ಟ್ ಆಗ್ಬೇಕಲ್ಲ, ಜನರಿಗೆ ಅನ್ಸ್ಬೇಕು ಕೋರ್ಟ್ಗಳು ಏನೋ ಮಾಡ್ತಾ ಇದಾವ ಕೆಲಸ ಅಂತ ಅನ್ಸ್ಬೇಕಲ್ಲ. ಮೊದಲೇ ಕೋರ್ಟಿಗೆ ಈಗೆಲ್ಲ ತುಂಬಾ ಗೌರವ ಕಡಿಮೆ ಆಗ್ತಾ ಇದೆ, ನಿಮ್ಗೆಲ್ಲರಿಗೂ ಗೊತ್ತಿರುವಂಗೆ. ಇಂಥ ಹೊತ್ತಿನಲ್ಲಿ ನಾವು ಕೋರ್ಟ್ದ ಗೌರವವನ್ನು ಮತ್ತೆ ರಿಸ್ಟೋರ್ ಮಾಡ್ಕೊಳ್ಳಿಕ್ ನಾವು ಪ್ರಯತ್ನ ಮಾಡ್ಲೇಬೇಕಲ್ಲ ಅಲ್ವಾ? ನಾವು ಹಂಗೆ ಸುಮ್ಮನೆ ಸ್ಪೀಚ್ ಮಾಡಿ ಹಂಗ ಹೊಂಟು ಬಿಟ್ರೆ ಜನ ವಿಡಿಯೋ ನೋಡ್ತಾರೆ, ಅದ್ರಿಂದ ಏನು ಉಪಯೋಗ ಇಲ್ಲ ಅವ್ರಿಗೆ ಪಾಪ, ಸುಮ್ಮನೆ ಜನರಿಗೆ ಡಿಸಪಾಯಿಂಟ್ಮೆಂಟ್. ಹಂಗಾಗಿ ನೀವು ಹೇಳ್ಬೇಕು ಏನೇನಾಗಿದೆ ಆ ಕೇಸ್ನಲ್ಲಿ, ಯಾರು ಎಷ್ಟು ಸಾರಿ ಅಜರ್ನ್ಮೆಂಟ್ ಕೇಳಿದ್ರು, ಎಷ್ಟು ಎಕ್ಸಾಮ್ಷನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು, ಯಾಕೆ ಇನ್ನೂ ಟ್ರಯಲ್ ಬಿಗಿನ್ ಆಗಿಲ್ಲ ಅದನ್ನೆಲ್ಲ ಕೊಡ್ಬೇಕು ನಮಗೆ.
I will give it.
ಅದಷ್ಟು ಕೊಡ್ಬೇಕು. ಲಿಸ್ಟ್ ಯಾರ್ಯಾರು ಅಕ್ಯೂಸ್ಡ್ ಇದ್ದಾರೆ ಅಷ್ಟು ಎಲ್ಲದನ್ನು ಒಂದು ಕೊಡ್ಬೇಕು. ಲರ್ನೆಡ್ AAG representing the state and its officials
Please.
has filed the statement of objections on behalf of respondent numbers 1, 3 and 4.
Manila.
First off, in his usual style of impression, argued for a long and record is available in the online hearing. First off, we had put certain questions to which, in all fairness, answered inter-alia stating that the subject rules have been framed, promulgated under the Karnataka Civil Services Act 1978, and that going by the text and context of these rules, there is no role assigned to the government or to the Director General and Inspector General of Police. First, however, he added that in the earlier round of litigation relating to earlier recruitment process,
This recruit.
this very recruitment
Recruitment
process, there was a direction by the coordinate bench to entrust the examination to the Karnataka Examination Authority,
To another separate.
to
agency.
another agency,
Yes.
and accordingly it was entrusted to Karnataka Examination Authority. Full stop. He also tells us that under the scheme of rules, the appointment, the issuance of appointment orders has to be preceded by the provisional selection list, second revised provisional selection list, and
Final.
the final selection list. However,
It is second provisional list.
second provisional list.
Second provisional list.
ಅನ್ಕೊಂಡೆ ನಾನು second provisional list ಅಂತ. Provisional list, second provisional list and final selection list,
To be published in Gazette.
which obviously have to be published in the Gazette notification. Semicolon. However, since there was a big vacancy position of 788 posts of PSI civil,
Also.
PSI, SI ಏನು
No, no, PSI within.
PSI bracket ನಲ್ಲಿ civil, the appointment orders came to be issued to how many?
That's 485.
485 candidates. And all they are undergoing training
Please. Manoj.
and all they are deputed to training.
Lots.
5 members are unwell,
Alla. Out
unwilling.
of 485, 5 members have not joined. 480 are under training.
ಅಲ್ಲೇ ಏನ್ ಬರ್ದಮ್ಮ? 480 appointment orders have been issued to 485 candidates, of whom 5 have declined,
Unwilling, please. Manoj.
and now 480 are undergoing training.
Normal.
Out of 480, 460 are undergoing training. Out of 480, 460 are undergoing training. Appointment order ಕೊಟ್ಟಿದ್ದು 485 ಗೆ.
Okay. And ಹಿಂಗ recast ಮಾಡಬೇಕು. Out of these 480, 460 are sent for training or undergoing training at Mysore and
Kalburgi.
Kalburgi. Mysore and Kalburgi. First off. He also tells us, next paragraph, learned AAG also tells us that in terms of discussion that took place on the earlier occasion of hearing of this case, order ಇದೆ no?
Please.
And the order made therein by this bench, all the trainees, all the appointed trainees have been informed. ಏನಂತ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರು?
My lords, informed, my lords, about the interim order that was passed on the last date of hearing.
About the interim order,
Pendency of the case.
Tendency of the case and
about
interim.
the pendency of
This petition.
this petition,
proceedings.
this petition. And any other applications are pending before the?
Proceedings.
Before,
Some of them are before the KT.
ಅಲ್ಲ, KT ದಲ್ಲಿ ಬೇರೆ ಇದೆ.
ಬೇರೆ.
Insofar as
All right,
valuation process, there are other applications.
all right. And acknowledgement is also secured.
And filed with
that
the statement.
A copy whereof is an annexure in the statement of objections.
Please.
Okay. Next paragraph. Learned AAG, in all fairness, submits that he would confer with his clients as to whether steps can be retraced, if at all it is possible. It is possible. And therefore, he be granted a reasonable period. First off, there is no much objection from the side of writ petitioners at this stage. We have reserved all their contentions. First off, next paragraph. One sentence add ಮಾಡಿ. We also cotton with the idea mooted by learned AAG. First off, next paragraph. In the above circumstances, call this matter for further hearing. Further hearing.
Further hearing.
It cannot
ಅದೇ further
lose our hands, yes. Further hearing on which date?
It's,
ಹೇಳಿ, ನೀವೆಲ್ಲರೂ ಕನ್ಸೆನ್ಸುವಲ್ ಒಂದು ಡೇಟ್ ಹೇಳಿ. ಸುಮ್ಮನೆ ಹಿಂಗ ಈ ರೀತಿ ತಮಾಷೆ ಮಾಡ್ಕೊತ ಹೋಗೋದ್ ಬೇಡ.
16.
ಹಿಂಗ ಹಂಗ ಒಂದ್ ಮಾಡಿಬಿಟ್ರೆ
16 ಮುಗಿಸ್. 16. Next-
ನೋಡ್ರಿ,
Next Monday is a holiday.
Ah.
Tuesday ಬದಲು Wednesday.
17. Next day. 17.
17.
17, 2:30 ಹಾಕೋಣ. ಅವತ್ತು ನೋಡಿ ಜಾಸ್ತಿ ಹಾಕ್ಬಾರ್ದು ಮ್ಯಾಟರ್ಸ್. ಅವತ್ತು ನೀವೇನ್ ಮಾಡ್ತೀರಿ ಅಂತ ಹೇಳಿದ್ರು, ಆಲ್ಟರ್ನೇಟಿವ್ಲಿ ಯು ಶುಡ್ ಬಿ ರೆಡಿ ಫಾರ್ ಆರ್ಗ್ಯುಮೆಂಟ್.
Please.
ಸಪೋಸ್ ನಿಮ್ ಪ್ರಪೋಸಲ್ ನಾವು ವಿ ಆರ್ ನಾಟ್ ಅಗ್ರಿಯಬಲ್ ಅಪ್ಪ,
Please.
ಅವಾಗ ಆರ್ಗ್ಯುಮೆಂಟೇ. ಆರ್ಗ್ಯುಮೆಂಟ್
Let's, two things, my lords. Argument on this aspect is one thing.
Ah.
Argument on the main,
ಅದು ಮಾಡ್ಕೊಳ್ಳಿ.
please,
ಬಟ್ ಮ್ಯಾಟರ್ಸ್ ಹಿಯರ್ ಮಾಡಿ
please.
ಮಾಡ್ಬೇಕು. ಅಲ್ಲಿ ಇನ್ನೊಂದಿದೆ. ಲರ್ನೆಡ್ DAG on our suggestion has agreed to furnish the
Criminal investigation.
the status of criminal case in crime number ಏನೇನದು
Let's,
case
I'll furnish it, my lords.
case now pending on the file of
Yeah, ಅದು I'll furnish.
ಅದು ಕೊಡ್ಬೇಕು. ಯಾವ ಜಡ್ಜ್ ಅಂತ ನಮ್ಗೆ ಹೇಳ್ಬೇಕು.
In CC now.
So
Please.
that we can request him ಬೇಗ ಮುಗಿಸಿರಿ, ನೋಡ್ರಿ ಹಿಂಗೆಲ್ಲ ಇಟ್ಕೊಂಡ್ ಕೊಡ್ಬೇಡಿ ಅಂತ ಹೇಳ್ಬೋದಲ್ಲ.
Crime number and CC number along with the case I will furnish.
So and so
It can be added to the list.
so and so. ಅಲ್ಲಿ ನೋಡಿ ಅಲ್ಲಿ AG ಆನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಅಂತ ಮೇಲ್ಗಡೆ ಒಂದ್ ಕಡೆ ಬರ್ಬೇಕಲ್ಲ, ಅಬ್ದುಲ್ಲಾ ಜಿ ಸೌದಾಗರ್. ಹಾ, असादुल्ला जी सौदागर, आप सौगंध खाकर कहे उसको AAG को. ओके, ಹಿಂದಿಯಲ್ಲಿ ಬಹಳ ಮಜಾ ಶಬ್ದ ಇದೆ, ಸೌಗಂಧ ಖಾಕರ್ ಅಂತ. ಅಂದ್ರೆ ನಿಜ ಹೇಳೋದಕ್ಕೆ ಸೌಗಂಧ ಖಾಕರ್ ಅಂತ.
Yes, grateful.
ಅವತ್ತಿನ ದಿವಸ ರೆಡಿ ಇರ್ಬೇಕು.
Please.
Statement of objections was.
Objections. Yes.
There's a delay of 69 days, my lords, in filing of the appeal. Issue of transfer pricing, my lords, may I request to be condoned.
Serial number 11. Control.
We'll leave it to your lordship.
ಅಲ್ಲಿ ನೋಡಿ ನೋಡಮ್ಮ ಡಿಲೇ ಕಂಟ್ರೋಲ್ ಮಾಡ್ಕೋಬೇಕು ಆರ್ಡರ್ ಮಾಡ್ಕೋ. Appeal is admitted on the following substantial questions of law. ಯಾವ page?
Page my lords, 9 my lords.
ನೋಡಮ್ಮ
5 questions.
ಫುಲ್ 5 questions ಇದಾವ. ಮಾಡು. ಅದ್ ಕೆಳಗಡೆ ನೋಟ್ ಹಾಕ್ಬೇಕು. Note ಇದೆ ರೆಗ್ಯುಲರ್ ನೋಟ್. Which Chaitanya is arguing na some of the questions that. Yes. Yes. Notice Sotira?
We undertake to file vacant.
Tata Krishna. Tata Krishna volunteers to accept notice for respondent SSC. Delay control ಮಾಡ್ಬೋದಾ?
I'll leave it to your lordship. There's one submission I'd like. Sir, your lordship, this is a duplicate appeal and.
ಇನ್ನೊಂದು appeal ಇದೆಯಾ?
Yes, your lord. The main appeal is in ITA number 147 of 2024.
ITA with a cross objection, my lord, before the ITA. So both are.
This
May
is
be called
arising-
along with that matter.
It may be tagged
Call
along
this matter.
and called for admission.
ಅಲ್ಲೇ ಡಿಲೇ ಕಂಡೋರ್ನ 168 days. ಅವ್ರಿಗೊಂದು ಒಳ್ಳೆ ಪುಸ್ತಕ ಕೊಟ್ಬಿಡಿ. Give one good book to your young friend. Which book you will give?
Ajaya.
ಅಜೇಯ, ಬಾಬು ಕೃಷ್ಣಮೂರ್ತಿ. ಅಜೇಯ, ಅದಮ್ಯ ಎರಡನ್ನೂ ಕೊಡಬೇಕು. By same author. Okay? Adamya is a book relating to, it's a biography of Vasudev Balwant Fadke. Ajay and Adamya by Babu Krishnamurthy, Dr. Babu Krishnamurthy. ಚೆನ್ನಾಗಿದೆ, ಎರಡು ಓದ್ಬೇಕು.
Publish.
Next. Call along with number ಕೊಡಿ. Okay. ಅಪ್ರಮೇಯ.
Your lordship, I have
ಪ್ರಮೇಯ ಯೋಗೀಶ. Yes.
This appeal is preferred against the order of the additional commissioner. The order of the additional commissioner is time barred under 64 of the KBAT Act. There's a short delay of about 221 days.
ಅದು ಅವ್ರದ್ದು ಟೈಮ್ ಬಾರ್ಡ್ ಇತ್ತ ನಿಮ್ಮ ಅಪೀಲ್?
ಅಲ್ಲ, ಅವ್ರ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡೋದು ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಟೈಮ್ ಬಾರ್ ಆಗಿದೆ. It has to be revised within 4 years. So
read that section, let us see. Is it true?
yes, sir.
I've not seen the papers.
Learned issue notice, learned AGA is requested to accept notice for respondent. Interim order ಕೇಳಿರಾ?
ಹೌದು ಸ್ವಾಮಿ. I've sought a stay.
ಎಷ್ಟು ದಿವಸ ಇದೆ ಡಿಲೇ? 264 days ಇದೆ.
Vehemently opposed.
Yes, 264 days. ಡಿಲೇ ಏನೋ ಒಂದೆರಡು ಒಳ್ಳೆ ಪುಸ್ತಕ ಕೊಟ್ಬಿಡಿ. ಆದಿತ್ಯ, ಸಜೆಸ್ಟ್ ಗುಡ್ ಬುಕ್. I will suggest one book. The Causation in the Law, one of the finest books. Program, one of the best books, very rarely prescribed as a book in the law university, law colleges. Causation in the Law is written by H.L.A. Hart. Have you heard of Hart's concept of law? Yeah, H.L.A. Hart and Tony Honor, they have written that book. It is amazing book. Cause condition difference in various jurisdictions, including African jurisdiction. Great work. Hart himself is a great professor. H.L.A. Hart. Concept of. That's what. So you give 2 books, 3 books, one to Aditya and one to High Court Library, another to Lower Court Library. One person may read it. We don't know. This appeal is filed after booking a delay of 268 days. Full stop. An application supported by an affidavit accompanies the appeal seeking its condonation. Full stop. Learned DGA appearing for the respondent, sole respondent, vehemently opposes the application, saying that delay is too long to be condoned and that there is no plausible explanation for its condonation. First, next part, having heard the learned counsel for the parties and having perused the appeal papers, we are inclined to condone delay because even older matters than this are still stacked in the court cupboards, and some plausible explanation is offered for broking delay. First, of course, this inclination is subject to the condition of the assessee presenting three books, namely the causation in the law by Professor H.L.A. Hart and Tony Honor as under. One copy to learned AGA Mr. Aditya Vikram Bhatt. Two, one copy to High Court AAB Library, and one more copy, other copy to Advocates Association Library, City Civil Court. Within 2 weeks. 2 weeks. Okay. And in view of the above, application is allowed, delay is condoned.
I've sought a stay also, Your Lordship.
ಏನಾದ್ರು precipitate ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Only
Matter
question-
not to be precipitated in terms of impugned order till next date of hearing.
only,
Lordship,
if my learned friend can assist me,
Ah.
if there are some appeals that are coming up on whether the final order in suo motu revision can be passed beyond period of
After,
4 years. The other relates to whether initiation of suo motu.
Right.
If he is on the point of,
Initiation we have decided.
if he is in the point of initiation, there can be a stay.
Your Lordship, here.
Point of initiation or point of accomplishment?
The initiation was time barred, not the accomplishment.
Then it's covered by judgment ಆಗ್ತದೆ.
If initiation is,
Time
because
bar.
that there are judgments of coordinate benches, my lord, which say that expression, any power exercised is initiation. So therefore, if initiation is time barred, let there be a stay.
Annexure N, page 110. It's time.
I think 28.
We have written one judgment on that. Initiation. That was under the Income Tax Act. Perhaps you argued that matter.
And one small submission, Your Lordship, here, again, after revision was done, the matter was remanded to the Joint Commissioner to pass.
That is the penalty proceedings ಮಾಡುವಾಗ Mr. Tiwari argued that matter. Correct. Okay, do you have a copy of that?
Lord, that was a case, I think, of subject to what the union says, of referral by assessing
Correct.
officer.
The
Here-
other officer referred it to the competent authority.
Yes.
Whether at that point the reckoning happens, or
Yes.
when the authority starts proceedings, at that point it happens for the subject
Yes,
matter, but
yes.
likely that's one.
Yes, yes.
Just collect that and you may get some points from that judgment.
Yes.
also.
So here from the list of dates, it appears that my initiation is time barred.
Yes, sir.
Initiation is time but ಇದ್ರೆ ಸುಜಾತ ಮೇಡಮ್ ಅವ್ರದ್ದು judgment ಇದೆ.
Yes. Annexure N, Your Lordship, the initiation date, 8/1/2020, it is the time barred.
Let us see. Now you have been given reprieve, na?
Yes,
Wait, let us see. Yes.
great.
Give copy to him, to your
I
friend.
have this, and
But 12 days time.
Lords, may I be permitted to take notice in this matter?
Madam appears for respondent assessee. First, and opposes application for condonation of delay. Okay. Next paragraph. The delay being very short and explanation being plausible, comma, application is allowed and delay is condoned.
My lord, the substantial
is
question of
admitted,
law,
eh?
my lord, substantial question of law has been admitted in
But we are told that in identical matter, similar substantial questions of law have been framed by this court and appeal is admitted. That is ITA number 49 of 2025. First, therefore, we duplicate that order in this case also. Call this matter, this also, first off, appeal is admitted on the following substantial questions of law. Okay? Call this matter along with ITA number signs. Next. Notice only.
It's appearing for appellant minutes. There is short delay of 83 days.
Notice only. Just let us. Just next.
Serial number 16 also.
Same, 83 days.
Yes.
All. Notice, emergent notice, lateral leave. Admission matters.
Counsel for the apparent praise for a week time.
Call after, admission matter, 23 matter.
Remand ಆಗ್ಬೇಕು ಅಂತ ಇದ್ರೆ he wants some documents to be produced.
All right. Call after occasion at the request of.
My lords, I'll withdraw this appeal, my lords, below monetary limit.
Below monetary limit, Nodama. Okay. Please follow.
Yep.
Yes. 19.
Lordship, in this case, the revenue is challenging the order passed by the tribunal. Your Lordship, the tribunal has remanded the matter, my lord. During the course of the hearing before the tribunal, the assessee filed on paper book relating with some additional documents relating to administrative services provided by the assessee. The same was not provided before the below authorities. Your Lordship, the matter was remanded, my lord, challenging that order. It may be disposed of. It is a remand order, my lord. After remand, the order has been passed and they have got the relief.
Is it true?
My lords, there are actually, my lords, two issues. This is 3, 4. My lords, if you just see the appeal memo.
Yes, sir. Now, after remand, if
On
order is passed,
Yes, my lord.
maybe in your favor.
One issue in my favor, one issue against me,
uh,
which I'm in appeal on.
Then this
can
not
go.
survive for consideration. Barkali.
Your Lordship, without saying that one, Your Lordship, my kindly said, since it's a remand order, opportunity was granted to the assessee and.
No, remand order is operated.
Yes, yes, my lord.
Already concession baralla, tax transaction strict ಏನಿದೆ ಅಂತ ಬರ್ಕೊಳ್ಳಿ. The challenge is to the order dated
Your Lordship, 29/9/22.
29/9/2022 passed by the Income Tax Appellate Tribunal, Bangalore, whereby assessee's ITA number.
That's right.
Yes, my lord.
Assessee's ITA number 2067 of 2017 relating to assessment year 2003-4 having been favored, matter was remanded for consideration afresh at the hands of
Transfer pricing officer, my lord.
transfer pricing officer. First, we are told at the bar that the said remand has already
Your
been
Lordship, the respondent has filed the paper book containing that subsequent order.
disposed of. Wide order dated
There's an order which is dated to 10th December 24.
10/12/2024, partly in favor of the assessee and partly in favor of the revenue. And that the same is put in challenge in ITA number
497 of 23.
by you,
Yes, my lord.
by the revenue in ITA number 497 of
2023.
2023.
2023.
You have not passed any,
No, my lords. This order has been challenged only by me before the
not
commissioner.
he.
Not
No,
him.
no, no.
Huh?
I have not challenged.
But assessee, by the assessee,
Yes, my lord.
not the revenue,
Not yet.
by the assessee, correct?
That appeal number will.
You don't have the appeal.
I don't have the appeal number, my lord.
Has been put in.
I challenged in appeal before this court.
No, before the
Before the
CIT
first
appeal.
appellate.
For the first, again, before the first appellate
First appellate authority.
before the first appellate authority. First, the same is pending. The same is pending consideration. First, next paragraph. In view of the appeal above, this appeal is not maintainable
Your Lordship,
and accordingly is disposed of,
Lordship,
keeping
may
open
I-
all
Your
contentions.
Lordship, may I also add that even otherwise, we don't see any error in the tribunal's order remanding the issue since additional documents were produced before the tribunal. For consideration of that, it was remanded.
Next paragraph. Even otherwise, the remand order of the tribunal is unassailable in as much as it has been framed after looking into the additional evidence produced by the assessee. Correct? Assessee, first. Ordered accordingly and appeal is disposed of.
Obliged.
Yes.
Yes, for respondent.
It's not here. ಏನಿದೆ ಮ್ಯಾಟರ್ ಬರ್ಲಿ
Lordship,
ಏನಿಲ್ಲ
ATP deduction they are seeking, my lord. They are involved in the activities of making formation of layout.
not ಅವ್ರಿದ್ರ call this matter after vacation to enable counsel for the assessee to come and argue. ಏನಿದೆ ರವಿ?
But the tribunal has followed, my lord, the judgment of this honorable court in tally solutions. Whether, my lord, TDS had to be done, because the contention of the revenue is, my lord, it amounts to royalty and TDS had to be done. Now, my lord, we are in appeal because the matter is not yet in finality, my lord, the tally solutions. Only,
It's pending before the apex court.
My lords, may I just clarify one point, my lords? My lords, the question is whether on depreciation that I have claimed, if I had not deducted tax at source, whether that depreciation can be disallowed. That was the question before the tribunal. That question, my lords, is settled by this honorable court in the case of tally. May I just pass on the judgment copies, my lords?
Covered by judgment. ಇನ್ನೊಂದು ಮಾಡಿದ್ವಿ ನಾವು ಅದರಲ್ಲಿ
this is slightly different, slightly,
ಡಿಫ್ರೆಂಟ್
slightly, but it's covered by.
covered by
Tally.
judgment. But revenue
My lord, page
Has
number 8
filed.
is the question of law.
has filed this appeal for calling in question appellate tribunal's order dated 30 May 20 for the assessment year 2011-12, whereby assessee's appeal was allowed.
SC's appeal was allowed.
Assessee's appeal in ITA number 1008 of 2019 having been favored, the following relief has been accorded. First, next paragraph. The appeal is presented to this court on the following substantial questions of law.
One question.
ಒಂದೇ
ಒಂದೇ.
following substantial question of law. ನೋಡಮ್ಮ ಪೇಜ್ 8 ಮತ್ತು 9 ದಲ್ಲಿದೆ. Roman para 6. Next para. Having heard the learned counsel for the parties and having perused the appeal papers, we are of the considered opinion that the appeal involves a question of law that has by a coordinate bench of this court. Correct?
Yes, my lords.
In Principal Commissioner of Income Tax 7 versus Tally Solutions Private Limited, 2021, 123 taxman.com, 21 Karnataka.
Which is followed by the tribunal.
Which judgment, which decision has been scrupulously followed by the tribunal? First off. Next paragraph. In view of the above, we do not find any merits in the appeal, and accordingly, the same is rejected. Courts
Lord,
having
next.
been made easy.
My lord, same issue, next matter also, 23 also.
Rama, 23 also same,
That is for the assessment year 2014-15.
14-15. ಅದ್ನ assessment order ನೋಡ್ಕೋಬೇಕು, year ನೋಡ್ಕೋಬೇಕು.
ITA number change ಆಗುತ್ತೆ.
ITA number change ಆಗ್ತದೆ. Yes. Yes, brother. Brother, after vacation, barli. Let them come after vacation. All right.
This matter requires detailed hearing, my lords. In fact, my lords, on the last occasion.
Admission ಇದೆ.
Admission, my lords. In fact, there's an interim order granted by this honorable court, my lords. However, the opposite side, in fact, asserted that the interim order is affecting them. I would like to bring a few points, my lords, because they kept insisting that there is, the judgment covers
That
everything.
all that necessary. We'll have it after vacation.
My lords, can be taken up at least with respect to interim order not to be extended, my lords. I'm
ಯಾಕೆ?
ready for arguing, my lords.
ಅಲ್ಲ ನೀವು ಅಷ್ಟು ಟೈಮ್ ಇಲ್ಲ ನಮಗೆ, ಬೇರೆ ಇಂಪಾರ್ಟೆಂಟ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ ಅದಕ್ಕೆ.
Let's ready to argue.
Immediately after vacation.
After a week or 2 weeks, my lords.
After
It's
2 weeks vacation ಬಂತು.
15th, my lords.
Court works only 14 days.
No, my lords.
ಹೌದು.
I guess.
ನೋ ಅನ್ಬೇಡಿ, ಕ್ಯಾಲೆಂಡರ್ ನೋಡ್ಕೊಂಡು ಹೇಳ್ತಿರ್ತೀವಿ.
My lords.
ಅಲ್ಲ ನೋ ಅನ್ಬೋದು ನೀವು, ಅದ್ರ ತೋರಿಸ್ಬೇಕು.
No, my lords.
Interim
Urgency,
order.
that's the reason, my
Immediately.
lords.
Call immediately after vacation. Till then, interim order to continue.
Much.
Okay.
Great from.
Yes.
This matter, we are
Could I seek a
requesting
passover,
for,
my lords?
Passover.
ಇದರಲ್ಲಿ only this, we are, the mandate of the arbitrator, which was originally as contemplated under the act is over now. We are seeking for extension.
You are seeking for extension.
Extension.
ಅದು ಈ ಕೋರ್ಟ್ ಕೊಡ್ಬೇಕಾಗ್ತದ?
No, the provision is for the court to give.
Court.
Yeah.
Which court?
Please. But this honorable court.
No, there's a lot of meaning to our question. Kindly see the section.
No, but this honorable.
Is it?
Yes, 29. The reason is this one, because this honorable court appointed that. It's an adjunct power.
So power to appoint includes power to continue.
Continue
appointment
for
also.
that purpose. But Euro 37/2022, lots 7737/2020.
ಅದು single judge ಅಲ್ವಾ?
Adu section 11, that's what I was telling you normally, but what they do is, my lord, since the arbitration writs are posted before the division, so it does not matter ultimately.
Whether that bench or this bench. How courts have viewed the question?
My lord, there is one decision of the Honorable Supreme Court
Yes.
where, my lords, in a different context, they say you have to go to the court, means court of the principal citizen. Lordship Justice Oak's judgment presided over that. But that was in a different context. But the interpretation, plain interpretation of section 29, not according to me.
Let us read.
Please.
29. But ಇದರಲ್ಲಿ ಏನು interim order ಏನು ಕೇಳಿಲ್ಲ ನೀವು?
No, no interim.
No interim order.
We are seeking only for extension.
That's what.
And my lords, if my learned friend consents for substitution of the arbitrator, at least beside.
Any other arbitrator ಬೇಕಾ?
Or let them
It
choose.
would not be fair on the arbitrator, my lord. Don't
If
understand.
you want, we are not saying that.
No, no,
It
no.
is choice of
Appointed
the
by-
party.
Yes.
In fact, ನಮ್ ಕೇಳಿದ್ರೆ ಈ ಜಡ್ಜಸ್ಸಿಗೂ ಹಂಗ ಮಾಡ್ಬಿಡಕು. ಇವೆರಡು ಸೈಡ್ ಒಪ್ಪಿದ್ ನಮಗಿಂತ ಬೆಂಚ್ ಇರ್ಲಿ ಅಂತಕೊಂಡ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ಆ ಬೆಂಚ್ ಕೊಡಂಗ್
Yeah, that's
ಮಾಡ್ತಾರೆ.
all we'll say.
ಅವಾಗ ಪ್ರಾಬ್ಲಮ್ ಇರಲ್ಲ.
Well, let him get instructions.
So that
what
was-
if he
That's
wants
what.
to.
That's what.
That was what happened earlier, my lord.
Anyway, the subject property
Appointment.
shall not be alienated. That's the order.
That
now.
is there.
That interim order will continue.
That may be, my lord, but my humble submission is that no reasons are forthcoming as to why this substitution.
No,
No, I'll explain. But basically, we are seeking extension. Insofar as substitution is concerned, having regard to his lordship, what is the former judge, learned friend says they do not want to say anything. But if my learned friend desires, so we will
if
have.
you want,
That's all.
or otherwise he does not want. He is as fair as can be.
Or amele honorable retired judge of the honorable court, we can't make allegations of saying that we don't want him or anything.
But
It would be
ಅಲ್ಲಿ-
inappropriate on our part.
ಅಲ್ಲಿ ಬಹಳ ಸೆನ್ಸಿಟಿವ್
Please,
ಇಶ್ಯೂ
please. Therefore,
ಏನಿರ್ತದೆ ಅಲ್ಲಿ ಎರಡ್ ಮೂರು ಆಸ್ಪೆಕ್ಟ್ ಕನ್ಸ್ಟ್ರೆಂಟ್ ಬಹಳ ಇದೆ.
ಹೌದು.
ಈಗ ಏನ್ ಅಲಿಗೇಷನ್ ಮಾಡಿ ಪ್ರೂವ್ ಮಾಡೋದ್ ಹೆಂಗ್?
ಬೇಡ.
ಆದ್ರೆ ಫೇತ್ ಹೋಗಿರ್ತದೆ.
They have some reason, but I don't want to say anything else.
ಫೇತ್ ಹೋಗಿರ್ತದೆ. ಫೇತ್ ಹೋಗಿದ್ಕೆ ಕಾರಣ ಡೆಮಾನ್ಸ್ಟ್ರೇಟ್ ಮಾಡ್ರಿ ಅಂದ್ರೆ ಕಂಟೆಂಪ್ಟ್ ಜೂರಿಸ್ಡಿಕ್ಷನ್ ಹೋಗೋ ಪಾಸಿಬಿಲಿಟಿ ಇರ್ತದೆ. ಆಮೇಲೆ ಬೇರೆ ಸಮಸ್ಯೆ ಆಗ್ತದೆ ಅವ್ರಿಗೆ ಲಿಟಿಗಂಟಿಗೆ. ಹಂಗಾಗಿ ಎನಿವೆ
My
Mr.
humble submission is, my lords, even when
Nawadgi is now saying
there is no,
we will give up that
allegation.
very idea
please,
itself.
please, I'm perfectly fine with that, my lords.
Extend ಮಾಡ್ಬೋದಾ?
Your lordships may also see that if it is only with regard to the extension of the mandate, there is also, I have filed another petition under section 29A5 as required under law. And that matter, my lords, is petition court, where they have appeared.
ಅದೇ
They
ಅದಕ್ಕೆ
could consent there, because what the law requires.
ಅಲ್ಲಿ ಹೋಗಿ
What the
ಅಲ್ಲಿ
law
ಅವ್ರು ಹೋಗಿ
requires-
ಹೇಳ್ಬೋದು. ಇಲ್ಲಿ
the
ಆ
law
matter
requires-
ಇದೆ ಇವ್ರು ಇಲ್ಲಿ ಕನ್ಸೆಂಟ್ ಮಾಡ್ಬಿಟ್ರೆ ಆಗತ್ತೆ ಅಂತ ಅವ್ರು ಹೋಗಿ ಅಲ್ಲಿ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು? ಇವೆಲ್ಲ ಬಿಡಿ. ನೀವು extension ಗೆ ಹೋಗ್ತೀರಾ ಅಥವಾ ಇಲ್ಲ?
Extension I have no
ಬಿಡಿ ಮತ್ತೆ ಮುಗಿದು
forms at all.
One request. My learned friend says, Mr. Chaudhary, ಸ್ವಲ್ಪ ರಿಸರ್ವೇಶನ್ ಇದೆ ಅವ್ರಿಗೆ. He now
would not
says,
be
"Mr.
fair."
Okay,
ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಲಿ ಒಂದು ದಿವಸ.
ಅದಕ್ಕೆ ಇರ್ಲಿ.
ಇನ್ನೊಂದು
Then what
ದಿವಸ
lordships may differ. It's a
ಕೊಡಿ.
very delicate what path we are walking on.
I
So you don't want to.
We
say
understand.
anything. Please.
There are many constraints. In
Yes.
fact, in one matter,
Yes.
very reluctantly we did where Chaudhary himself appeared. He was a great judge of this
Yes.
court.
Yes.
But very reluctantly we had to do because of certain
Correct.
things. Not as a, casting any aspersion. He's a very
No,
tall
not,
judge.
not even that. ಅವ್ರು
No,
ಸ್ವಲ್ಪ
ಅದ್ನೇನ್ ಮುಚ್ಚಿಡೋದು.
No.
He's a very tall
No,
judge.
no.
Who can make any allegation against him?
No question.
ಪ್ರಶ್ನೆನೇ ಇಲ್ಲ. But that does not mean that ನಾವು ಪಾರ್ಟಿ ಕೇಳ್ದಾಗಿಲ್ಲ ಅಂತ ಹೇಳಿಲ್ಲ ಅಲ್ವಾ?
Correct.
He was a great judge.
Lordship
yes.
Justice A.V. Srinivas Reddy is there in this month. Anyway, we will just have it differ.
After vacation, Karina,
That date.
call this matter immediately after vacation. First off, in the meanwhile, the interim order granted by the coordinate bench on 16/1/2025 shall continue.
Please. But the law is not that,
Understand.
it is this honorable court which has to do it, not the trial court.
My lord,
Read that section. We want.
I seek a date prior to the vacation, my lords.
Prior to vacation difficult.
ಯಾಕಂದ್ರೆ ಅದು ಬಹಳ ಡಿಲೇ ಆಗೋಗಿದೆ. There
Israel
was
now.
matters stood.
No, I'll tell you what. If now they want to possibly file an affidavit requesting for a substitution properly, but let them do it in their way, whatever they want.
ನಾವು ಇನ್ನೊಂದು ಕೇಳೋದಿತ್ತು ಪ್ರಭು, ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಟ್ರೆ
ಸಾಹೇಬ್ರಿಗೆ.
ಸರಿ ಸಜೆಸ್ಟ್ ಮಾಡಿಕೊಂಡು ನಂತರ ಬಂದ್ರೆ
Correct.
ಹಾ,
Also,
ಈ ಅನವಶ್ಯಕ ರೆಕಾರ್ಡ್ ಬಿಲ್ಡಪ್ ಮಾಡೋ ಬದ್ಲಿ ಅವ್ರಿಗೂ ಅನುಕೂಲ ಆಗಿರುತ್ತೆ.
I'll just ask him.
ಅದನ್ನ ಎಕ್ಸ್ಪ್ಲೋರ್ ಮಾಡಿ.
Yes.
If it can be, my lords, prior to.
ನಿಮ್ಗೆ ಗೊತ್ತಿದೆ ಎಷ್ಟು
Because the matter, my lords.
ಎಲ್ಲಾ ರಿಕ್ರೂಟ್ಮೆಂಟ್ಗಳು ಈ ಕೋರ್ಟ್ನ ಬಂದು ಬೀಳ್ತಾ ಇದಾವೆ. ನಮ್ಗೆ ಅಲ್ಲಿ ಆಗುವ ಸಮಸ್ಯೆ. All recruitment processes,
If we can take our.
APSC, KEA, other authorities, all they are landing. ನಮ್ದು KPSC
ಯಾಕಂದ್ರೆ-
ಕೋರ್ಟ್ ಆದಂಗೆ ಆಗಿದೆ ಒಂದ್ ರೀತಿ.
Yes.
29 29/6.
29 capital A.
29 capital A.
First scene was subsection 4.
29 4
29 capital A.
A
subsection
4.
29 capital A subsection.
Award is not made within the period.
If the
specified in
award is not made within the period, the mandate of the arbitrator shall terminate unless the court has either prior to or after the expiry of the period so specified extended the period. And subsection 6, while extending the period referred to in subsection 4, it shall be open to the court to substitute one or all of the arbitrators if one or all of the arbitrators are substituted the arbitrator. The question is not which is the court. But the court definition, you normally automatically they went to the definition of court and said court means principal original court of 2(1)(e), section
Because
2.
2(1)(e) gives that definition.
But that, my lords, therefore, my lords, this interpretation may not be entirely correct, saying that court means not court always in all the, wherever it
Of
appears.
course, that's what Crayson statute.
Yes, I have heard.
He says that way.
Yes.
Generally, dictionary clause will govern the provisions of
Yes.
all provisions of
Correct.
the act.
Yes.
But it is not the invariable rule.
That's correct.
There may be cases where court may mean something else
But
than
because
what
the
is
reason
given in the
is
dictionary.
section 11, lords, this honorable court appoints the arbitrator.
Therefore, it cannot be that.
It's an adjunct power. That's all. That is a position.
Appears to be.
Yes. But I'm told, my lords, one day lordships may have to lay down the law because I'm told in Karnataka, my lords, most of them are now following court means and they go to the trial arbitrator to the trial court, a commercial court and get the extended and
So
substituted.
this side or that
Wherein
side.
the
some
original
clause.
arbitrator is actually appointed by your lordships under exercise of section 11.
So he
That-
cannot extend
No,
that.
he can obviously can, and he cannot substitute. So that is something not in a given case, lordship.
Section 21 of General Clause Act. Odi.
Correct.
Yes, Mr. Holla.
Lords, two or three aspects that Lords would have to look at in this matter. One is, Lords, 29 Lords A3. Their conduct. Lords saw all of Lords 29A. 29A3, Lords, provides for the parties themselves to extend it, Lords, by 6 months. The original time period, Lords, that is prescribed under the Act is 1 year from completion of pleadings or framing of issues. then, my lords, there is a power given to, my lords, the parties themselves to extend it, my lords, for a further period of 6 months. At the end of that, my lords, 29A, 4 and 5, my lords, come into picture, where the court, as defined, my lords, now, as to which is that court, that may be, my lords, a separate.
Law settle ಆಗಿಲ್ಲ, no? So apex court judgment.
there.
Aditya,
No, the honorable.
what is the position in this
Appears to, some judges exercising power under section 11
same court?
appear to have held that same court.
Okay.
No, honorable Mizoram, Meghalaya court took a, Meghalaya High Court took a particular view, saying that court means the High Court. But there, the arbitrator was appointed by the consent of the parties, not under section 11. The Honorable Supreme Court, just so in one paragraph said, court means the original court. But that paragraph is now construed to say for all purposes.
Also it is.
No, but that was the case where it was not section 11 invocation. But it was the parties.
Once section 11
is
intervenes,
invoked, but it is
other provisions have to be consistently
only under
interpreted.
that. That's.
Otherwise, the court appointing the arbitrator is one, court extending the period of
Cannot be.
arbitrator is another.
Another.
That does
Therefore,
not
the word court as it appears in 29(6) must be meaningfully construed to mean the court which appointed the.
On the ground, my lords, where, as in most cases, the extension is as a matter of course, because everybody, including parties, honorable arbitrators and counsel are burdened.
ಅದು ಆಗ್ಲಿದ್ದಾಗ ಈ ಪ್ರಶ್ನೆ. Very rarely.
1 year plus 6 months is within the jurisdiction. After 1 year, 6 months, it is only the court which can accept.
But even after 1 year, 6 months, supposing a petition is filed before the Honorable High Court, question of maintainability, entertainability, etc., is not being raised at all. As a matter of course, that is happening.
Correct.
Therefore, there are two streams of orders that are coming, my lords.
Okay. Very interesting.
It may be a case for exercise of concurrent
Jurisdiction also, even otherwise. That's also another point. It can be a case of concurrent jurisdiction, even otherwise, assuming that court fits into that.
Yes.
Since section 11 intervened.
Correct.
So the 29 capital A
Correct.
has to be read along with 11 itself, not the month.
Yes, that is our submission.
Let us see. Please requires consideration. Please. After occasion, Akobada. Your colleague was insisting for earlier date. I told him we are hard pressed for time. Yeah. Call this matter after occasion.
Request, since question of law, lordship may lay down, so it can be shown as further.
All our judges are appointed under the same warrant.
It's a request, I leave it to you. I leave it.
Let it. We have not heard fully. Even to treat it part heard and
not for anything.
No,
Just
no,
it's a pleasure
no, I'll
to
tell you
assist
what-
your lordship for.
No, it's the right time. You asked us, you raised it, and we want to tell something.
Yes.
If we treat something as part heard,
Please.
it becomes matter of debate elsewhere. Number one.
Yeah.
And
No,
by
not for
our
anything.
brother Nagprasanna
Yes.
said not before me, matter went to Supreme Court.
Yeah.
Of course, Supreme Court
Yes,
imposed
sometime.
heavy cost and then dismissed it. Is another. Brother Nagprasanna said, I don't want to. He said,
Correct.
I want to recuse from this case. Recusal was challenged before the highest court of the country. These are very sensitive. nowadays. Therefore, for deciding the case, we have no problem.
Your
For-
anxiety, I'll explain, if lordship permit one sentence. But he was in fact telling me this interpretation, it would be a pleasure to get the law laid down by lordship justice, the bench of that is what, nothing else, if not, I leave it.
ಅಲ್ಲ ಅಂದ್ರೆ ಸೆನ್ಸಿಟಿವ್
Yes, yes, I understand.
ಈಗ ನಾವು ಅಂತದಕ್ಕೆ ಸ್ಕೋಪ್ ಕೊಡಬಾರ್ದು. ವೈ ವಿ ಶುಡ್ ಕೀಪ್
Yes,
ಆಲ್ ದೀಸ್ ಪಾರ್ಟ್ ಹೆಡ್ ಮ್ಯಾಟರ್ಸ್ ಎಟ್ಸೆಟ್ರಾ. ಬ್ಯಾಡ ಆದ್ರೂ ಬಹಳ ಚಲೋ ಆತ್ ಇನ್ನೊಂದು ಕೋರ್ಟಿಗೆ ಹೋಗು ಅಂತ ಕಳಿಸ್ಬಿಡು.
ಇಲ್ಲ, correct.
ಒಳ್ಳೆದು.
Sometimes academic interest is ಸಲುವಾಗಿ ಹೇಳಿದ್ದು, not on.
I understand.
Actually, it does not
We appreciate
really.
that. We
Please,
appreciate
I'm grateful.
Interim order to continue, call
Please.
immediately after vacation. Days have become sensitive.
I understand.
ಏನಾಗ್ತದೆ ಎಲ್ಲ ಆನ್ಲೈನ್ ಇರ್ತದೆ.
Correct, correct.
ಅದು ಒಂದ್ ರೀತಿ ಅನುಕೂಲ ನಮಗೆ. ಈಗ ನೀವು ಹಂಗೆ ಹೇಳಿದ್ರೆ ಹಂಗನೇ ಕ್ಲೈಂಟ್
Transparent.
ಟೀಮ್ ನೋಡ್ತಾನೆ, ಸರಿಯಾಗಿ ಆರ್ಗ್ಯೂ ಮಾಡಿರಲ್ಲ, ಸರಿಯಾಗಿ ಜಡ್ಜಸ್ ಪ್ರಶ್ನೆ ಕೇಳಿದಾರಲ್ಲ, ಅವ್ನು ತಿಳಿತದೆ, ಅವನೇನು ಅಷ್ಟು ದಡ್ಡ ಇರಲ್ಲ. ಮ್ಯಾನ್ ಆನ್ ದ ಸ್ಟ್ರೀಟ್ ಈಸ್ ಆಲ್ಸೋ.
Lord, some matters, Lord, it's always a pleasure to address it, irrespective of the way the result goes or
That's
the law is laid down.
that is the
They're all
reason. That is the
youngsters.
reason why we listen to your lecture in Manchester
No, no.
University.
No,
Prabhu went to Manchester
no, no.
to speak on our Indian Constitution. So beautifully has spoken. Some videos you will see in I think. there are many
These
speeches.
youngsters, particularly all of them, they are so keen to see that the law develops and
Correct.
correct. That is the only, nothing else.
But you spoke so well in that Manchester University.
I am nothing.
You spoke
I am
very-
nothing before law. Knowledge, no, I am totally
Yeah.
inconsequent.
Yeah.
Great.
Okay. He spoke on Indian Constitution. So beautifully he has spoken. Yes. Yes,
BDA,
Chetan?
BDA G category site, my lord.
Ah.
3 times they gave me a site which was under litigation, my lord. Then I approached this honorable court. I got the order of mandamus also, page 23, my lord. Unfortunately, because of COVID, I could not file contempt. So now again, I gave the representation on 8/8/24, my lord.
Court earlier directed them to consider.
Consider, my lord.
But you should have applied for extension of the period fixed by that court itself. No, there is one such judgment.
My lord, page 25 is the operative portion.
25. ಅವ್ರು 1, 2, 3 ಆರ್ಡರ್ಸ್ ಮಾಡಲ್ಲ ಅವರು. ಅವರಿಗೆ ಚಲೋ ಆರ್ಡರ್ ಬೇಕು ಅವಾಗೆ ಮಾಡೋದು.
The 8 weeks time was given, my lord.
ನೋಟಿಸ್ ಆಗಿಲ್ವಾ?
Agila.
ಆಗಿಲ್ಲ. ಇಶ್ಯೂ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್. ಎಷ್ಟು ಸರಿ ಬರ್ಬೇಕು ಇವ್ರು ಕೋರ್ಟಿಗೆ?
First respondent.
BDA is requested to accept notice for first respondent, learned panel counsel. ನೋಡ್ಕೊಳ್ಳಿ ಯಾರು ಶ್ರೀ so and so is requested to accept. ಅಲ್ಲಿ ಮೊದಲಿನ ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ರು?
BDA Gopal Billy, my lord.
ಗೋಪಾಲ್ ಬಿಲ್ ಇಲ್ಲ.
Now he may not be in the panel.
ಯಾವ್ದಾರ ಒಂದು ಬೇರೆ ಯಾರು ನಾಜಯ್ ಕೌನ್ಸಿಲ್ ಅವ್ರಿಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ. ನೆಕ್ಸ್ಟ್ ಅಲ್ಲಿ ಇಶ್ಯೂ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್, ಕಾಲ್ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಸಿನ್ಸ್ ಶಾರ್ಟ್ ಪಾಯಿಂಟ್ ಈಸ್ ಇನ್ವಾಲ್ವ್. ಎಸ್.
Lords, for the respondent, I'm seeking time, my lord. Senior counsel Sri A. Shankar has been engaged for this matter. Due to personal A. Shankar, my lords.
A. Shankar.
Due to personal inconvenience.
matter, no? All right. Immediately after vacation.
Grateful.
Reluctantly adjourned on request of counsel for the assessee. First stop. Call immediately after vacation.
Grateful.
Appear for the appellant in this case, my lords.
Any.
This is a matter concerning, my lords, denial of exemption on account of deemed export sales not covered by Form H. The genesis of this, my lords,
Similar matters, ಯಾವ್ದೋ ಒಂದು judgment ಯಾವ್ದೋ ಬಂದು ನೆನಪಿದೆ. Any matter was decided by any court?
there's a division bench judgment of the Honorable Andhra High Court, my lords, on the exact same point. Because what happens is for the first and third quarter sales, one format is provided by me as the assessee to claim the exemption. Now, the provision for Form C, the requirement is that for one quarter, one Form C is filed, and for each quarter, a different Form C is required. The provisions pertaining to Form C have been made mutatis mutandis applicable to Form H. A circular comes to be issued concerning Form C where they relax this rule, saying you can, for more than one quarter, one Form C may be considered. Similar exemption is not granted for Form H. And because of that, the exemption comes to be denied initially. The appellate authority, my lord, holds it in my favor and grants the benefit of the exemption on account of the Form H. In suo motu revision proceedings, it has been found to be prejudicial to the extent, erroneous and prejudicial to the interest of the revenue.
36,
62, my lords, if I'm not mistaken.
No order shall be done prejudicial to the interest of the revenue. ಬಂದಿದೆಯಲ್ಲ, section 36.
It is 64, my lords. 64. 64 of the Caveat Act.
Under the CST Act, I think 9 read with 64.
9 read with 64.
It'll be 9 or 15 or something. CST Act.
Is it state respondent state, ಅಲ್ಲ?
Respondent state. Under the CST Act,
Yes.
I am appointed as agent of the central government. to administer this tax.
You are only collector.
Please, my lord.
ಮತ್ತೆ ಅದರಲ್ಲಿ ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಸೇ ಬೇಡವಾ? ಬೇಕಾಗಿ.
The statute gives me the power to administer, assess
Everything.
everything.
The only thing is you have to remit that money to the central exchequers.
Please, my lord.
What do you say about Andhra judgment, which is now
Lords, does not consider the provision at all.
not considered?
Does not consider the provision at all.
May I first place the judgment
Whether
of
that provision is considered.
it is considered, my lord.
It proceeds.
Just show it to Aditya.
Please, my lord.
ಅವ್ರಿಗೆ ಮೊದಲೇ ಒಂದು ಕಾಪಿ ಕೊಟ್ಬಿಟ್ರೆ. He comes after it. Can you have this matter immediately after occasion?
It's a,
As a lord.
Are covered?
No, no, I am contesting.
That. Call this matter immediately after the 2017 matter anyway.
at the stage of the admission proceedings, I had handed over a copy to the other counsel, my lord. My apologies. I didn't realize it was not on the file. My apologies.
ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಟ್ರೆ ಮುಗಿಸ್ಬಿಡ್ತಾರೆ ಅವರು. He does not need more time. And he will say whatever is right, wrong ಹಿಂಗಿದೆ.
No, I ought to have served a copy on him prior. That's why I was just apologizing.
But
One page judgments we can read across the bar.
that's all.
Immediately after.
It's a fairly short judgment, my lord, just one page.
Ah.
Essentially, the language of the relevant rules will
They are
make,
parimateria, Andhra.
please, my lords, because the same provisions of the CST turnover and registration rules are what is considered.
Very same rules, sir.
Please, my lords, only thing is here there is a Karnataka rules, but my lords had in fact pointed out a particular Latin maxim. When something is deliberately omitted, it is meant to be excluded. Therefore, what
Is
exclusio unius,
exclusio ulterius,
please, my lords.
that way, something like.
Please,
that.
my lords, please, my lords. My lords, in fact, had pointed out that my only humble submission before this court is the requirement of 1 quarter, 1 Form C has not been explicitly extended to Form H. Even if I assume to the contrary, when a circular is issued to exempting this rule for Form C,
Expressio unius exclusio ulterius.
please, my lords, please, my lords. I did not have it on memory, my
But
apologies.
Broom says, in Broom's legal maxims, he says it is a very weak maxim.
Please, my lords.
Yes.
Please, my
In
lords.
one matter, Raghuraman argued,
Please, my lords.
placing reliance on apex quotation and
Please, my
English
lord.
judgment also.
Please, my
It's
lords.
a weak maxim ಅಂತ ಹೇಳ್ತಾನೆ ಅವ್ನು.
Please, my lords. Nevertheless, in the specific context of the present case, when the machinery provisions alone are in dispute, because the genuineness of my exports are not in question.
Not doubted.
They don't raise a serious dispute as regards the genuineness.
He needs
It's
to
only when the machinery provisions that a controversy has
Let us
arisen.
see what Aditya says.
He needs to comply with the law. And the Andhra Pradesh judgment does not consider proviso 3 to rule 12(1). That is my short submission. You can,
I'll submit, my lords, even.
No, 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 no. This
Please,
is
my lords.
what-
Please.
Yes. AR 1953 Supreme Court. Just look into that judgment. It considered expressio unius doctrine by maxim
Please, my lords.
and referring to a very very beautiful judgment it is.
Please, my lords.
53 SCR.
Please, my lords.
AR I don't know, equivalent I do not know.
Please, my lords.
SCR it is discussed.
Please, my lords.
Okay.
Grateful, my lords.
Sir, Afi?
Lordship, I have received the written submissions today, my lord. I will file one reply to this one, my lord.
Jay. All right.
Please,
After immediately after vacation?
please, my lord.
All right. Immediately after vacation. Next one.
After vacation.
I'm requesting for an adjournment to this matter. I'm requesting for a short accommodation. in this matter.
Generally, you do not ask for time at all. How is that today you are asking? Yes,
We are ready.
all after vacation at the request of counsel for assessee. ಅಲ್ಲೇ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಸಿನಾಪ್ಸಿಸ್ ಎಲ್ಲ ಡಿಸ್ಪೆನ್ಸ್ ಅದು ಯಾರ್ದೋ ಮುಂದೆ ಹಿಯರ್ ಆಗಿತ್ತು ಯಾರೋ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿ
May I request this after vacation, my lords?
after vacation.
Yes, my lords.
All
Good.
vacation at the request of panel counsel. Yes. 32. Yes.
My lord,
Served and represented. Short idea, long idea.
ಇಲ್ಲ ಸ್ವಲ್ಪ it has to be.
Solve up.
Please.
Vacation. Yes. Ah. Short matter or long matter?
It may take about an hour.
1 hour
ಒಂದು ಗಂಟೆ ಬೇಕು.
after vacation. Yes. Raghavendra. ಎಷ್ಟು ನಿಮಿಷವರೆಗೂ? ಕೋರ್ಟ್ ಮೂವ್ ಮಾಡಿದ್ರೆ ಯಾಕೆ ಏನು ಅರ್ಜೆನ್ಸಿ ಇತ್ತಾ?
Very short matter. It's very short issue. Sir,
ನಾವು ಓದಿಲ್ಲ ಪೇಪರ್ಸ್.
this matter, there is, by the record, the works contract appears to have been carried out on land that is owned by the assessee.
Works contract on the land of the assessee himself.
Yes,
In law, legal significance ಇದೆ ಅನ್ನೋದಕ್ಕೆ.
yes.
Is it?
Now, there is a finding in the SMR order that it is undisputed that it is a joint development agreement. I am unable to support that argument, that finding. The only submission, my lord, is that how large the project is, how many tracts of land were acquired. If it can be relegated to the prescribed authority, this order can go. There is no, I am not able to defend this order. If the prescribed authority can be directed to
Relook into
review
the
these,
matter and-
review all the sale deeds in accordance with observations of this honorable court and grant relief of the concessional rate.
ಮಾಡ್ಬೋದಾ?
My lords, I have only one submission in there. There is only one project. There's only one sale deal. There's nothing to be done. And what we are saying, my lords, is
ಏನಾಗಿದೆ ಫ್ಯಾಕ್ಟ್ ಸ್ವಲ್ಪ
facts.
foundational facts ಏನು?
I'll give you the facts. There is a reassessment order.
ಅಲ್ಲ,
issued.
why you disagree with the fair proposal of learned AGA?
No, it's a very fair proposal.
ಹಾ.
But I am saying this, my lords. Section 64 itself could not have been invoked.
SMR ಬರುದೇ ಇಲ್ಲ ಅಂತನಾ?
Because there is neither an error present here. The jurisdictional facts for invoking 64 is
Let
that
us
there-
read the 64
Yes.
provision. We have not interpreted it. I think there are 2-3 judgments.
Your
we have
lordships have interpreted on high courts
High court
on
ಮಾಡಿ-
error.
error ಮೇಲೆ.
That is
But
that.
ಇದು ಈ ಅಥಾರಿಟಿ ಇದೆ SMR ಮೇಲೆ ಮಾಡಿಲ್ಲ.
Yesterday, that argument was made, my lord, on what are the twin tests, prejudicial to interests of revenue and error on the record.
I'll just give your lordship's compilation where this act is, now I've extracted this.
Yes.
The lordships were to see.
Foundational facts ಏನು?
Foundational facts. I buy a land. I construct. And I sell it to individuals.
In other words, the works contract is done on your own
On
land.
my own land. There is no dispute. There's only one land over the 3 years. Now, I file my returns. A reassessment under section 39 is done, where the authority goes through all the facts. He comes to a conclusion that more or less everything of mine is right. He disallows certain things which I have discharged. There's no dispute on that in this. Now, the revisionary authority wants to reopen all this under the ground that the only ground which he says in his reopening is that the value of land has not been included in the value of works contract. That is the only ground on which he reopens. In which there are at least 3 or 4 settled positions of this court. Where my
While
lords will
working
know.
out a works contract,
While doing a works contract, entry
value of the
54
land cannot be included. ಅಂತ.
cannot make, because that is immovable property. Entry 54 only goes to sale of goods.
Correct.
And as interpreted by this court in a catena of cases and the Supreme Court also, in L&T's case, value of land can never be included.
It is that judgment. Works contract definition ಅಥವಾ how it is worked out ಅದಂಗೆ
that is there in the KVAT itself. The definitions are there. What he says is this, man. I'll go a little further. What he says is this. When you look at the deductions that are prescribed for works contract, there is no deduction for land.
Okay.
This is his presumption on the presumption on which he goes.
That
In
itself
fact,
is wrong.
That itself is wrong because it cannot
That cannot be included because it is not a goods at all.
Exactly. And it's a settled law, my lords, that what is not included in the top line can never be deducted in the bottom line. It's very simple. This is the only issue in this. So therefore, my lords, we are coming to a fundamental. There was no error in the reassessment order.
For SMR.
For an SMR to take place, assuming for a moment, I will put it this way simply, in a mathematics class, if I were to say 1 plus 0, 1 minus 1 is equal to 1, everyone will laugh at me and say there is a error.
No, nowadays nobody will laugh.
1 minus 1, 0, 1 and the people will laugh. Now, my lords, I'll draw a parallel. I'm just giving a parallel to show what is error, what is not error. In a philosophy class, if I were to say 1 minus 1 is 1, I can take support from Ishavasya Upanishads, Shanti Mantra, straight away.
What it says?
It says if the whole, WHOLE, is deducted from the whole will remain.
Purnam midam.
Exactly. I didn't want to quote that entire thing. That, my lords, can be, I can hold that opinion. He can have a different opinion on that. He may say, no, I don't think you're. That is only a change of opinion. So what the courts have, why am I drawing that analogy here, my lords? What the courts have held is,
Simple is, if land is not goods, which it is not, where is the question of including the land value while working out the works contract? That is the only
question. The only question, my lord.
Unless it is complicated, complicated by many decisions.
Yes. No, there is no complication.
No, it happened. In England, it happened. Yes. Lord Atkins said, every decision of House of Lords makes the law more chaotic than it was before. In England, it happened. Not just.
It is something anyway. Like it's something like Anismic's case, which is
Anismic case,
which has kept on having iterations. Our Supreme Court, for example, my lord says, want of jurisdiction, excess of jurisdiction, and what is within jurisdiction errors. There is a difference. But House of Lords
apart, Mr. Aditya, that sounds to logic.
The only difficulty is this, that there is a finding in the impugned order that 4% has been collected even on the land cost. So therefore, my lord, the reconciliation can happen at the prescribed authority. I'm not able to defend it's on a.
No, you said that in all fairness, appreciable fairness.
There is
but where is the case for remand?
If the collection of tax has happened at 4%, then he cannot retain it either. That my lords, under Rule 33(14), he is required to maintain separate books of account for the project. Let him go reconcile that.
My lord, there's only one project. I will answer.
No, if you have,
because I do not know. Sitting in the High Court.
I have not collected, my lords, because that was the original, even the reassessment. They started off the same way. But my lords, they did.
Time bound ಮಾಡಣ. ಯಾಕಂದ್ರೆ ಈ ಆಸ್ಪೆಕ್ಟ್ ಇದ್ರೆ ನಾವ್ ಹೆಂಗ್ ಡಿಸೈಡ್ ಮಾಡೋದು?
So this aspect, my lords, is not there. I'm trying to say.
Your lordship, we kindly see page 76.
76.
Para 6, my lords.
Petition.
19. Sir,
76.
This is 18. 19.
Look at 19.
19.
That will have all the issues covered. 19 of 2022. That's also same page. Same page, 76.
No.
Assessment.
No, it's
separate page. Your Lordship, may kindly see 58.
58.
There were,
But one paragraph, I request you to read, any one of you can read. Para 7, page 76 ಇದೆಯಲ್ಲ. They have reproduced A, capital A. then. Just see that, yes, so beautifully, which judge has written it, I do not know. Our officer himself has written it. Many officers write better judgments than us.
that
at
is
least
in
than me.
18. 18 only.
Just see.
Position
The
of law.
presence or otherwise,
The position of law as regards the tax leviable and deductions allowed when a dealer opted to pay tax under 15(1)(b) is discussed below. The presence or otherwise of any order being erroneous and in being prejudicial to the interest of revenue is to be gathered from the facts of each case. The word erroneous employed in section 64 if wider connotation.
of wider.
Of
connotation.
wider connotation, is of wider connotation.
Correct.
It includes any mistake, error, blunder, Himalayan blunder, and even hallucination in the general sense. However, in legal sense, it means it must be an order which is not in accordance with law or which has been passed by the authority without making an inquiry and undue haste. As to what is prejudicial to the interest of the revenue, it can be that an order can be said to be prejudicial to the interest of the revenue if it is not in accordance with law, in consequence whereof the lawful revenue due to the state has not been realized or cannot be realized. The powers of revision are supervisory in nature. In order to bring an equal treatment of any issue under existing law and in accordance with law in all similar cases, revision powers can be exercised. In the present case, sufficient ground, so and so. Scope of deduction towards.
The last.
Please, we'll continue.
Notice provisions section.
Please continue.
Yes. And ambit and scope
Land
of
cost received in a JDA type of.
Exactly.
that JDA type is not there. That is my
And
first submission.
my lord, that is the only ground he has invoked.
I would
The other grounds of 4%, everything has been left because I will show you a lot from his order itself. Please come to paragraph 6, my lords, last, what he does.
Paragraph 6. Page.
Page 76, my
Six.
lords, where he says this 4% you just.
The dealers have stated that order of reassessment and revision is not erroneous.
Please come to the last 5 lines, my lords. The dealer has totally failed to explain the tax actually collected from the buyers. The dealer has not disputed total receipts of 280653 but contends that the same relates to land cost also, which is not eligible to tax under KVAT.
But it speaks admitted at 4% on rupees so and so.
That is on 20. Well, this is the error.
Huh?
Please come to page number 72, my lords. Page number 72, what I have done.
2.
only thing I am saying is this mathematics I am not able to assist with. Let somebody.
I will assist because fortunately, my lords, I know little bit of accounting. Having passed the chartered accounting course several years back. Please come to 72, my lord. See the table for a moment, the second table. My lords.
Second table.
Yes.
Ah.
The receipt.
Total receipt.
Same 28 crores is there.
Correct. Less
Now,
land
less
cost.
land cost 770. Now,
What remains is?
total contract is 20 crores on which
Fine.
VAT has been collected. This is all. So that 4% which he raised, he gives it up. He says only the land cost is an issue. So we have to read 6 and 7 accordingly. He gives up that
Yes, that
issue.
way, fundamentals of accounting, they say like that. Record it.
It's slightly a contrived order. I cannot.
You are more than fair.
It's very fair, my lord. It's very fair. No doubt.
Allowed. Impugned order is set aside.
3 are there, my lords. 18, 19 and 20.
Yes. Even the issue of 4% levy will also not arise because of second table at page 72.
Right. There are 3 appeals, my lords.
And so, same appeals, sir.
Same
order.
identical, same project also.
Set aside.
Deeply obliged.
He's been very fair. I have to place it on record. He's been very fair.
There's always in too many matters we have said that.
No, from my side, I have to say that.
Right,
Deeply
always
obliged.
fair. But if we write that, we have difficulty. They will face difficulty.
They
I
will
know
face
that.
difficulty.
ಹೌದು ಫೇರ್ ಆಗಿ ಇದ್ರೂ ಸಮಸ್ಯೆ ಇದೆ. Fairness at times land you in trouble, especially when you are appearing for the government, the governmental authorities, etc. Statutory bodies. ಪಾಪ ಅವರಿಗೆ ಫೇರ್ ಆಗಿ ಹೇಳಲಿಕ್ಕೂ ಬರಲ್ಲ. They think that you are our loudspeaker, you should go and say what we say.
I'm just giving a There are small officers summary.
Of course,
There are officers who,
good officers.
no, all submissions from my end, my lord, are discussed previously with the department. But what happens is,
Very good.
that is a floating cadre.
Ah,
Once the power structure changes,
changes.
then ಅವ್ರು ಯಾಕೆ ಹೀಗ್ ಮಾಡಿದ್ದು,
ಹೌದು.
ಯಾವ್ದು ಹೀಗ್ ಮಾಡಿದ್ದು? My lord, I'm just
Yes.
placing a short summary, my lord.
Got
So
it.
it will be useful
Got it,
for
got it,
drafting.
got it. Okay.
Deeply obliged.
Okay. Very good. Thank you. 37. Anything urgent?
Yes,
No, it'll take some time.
yes, your lordship, it will take some
Application.
Lordship,
Urgent
Before,
matters,
before vacation, any date, your lordship, 22nd
That is
and
our
20. It's a
difficulty now.
senior citizen, your lordship, he is suffering.
Then he will become little more senior, that's all. By passing,
Right
he
after the
will be,
vacation.
he will be in the June of his life. In June. There is such a phrase in English. The Wordsworth uses that. He was in the June of his life. Yes.
Lordship, right after the vacation.
Our, what Mr. Holla is always and ever in June of life. Yes. Now,
Right after the
Right.
vacation, your
Right.
lordship.
after vacation. Immediately after vacation.
First,
Now,
first week of vacation.
Ah.
Much obliged, your lordship.
now.
38, my lord, I am for the respondent. I seek for a short accommodation after vacation.
This is a short issue, but I don't want to inconvenience my friend. It's basically, my lords, now a PF deduction was disallowed for 16 days delay in depositing the collection right in the first month of COVID, May 2020. So on that, in fact, two tribunals have said that during COVID, there was difficulty, they've condoned. In fact, department.
COVID pandemic is
if-
considered
if I-
almost vis measure, vis majore in various jurisdictions. I read
My
a
lord,
beautiful
Mr.
article by
Lord,
one
Observe, COVID-
Onogo Okachukasma, a famous professor in some African country. A Professor Onogo Okachukasma has written how COVID is treated in various jurisdictions. It's a good article, actually. It earlier appeared in a Yale Law Journal. So beautiful. You know what a kind of, Mr. Holla, their journals are, they are simply mind-boggling. Where are your journals? We don't like, I tell you, what is the quality substandard journals we have? Why no effort is made to upgrade our journals?
Malas, can I just submit this?
ಯಾರೋ
In
ಒಬ್ರು
fact,
ಕೇಳಿರಂತೆ. No, I should tell
in
this.
those universities, the competition to get into the reviewing panels, what they call, say, the Harvard Law Review or Yale Law Review, it is so competitive, and they make sure the best of the best will be selected. And that is, and when Supreme Court judges and their federal court judges recruit, they will look at whether you're a part of those law reviews.
ನಮ್ಮಲ್ಲಿ ನೀವೆಲ್ಲ ನೋಡೋದು ಬೇರೆನೆ.
When they get inside itself, not the best of the people from all over the world go there. Yale.
ಅಲ್ಲ ನಮ್ದು ಯಾವ್ದು ಒಂದು ಜರ್ನಲ್ ಇಷ್ಟು ಜರ್ನಲ್ಸ್ ಅನ್ನು ನೋಡ್ತೇನೆ ನಾನು. ಅವಕ್ಕೆ ಹತ್ರ ಸಹಿತ ಬರಲ್ಲ ಮಿಸ್ಟರ್ ಆದಿತ್ಯ. Even
Our law school in Chanak Bharat, actually, to be fair.
Huh?
They, from Mr. Aditya's law school, I think most of the articles there are always of, the quality is maintained. Problem is, Malad, there are too many journals.
Definitely not comparable with the Yale Law Journal. Used to beautiful, used to thoughtful irtade.
When one of the challenges is that the faculty in law schools is not willing to write for peer review. There was a recent requirement by one of the universities that in 1 year you should have these many peer reviewed articles. ಯಾಕೆ ಮಾಡಬೇಕು, ಟೀಚಿಂಗ್ ಅಲ್ಲಿ ಬ್ಯುಸಿ ಆಗಿದೀವಿ, we are overburdened, we have no time to write. That is
ಒಂದು small event I should tell you. My guru, Mr. Holla's father, BP Holla. I was reading one ILR relating to adverse possession, a judgment. And, I used to sit in and he used to sit in the front in that old library inside. I should actually, I should pray for that great soul. I was reading ILR. ಏನು ಓದ್ತಾ ಇದೀಯಾ ಅಂತ ಕೇಳಿದ್ರು ನಾನು. ILR judgment on adverse possession I am reading. ಯಾವುದನ್ನ ಓದಬೇಕು ಯಾವುದನ್ನ ಓದಬಾರ್ದು ಅಂತ ತಿಳಿಯಲ್ವಾ ನಿನಗೆ? ಓದ್ಲಿದ್ರು ಬೈತಾರೆ, ಓದಿದ್ರು ಬೈತಾರೆ, ಏನ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋದು. ಅದು ಅಂತದೆಲ್ಲ ಓದ್ಬೇಡ, ನಿಂದಿರೋ ಬುದ್ಧಿನೂ ಕೆಟ್ಟ ಹೋಗ್ತದೆ. Don't read these ILRs. Read best judgments from All England reports. You are a growing man. You want to get everything polluted? If you want pollution, read all those ILRs. ಹಿಂಗೆ ಹೇಳ್ಬಿಟ್ರು. ಅಂದ್ರೆ ಒಳ್ಳೊಳ್ಳೆ ಗ್ರಂಥಗಳನ್ನು ಅಧ್ಯಯನ ಮಾಡ್ಲಿದ್ರೆ ನಮ್ ಲೆವೆಲ್ಲು ಹಂಗೆ ಆಗ್ಬಿಡ್ತದೆ. I learnt a great lesson from him. I pray for him. He was my guru. He told me, ಎಂಥ ಪುಸ್ತಕಗಳನ್ನು ಓದಬೇಕು ಅನ್ಕೊಂಡು. And I started telling my friends. I never said that way. He was very curt, very strict, and he knows, Mr. Valla knows his father. But he treated me more sternly than he treated you, because he was so much, he was very fond of me. Very cut, never cared anything at all. ಅವ್ರು ಹೇಳಿದ್ರು, ಈ ಕೆಟ್ಟ ರಿಪೋರ್ಟ್ಸ್ ಅನ್ನ, ಕೆಟ್ಟ ಲಿಟ್ರೇಚರ್ ಅನ್ನ ಒಂದು ಪೇಜು ತಿರ್ಗಿಸ್ಬೇಡ ಅಂತ ಹೇಳ್ಬಿಟ್ರು. ಹಂಗೆ most of the LRs I do not read it. I should confess, I do not read most of the select. ಆಮೇಲೆ ಅದು ಹೇಳಿ ಚೂಸ್ ಸೆಲೆಕ್ಟ್ ಜಡ್ಜಸ್ ಅವ್ರು ಹೇಳಿದ್ದನ್ನ ನಾ ರಿಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದೆ. ಚೂಸ್ ಸೆಲೆಕ್ಟ್ ಜಡ್ಜಸ್ ಈವನ್ ಫ್ರಮ್ ದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಂತ ಹೇಳಿದ್ರು ಅವ್ರು. ಹಂಗೆ ಹೇಳ್ಬಿಟ್ರು. Of course, what Supreme Court says is law, but for many purposes, maybe with lot of wisdom, he would have said that with that courage, he would he said that. Choose select judges from the Supreme Court and then read those judgments. Alla court begin on irbadu. We do not know like that anyway. But I pray for him. I pray for him actually. Great Allah. Yes.
In this case, it's only that issue. Of course, I'm well aware of the fact that there is a Supreme Court judgment which says that delay in depositing this PF amount in ordinary circumstances, there can be no question of allowing any deduction. But once given the fact that this was for the month of April 2020, I'm supposed to deposit by May 15th, 2020.
But delayed.
There is 16 days delay. 16. So therefore, if a lordships could consider only in the facts of this case. In fact, Bombay Tribunal and Calcutta Tribunal for the same month has already condoned. I'm told the department has not challenged it.
Kindly observe COVID.
In terms of COVID. And Bombay judgment.
Bombay judgment. It's of course, it's a tribunal judgment, Malas, only for the purpose of showing your lordships that
that they have not challenged.
They have not challenged it. Of course, it's not binding on my lords, of course, but yes, miss. They've also relied in the Bombay Tribunal, relied on a circular issued by the PF department itself saying that.
Sorry, ಓದ್ಕೊಂಬರ್ತೀವಿ.
I think.
Give short accommodation to us.
Very well.
Because we don't
No,
want
no,
to.
of course. I don't want to talk to my lord. If
Mr. Valla is waiting for which case? Next matter, yes.
Any date, my lords, if we could, since this is the only issue, if your lordships could consider on this side of the vacation, I'll be 17th one day better, any other days.
21st ತೋಣ?
Please. Grateful.
21st.
Great.
23rd.
20. Great.
Yes, Mr. Valla.
But this relates to a solid waste, my lord, pit that we had made. Whether, my lord, that would be treated as plant or not. Short question is functionality test, my lord.
Treated as plant or?
Or not. If it is a plant, then, my lord, I get certain benefits. If it is not treated as a plant, I don't get. Functionality test, anta. That's what, my lord, even the latest judgment of the Supreme Court in 2025, Justice Oak has rendered a judgment. Functionality test, where, my lord, the Supreme Court in 4 judgments have held. Theatre is, my lord, treated as a plant. The power stations treated as a plant. Mall treated as a plant. So,
definition illa, no plant.
Illa. Definition.
Hangagi judicial opinion say.
That's why, my lord, they have given a test called the functionality test. Does it function as a plant? That's what it is. In this, there are certain judgments also, my lord, directly covering this. So that's the issue for my lord's consideration.
My lord,
My name is
some
shown,
confusion, my lord. So one, my learned friend's name.
is
appears
shown
to
for
be-
R1 and R2, which my lord, I don't appear.
And
for
then
R2.
there is,
ಹೇಳಿ ನೀವು ಯಾವ್ದಕ್ಕೆ ಅಪಿಯರ್ ಆಗ್ತೀರಾ ಸರಿ ಮಾಡ್ಬೇಡ. Let us
no,
diffuse
and
the
then Mr.
confusion.
Niralgi has been requested to take notice for
R1, R2.
R4.
ನೋಡಿ.
And there is, because the central, principal commissioner of central tax,
R3, I appear for R3, my lord. in that matter.
Or three.
but I will appear for R4, my lords, because the
ನೋಡಿ,
assistant commissioner of commercial
ಯಾರ್ಯಾರು
tax.
ತೋರಿಸ್ಬೇಕು ಅಂತ ಹೇಳಿ ನೋಡ್ತೀನಿ. Entry order ಇದೆಯಾ?
Entry order ಇಲ್ಲ ಇದರಲ್ಲಿ.
ಏನ್ ಕೇಳಿ? Vacation ಹಾಕೋಬೋದಾ?
Opinion and advance.
After vacation ಹಾಕೋಬೋದಾ?
ಮುಂಚೆ
ಈ ಕಡೆ ಹಾಕೊಳ್ಳೋದು ಬಹಳ ಡಿಫಿಕಲ್ಟ್ ಇದೆ ನಿಮ್ಗೆ ಗೊತ್ತು. You are also
ಯಾಕೆಂದ್ರೆ
there in some-
ನಮ್ಮವರು ಏನೋ ಅರ್ಜೆನ್ಸಿ ಅಂತ ಹೇಳ್ತಾರೆ ಗೊತ್ತಿಲ್ಲ. Subjective ಅಲ್ಲ, I know, I also don't want to unnecessarily pressurize your lordship, but not question ಅಷ್ಟೇನೆ.
That's the point.
ಫಂಕ್ಷನಾಲಿಟಿ ಟೆಸ್ಟ್. ಅದಕ್ಕೆ ನಾನು ಒಂದ್ 2 ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿರ್ತೀನಿ, ಇಲ್ಲೇನೆ ತಮ್ಮ ಇದರಲ್ಲಿ ಈಗ ಇಟ್ಟಿರ್ತೀನಿ. ನೋಡಿ
ಕೊಟ್ಟಿರಿ. 23rd ಗೆ ಹಾಕೋಣ. We'll try.
So, R1 and R2 ಗೆ ಯಾರು
But good,
application ಇಲ್ಲ.
Court of-
I'll give you.
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ.
ಅಲ್ಲೂ ಕಾಪಿ ಕೊಡ್ತೀನಿ. ಅಲ್ಲಿ ಇದೆಯಲ್ಲ. ಇಗೊಳ್ಳಿ.
ಅಲ್ಲ, ಕರೀರಿ.
ಇಗೊಳ್ಳಿ. ಆದಿತ್ಯ.
Thank you.
ಅದು ಒಂದೇ KPS ತಾನೆ, ಇದನ್ನೆಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಉಳಿದಿದ್ದೆಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೋದಾ? ಮುಗ್ದೇವಿ. ಅಲ್ಲ, okay. ಹಾ.
Urgent is cyber.
ಇದಿತ್ತು ಸರ್ ಇಲ್ಲಿ. ಹಾ ಹೌದು.
ಹನ್ನೊಂದು. ನೆಕ್ಸ್ಟ್ ವೀಕ್ 11. 36 ಸರ್. ಅದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇದೆಯಾ? ಫೈಲ್ ಇನ್ನೂ ಇಲ್ಲ ಇದೆಯಾ? ಹಾಂ, ಟೈಪಿಂಗ್ ಪೆಂಡಿಂಗ್ ಹೋಗುತ್ತೆ.
Final hearing matter. Final hearing matter hosted. IT and I1 jingle. 3032.
RFA. ಯಾವ ಪಾಯಿಂಟ್ ಮೇಲೆ ಆರ್ಗ್ಯೂ ಮಾಡಬೇಕು ಫರ್ದರ್ ಹಿಯರಿಂಗ್?
That, my lord, in respect of
Amendment to specific relief act.
amendment to the specific, whether it has been,
Expert said in your favor.
please,
Still you want to argue? Oh,
much.
ಇಬ್ರು ಸೈಟ್ ಮಾಡಿಲ್ಲ ನೀವು ಆ ಜಡ್ಜ್ಮೆಂಟ್.
If we have, we have,
No.
Siddha Shetty, my lord, we have filed.
2024, 8th November 2024. Judgment is dated 8th November 2024.
But
where they
we
said
have
it
said
is
that-
not retrospective one.
Yes, please.
Okay.
We have cited Millard Siddha Shetty
Prospective.
as well as Millard.
Perspective ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅದರಲ್ಲಿ.
Prospective ಅಂತ hold ಮಾಡಿದ್ರೆ ಹಂಗಾಗಿ ಏನು ಅದ್ರ ಮೇಲೆ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡೋದೇನು ಬೇಕಿಲ್ಲ. Just look into that.
You have produced the
review.
You have produced the review judgment also.
That's what.
Please.
Ah.
Much obliged.
Special CCs which are pending.
Huh?
In PSI's case, my lord. Special CCs. Special CC numbers are.
ಸ್ಪೆಷಲ್ ಸಿಸಿ ನಂಬರ್
Yes, madam.
ಏನಾಗಿದೆ ಅದ್ರಲ್ಲಿ
17ನೇ ತಾರೀಕಿಗಿದೆ ಸ್ವಾಮಿ.
ಎಷ್ಟು ಸಾರಿ ಅಜರ್ನ್ ಆಗಿದೆ ಎಲ್ಲ ಡೀಟೇಲ್ ಕೊಡ್ಬೇಕಲ್ಲ ಬರೀ ನಂಬರ್ ಕೊಟ್ಟರೆ ಏನ್ ಮಾಡಿ ನಾವು ತಗೊಂಡು
ಅದು ಅವಾಗ
who is seeking adjournment in that matter?
all our discharge application was
We
filed.
do not know all that.
Yes.
Why it is kept pending since 2023?
Adjourning.
Like get the order sheet.
Order sheet I'll get.
Get order sheet.
Yes, madam.
You can't just go on playing with people like that. If a police officer is involved, he should be, whatever is, something should happen.
Yes, madam.
ಅದಕ್ಕೊಂದು ಕಮಿಷನ್ ಆಫ್ ಎನ್ಕ್ವೈರಿ ಆಮೇಲೆ ಅದಕ್ಕೊಂದು ಕೇಸ್ ಕ್ರಿಮಿನಲ್ ಕೇಸು ಅದನ್ನ 10 ವರ್ಷ ನಡೆಸೋದು ಹೆಂಗಾಗ್ತದೆ ಇಂಥವನ್ನೆಲ್ಲ ಸ್ಪೆಷಲ್ ಕೇಸ್ ಆಗಿ ಟ್ರೀಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ಸ್ ಆಕ್ಟ್ ಕೆಳಗಡೆ ಅಂತ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಲ್ಲ. There is a separate act. Yes. Criminal Laws Amendment Act 1948 or 49 ಇದೆ where they can seek special constitution of special court for such things. Not even one case they have done these things. ಯಾಕಂದ್ರೆ ಅವರೇ ಇನ್ವಾಲ್ವ್ ಆಗಿರ್ತಾರೆ ಅಲ್ಲ. Yes. ಕೊಡ್ಬೇಕು ಡೀಟೇಲ್ಸ್ ಕೊಡ್ಬೇಕು ತೊಳಿ ವಾಪಸ್ ನಾಟ್ ಹ್ಯಾಪಿ ವಿತ್ ದಟ್.
ಅಲ್ಲ ಅದು ನಂಬರ್ಸ್ ಬೇಕು ಒಂದು ಇದಕ್ಕೆ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ.
ನೋ kindly see the online record. Don't
ಆನ್ಲೈನ್ ರೆಕಾರ್ಡ್ಸ್.
don't lie to the court. Yes. Don't lie to the court. Yes. Yes. Yes.
But in this case, my lord, petitioner has filed IA for direction to furnish the copy of the subcommittee report, which is referred, my lord, in the reply statement. Entire reply statement states so. We are unable to, my lord, meet the points. But though we have prepared the, my lord,
ನಮ್ಮಲ್ಲಿ ಇದೇನದು
rejoinder.
ಸಬ್ ಕಮಿಟಿ ರಿಪೋರ್ಟ್ ಇದೆಯಾ ಕೊಡಿ ಅದೇ ನಾನು ಮುಚ್ಚಿಟ್ಕೊಂತದೇನಿಲ್ಲ ಅದರಿಂದ ಅದೆಲ್ಲ ಅದನ್ನೆಲ್ಲರೂ ಓದಿ.
Without that, my lord, I have prepared.
Rajgopal, we are of the view that copy should be shared with.
I have only one apprehension.
Yes.
Ultimately, I am in my lord's hand. I have no difficulty in sharing. Because one thing is, my lord's inquiry is yet to be initiated against them. It will be done under Rule 20.
Correct.
If we are not relying on the investigation report, and if we are only relying upon the evidences collected by the committee, or some other evidences also, only those need to be made available, particularly at the stage when we are filing FIR. If the disclosure of investigation.
Where
report-
have you filed FIR?
That is, the matter is being entrusted to CID. That is the
That's what,
whether it
now
is
it
to
has
see,
come.
whether it is to CBI or to FIR or to CID, my lord. Ultimately, complaint has to be made.
No, what is the reason to withhold these documents from the city? They will be aggrieved parties. Tomorrow,
As of
if
today.
we order, assume we
My lord,
order
as of today,
CBI inquiry.
as of today, whether investigation is by CID or CBI, they have no choice. Because as an accused, they cannot say which agency should investigate.
Correct.
Then about defending against the allegations, when,
course,
if
but-
and when issued.
Anyway, you have not opposed either CID inquiry or a CBI inquiry. We have recorded you.
I have not opposed,
Therefore,
but
that
it
question.
may impede the investigation until that,
No, it-
that is the.
No, we don't agree with that. We don't subscribe to that view. Any other, any government advocate?
When the government has to say, my lord.
Government? Yes.
Advocate General is on.
Very
I'm
simple.
sorry, Manoj, due to
Yes,
personal
sir, no
inconvenience,
problem.
Manoj, I'm not,
No, as long as you are here, your voice is heard.
please, Manoj, I'll,
It is sufficient for us. Now we
please.
are asking, Mr. Bhagwati is saying, Lakshmi Narayana also said other day, we need a copy of your inquiry report. What comes in the way of sharing it? After all, you cannot, we cannot keep these things. Whole world is moving towards openness now. Everything open. Therefore, what is the reason to withhold when the world is moving towards openness, transparency? There is nothing to be kept in enigmatically kept in a secret, wrapped in a cover.
Manoj, the only question is, Manoj, this is pre-inquiry stage, Manoj. The question is,
No, you have already ordered a CID inquiry now, that we are examining.
Correct, Manoj. CID inquiry is to look into the allegations, Manoj. We have not made up our mind whether it's true or what. After the CID inquiry, we don't know what is the outcome. So therefore, at this,
Very well. After all, on what ground you can withhold it? Which law? You can claim under 127 or ಯಾವ್ದು?
Section 8(1)(h) of the Right to Information
It's an
Act.
act, told.
It would protect disclosure
Let us read.
if it impedes investigation. I am only afraid of that, man.
Let us read.
Ultimately, whatever investigation has to go unimpeded.
Let
I
us
mean, if
read.
your lordship may kindly put it in the other way, if they, for what limited purpose they are going to use this document is what the question would be, then your lordship may consider giving it, Manoj. If at all your lordships feel what limited purpose, because by virtue of this, they should not challenge this saying stay of further proceedings pursuant to this report itself, Manoj.
No, not only that. Suppose this bench feels that matter merits investigation at the hands of CBI or NIA.
Please, Manoj.
To structure that judgment, to make it more invulnerable for challenge,
Please, Manoj.
we may bank upon the report. Then they will say, this report is acted upon by the judges without sharing copy of that with us.
Manoj, they are not saying
we
that
want
at
to
all, Manoj.
exclude the possibility of vulnerability.
Either CBI, CID, that, in fact, Manoj, it is for your lordship's satisfaction, Manoj, what thing, that is independent aspect. The question is with regard to the right of the petitioner to get the document, Manoj, may not.
Let us- That is, when they are parties to the proceedings, right to seek the documents is one, which is not spoken of by this act.
No, even then, my lords,
Even, no, there is a judgment of apex court.
Krishna Chandra Tandon, Supreme Court has said,
That
even when articles of charge is issued pursuant to an investigation, investigation report need not be made available. What evidences we are relying upon in the inquiry, only those need to be made available.
Now, if the court wants to structure its judgment based upon.
My lords are entitled to look into and do it
No,
because
if
for the
they
reason,
take
my
up
lord.
the matter before
For
the
the
apex
reason, my
court.
lords, my lords are using it only to decide which is the correct agency to appropriate agency
Correct.
to investigate.
Correct.
That is in my lord's hand. In respect of that, they have no role to play. As to which agency should investigate, it is beyond their
Anyway, in Captain Sharma's judgment, Captain Satish Sharma versus Union of India.
yes, my lords.
The apex court said there are two paragraphs which you can look into now.
That review judgment, my lord,
Review judgment.
152 paragraphs. Yes,
Correct.
my lord. Yes.
That
Morning,
gives right to them.
morning I have gone through the judgment, my
That-
lords.
that
Maybe I
judgment
have
says
missed
that-
one or two paragraphs. But the question, that stage is not reached. That was
Yeah,
a
then-
case where
Why you? How you are concerned?
I am
Why
not,
you should, see, why KPSC should worry about that?
I am not, my lords. I have
But he is
submitted
asking
my
it,
lord,
I
I have
understand.
submitted the report to the state government. Their
Yes,
payroll
so-
ends. But
Now
I
it
am
is,
only, I am only concerned, man.
No, it is only the state government now.
Very well, my lords. I only tried, my lords, because tomorrow investigation should not be impeded because of that.
ಅಲ್ಲ anyway,
ಹ್ಮ್.
ನೀವು CBI ಕೊಡ್ಲಿಕ್ಕೂ ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ರಿ ಅವತ್ತಿನ ದಿವಸ
ನಾನು
ಕೊಡ್ಲಿಕ್ಕೂ
ತಾವು
objection ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ರಿ ನೀವು.
It is for
ಹಂಗಾಗಿ-
the state to decide ಅಂತ.
ಅಷ್ಟೇ ಅವ್ರು ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ನೀವು ಹೇಳ್ಬಿಟ್ರಿ, ಅದು ರೆಕಾರ್ಡ್ ಆಗಿಬಿಟ್ಟಿದೆ, ಆನ್ಲೈನ್ ನಲ್ಲಿ ಇದ್ದು ಬಿಟ್ಟಿದೆ ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲ. ಮತ್ ನಾವು ಪ್ಲೇ ಮಾಡೋ ಅಗತ್ಯನೇ ಇಲ್ಲ, ನಿಮ್ಮನ್ನ ಕಾಂಟ್ರಾಡಿಕ್ಟು ಮಾಡಲ್ಲ ನಾವು. ಅನ್ಲೆಸ್ ಯು ಅಸರ್ಟ್ ಸಮಥಿಂಗ್ ಕಾಂಟ್ರಾ, ದೆನ್ ಓನ್ಲಿ ವಿಲ್ ಕಾಂಟ್ರಾಡಿಕ್ಟ್ ಯು.
Something contra ಏನಿಲ್ಲ ನಾನು.
Anyway, yes, which act provides you that protection? No crime is registered as of now.
Correct, Manoj. So therefore, your lordship may, as pointed out, Manoj, 81H may be
become-
81H, Manoj.
81H.
Please,
No,
Manoj.
we are not exercising 81H at all.
No, the
Not
question
on
is,
81H at
no,
all.
if your, then if your
Party to
lordships
the
are.
proceeding here. Right to information is public at large. If some XYZ comes and says that I want these documents, then you are entitled to invoke that protection. But this is a proceeding.
Manoj, this pursuant to your lordship's direction, Manoj, we have produced this document for your lordship's kind consideration, Manoj. It's limited to,
No, report was produced by the KPSC itself.
correct, KPSC, Manoj, pursuant to see what has happened for your lordship's kind reference, Manoj. So therefore, my
Never,
lord, it is only,
never you claimed a privilege while producing.
I am not claiming, it is
Take out
produced
SP
by.
Gupta.
my lord,
Take out
there are
SP
two-
Gupta versus Union of India, which is that section 127, or that only when you claim privilege, then you are entitled to withhold. This is what we were taught in the administrative law.
My lords, it's not my document, my lords. The question of me withholding does not arise, my lords. It's a document of the Karnataka Public Service Commission, whom they have placed before your lordships, my lords, for your lordships' kind consideration, my lords.
Mr. KPSC lawyer, Prakash, have you claimed a privilege of withholding the document before the court, or telling the court that don't share this document with anybody, we will give it to you? At least if you read that SP Gupta, take it, which is that 81 Supreme Court. Take out that judgment, 81 Supreme Court. Section 127, I have the evidence act nalli. What is the evidence act? Only when the state claims privilege, only then it avails, not otherwise. Evidence equity. Take out that from Google. Can you Google out that particular paragraph?
I can't appear.
One 127. 128. Privilege not waived by volunteering evidence. If any party to a suit gives evidence therein at his own instance or otherwise, he shall not be deemed to have consented thereby to, no, not that, another section. There is another section. Which is that section? States privilege to withhold information from the court. 123. Evidence as to the affairs of the state. No one shall be permitted to give any evidence derived from unpublished official records relating to any affairs of state, except with the permission of the officer at the head of the department concerned, who shall give or withhold such permission as he thinks fit. No public source will be compelled to disclose communication made to him in official confidence without that SP Gupta. Give that paragraph. That one paragraph. 56, What? Please read para 56. We are telling it from our students' memory. Thereafter, whenever we turn the pages of that report.
Can
I read it out, my lord?
Yes. Law is discussed in that. Professor.
Disclosure of documents, privilege, that's the heading which your lordship. Law school days memory, my lord, is right exact on the point, my lord.
Yes.
We now come to a very important question which was agitated before us at great length and which exercised our minds considerably before we could reach a decision. The question related to disclosure of correspondence exchange between the law minister, Chief Justice of India, Chief Justice of Delhi High Court and Chief Justice of India in regard to non-appointment of O.N. Vora and S.N. Kumar as additional judges. The learned counsel for the petitioner and S.N. Kumar argued before us with great passion and vehemence that these documents were relevant to the inquiry before the court and they should be directed to be disclosed by the Union of India. This claim of the petitioner and S.N. Kumar for disclosure was resisted. Vora was concerned, his case stood on entirely different footing from that of S.N. Kumar, since unlike S.N. Kumar, who allied himself with the petitioner and actively participated in the argument almost as if he was the petitioner, Owen Vora, though was a party to the respondent in the writ petition, and Mr. V.M. Tarkunde did not appear and participate in the proceeding and seek any relief from the court in this regard for his continuance as additional judge. Mr. Mridul, on behalf of the law ministry, informed us that in the fact Owen Vora was started practicing in Delhi High Court and his case could not be considered by us when he himself did not want any relief. So far as so-and-so is concerned, the learned so-and-so conceded that the documents which the disclosure was sought for on behalf of so-and-so were undoubtedly relevant to the issue arising before the court, but contended and in his contention he was supported by so-and-so on behalf of law minister that they were privileged as against disclosure on two faults. One was that found part of the advice tendered by the Council of Ministers to the President, and hence by reasons of Article 74, Clause 2 of the Constitution, and the court was precluded from ordering their disclosure and to look into them, and the other as they were protected against disclosure under Section 123 of the Indian Evidence Act, since their disclosure would injure public interest. We would propose to consider these rival arguments in so and so. Then they discuss the whole thing, Malad. Then para 56, then they come to the conclusion.
There's our professor is to say, Professor I.G. Hregood is to say, the state can exercise the privilege of withholding the document from the court, number one, provided A, B, C, D ingredients to inhere. And S.P. Gupta eliminated A, B, C, D exceptions. No document can be withheld from the view of the court, but you can say that it should not be shown to others.
Correct.
To that level, law has developed. Is there any change in the law after 1981?
Therefore, Malad, the question
81 Supreme Court.
Please, Malad, therefore, insofar as giving the document, sharing the document to show to your lordship, Malad, either
No,
any
it's
of
not your document.
that is what I.
At all. Therefore, 123 privilege not available to you. It's your document.
Yes,
Yes, 123 reader, which law provides for withholding the document. 123 speaks of the state. You are not state.
Can I read,
You are not
Malad?
government.
Can I read, Malad?
Yes.
No one shall be permitted to give any evidence derived from unpublished official records.
Official records.
Please, Malad.
Relating to any affairs of the state. It's not affairs of the state.
No, that's why, Malad.
Interpreted by Punjab Haryana High Court. It is not affairs of the state.
No, Malad, this is given an inquiry report given by the KPSC, Malad, for the purpose of initiating further action. It is the internal inquiry report to that only to that extent, Malad.
But never it was acted upon.
It
Only
was
when we threatened the government started doing all that. I repeat, we repeat, when we threatened the government, then government started working it. It is issued on 23 March, perhaps.
January 2025, Malad.
31/25.
23rd January.
When the hearing was halfway through and we were threatening, then it started. Therefore, it cannot be like that.
No, now the application is before your lordships and probably I've not got the application under 226 to your lordships for is there, yes.
What?
For your lordships kind consideration, application is filed before your lordships to direct them to submit a subcommittee report, Malad.
What is the, Mr. Lakshminarayan, what is the law on the point? Legal aspects. Don't argue on facts. Facts we know now. What is the law on the point? How the courts have treated this question? Come this side. The many will be interested in hearing your voice.
Whether the information can be withheld or not.
Yes. What is the law on the point?
I have passed on the judgment on 29, but 2023.
What does it say?
Paragraph 60.
Read.
I'll just read it. Married.
Yes.
The judgment is passed on. In Amit Kumar Sharma versus Union of India, one of us, Dr. D.Y. Chandrachurje, speaking for the court, comment on the procedural infirmities which the procedure sealed cover perpetuates. The elementary principle of law is that all material which is relied upon by either party in the course of a judicial proceeding must be disclosed.
Yes.
Even if the adjudicating authority does not rely on a material were arriving at a
Still,
point.
even that should be disclosed, because the other side may rely upon it. But that is the argument, what the court articulated, what is the
They said
issue?
the finding is that the information should, that is one of the part of
Read that paragraph.
the non-disclosure of a relevant material to the affected party in its dispute give adjudicating authority in this case sets a dangerous precedent. That's the position.
Therefore, any document which is a part of adjudicatory process, that should be shared with both the parties, with each other.
1961 Supreme Court, I have 62 Supreme Court, 1110, my lord. That was a case where an examiner was involved in a malpractice. The committee has been constituted. The apex court said,
Ghanasham Das case,
yes. I'm sorry.
much
my lord.
law has developed thereafter.
Yes, sir. Your lordship read Ghanshyam Das case.
That is, law has marched much thereafter.
Yes. In fact, I have placed on that the latest two judgment of my Lord Justice Chandrachurje, Judy of administrative action. Now KPFC has exercised, my Lord, power of to constitute a committee which is an administrative in character. And under what circumstances this power can be, judicial review can be exercised. That's the position.
First one. Did you refer to that committee report in your pleadings before the KAT?
No, my Lord, I
See, just see.
I did, my learned friend, my lord, filed an application before the KAT. And
There,
that came to. My
anywhere-
lord, I just wanted only two sentences. In fact, I have built up, my lord, up to 2024. What the apex court has said,
No, we are not on that. We are asking a factual thing now.
factual. my lord.
Have you mentioned anything about the inquiry subcommittee's report in your pleadings in writ petition or in
In the writ petition,
KAT? Just read.
the writ petition also, my lord, we have pleaded in the present, now rejoinder is filed, we have taken up the stand stating that we have not been heard and committee.
No, not that, not that. Did you have you mentioned about the report of the committee anywhere in your pleadings? Disclose that to us first.
Yes.
Did you tell it to KAT? Did you tell it to writ court at any point of time? You were not heard in the matter is another thing.
Yes.
You are not with a copy of that report is at another.
Yes.
Where is the stand you have taken? About report, what you have stated?
My lord, the second prayer which I made, my lord, in the petition, if your lordships kindly take paragraph, page 21, issue a writ of
Based
mandam.
on report dated 24/1/2025.
Yes.
Therefore, you know the report.
Yes.
Yes, otherwise you would not have said.
No,
Don't act upon the report unless we are heard. How are you going to say?
no,
Where have you taken up the contention? Report is not given to you.
I have taken up the content.
Where have you? Taken? Show that. You were not heard is maybe true. We don't have the copy of the report and tell you. Where have you stated? Mr. Bhagwat?
My lord, para 43,
43.
yes. Therefore, the petitioner, that this sum may be directed to issue interim direction directed the KPSC to make available the report dated 24/1/2025 and give them an opportunity. I sought for an interim.
Make available the copy of report.
Yes. We don't know, my lord. We relied on this newspaper.
This is in WP.
Yes.
KPSC, you have filed your statement of objections. Where have you said that this report cannot be given? Where is your objection statement?
We have filed here, my lord, not in.
You have filed statement of objection.
Report based, report.
Where have you taken up the contention that this report cannot be granted? All right. State also should be ready to answer. What have you stated in your objection statement? You have also filed one.
The objections, my lords.
Para 23, we have stated report is not.
Not given. Yes, sir. Where have you? Where have you, Mr. Rajgopal, have you said anything?
In Mr. Bhagavat's petition, there is no prayer for making
Leave it.
the report.
But this petition.
About this petition, I have said
Petition
this
itself is not
petition,
maintainable,
no,
therefore. we
because
come to that.
he was not a party before the tribunal.
That's all right.
That-
In your objection statement, have you controverted this contention that we have not been given a copy of the report? We will not give one. We want to exercise privilege. Whether such a contention is taken.
My lords, in fact, when we handed over in the statement of objections,
Nothing is stated.
nothing is stated for this reason. Even when we handed over the report to the court, if my lords would kindly see, it was handed over in a sealed cover. At the first instance, tribunal asked for the report. Then we gave the report saying that it is only for the perusal by the tribunal.
Correct.
And it shall not be shared, and they returned it to us. Here also, my lords, in two sealed covers, it was given.
Correct.
My lords have recorded.
Correct.
So,
But where have you taken up the stand? Pleadings are drawn now. In your pleadings,
yes, ma'am.
you should have said, we can't give that to this one. He is not
Because
entitled.
in the
This
fir-
will be the problem.
In the first of the writ petitions, there is no prayer for disclosing the report.
At
It
all.
is now in the report at all. Now, for the first time, they are seeking by way of an IA.
No, first bidding.
Okay.
ಇನ್ನೊಂದು petition ಇದೆ.
In the petition, I have given only one sentence response that
Not
it is not maintainable.
That's all right.
Because he was not a party.
You have said that.
Yes. On merit side, it not, because by virtue of the judgment in Chandra Kumar, I have not traversed on merits whatever has been stated there.
Mr. Bhagavat, where have you said you needed a copy of the report? It was not given to you. Where have you are arguing that one?
But now, in the reply refer, I filed a revised.
No, resigned are all right. Resigned are under our proceeding rules. Rejoinder cannot relate to anything which they have not asserted. You should have done something that they have said. This is what division bench has said.
Based on the report.
That's all. We are asking simple question. Have you said anything about in your report? Mr. Goraj Gopal, you have not said.
Before the tribunal because report was not available at all. They gave only before the court tribunal.
Did you,
Then I asked.
all right. Did you ask for the report before the tribunal?
Yes, my lord.
Where is that?
They said before that we don't.
Where is that order? See, oral evidence ಮಾಡ್ಸಕ್ಕ ಅವ್ರದ್ದು ಎವಿಡೆನ್ಸ್ ತೊಳಿಕ್ ಬರ್ತದ ಫಿಟ್ ಮೇಲೆ in the order sheet ಹೇಳ್ಬೇಕು. No. So in your objection state, you have not filed any objection Lakshmi Narayana's matter? Any objection?
So I have
Not
not
filed
filed a
any at all.
I have filed a joint objections in respect of two. There in one paragraph, I have said that writ petition is not even maintainable because he was not a party before the tribunal. And he cannot convert this honorable court into court of first instance.
Okay.
That is para 2 of my statement of objections.
Second of the writ petition, that is writ petition 5562 is not even mentioned. The petitioner is admittedly not a party before the tribunal. Commission administration. tribunal
Yes, we
is
have
the-
seen that. Your Chandra Kumar had said.
Therefore, I have not referred on merits. I have no occasion to traverse.
Where is the tribunal's order, Mr. Bhagwat, you are referring to? We do not know all that.
They-
Tell it, they produced on, where did you ask for a copy?
I asked them, they have report said.
How can I believe you? That's what. No, we can't believe that way. Question is not personal. Don't take it personally. Don't take it personally.
They have given the report to the traveler, and I asked the report lot, and that.
How we should, now you are saying that we have asked for report. There is a method for asking the report before the tribunal. By making a memo. There is a method. Otherwise, ನಾವು ಹೆಂಗೆ ನೀವು ಹಿಂಗೆ ಹೇಳ್ತೀರಿ ಅವ್ರಿಲ್ಲ ಅಂತ. ನಾವೇನು ಟ್ರೈಬ್ಯುನಲ್ ಅವ್ರನ್ನ ಎವಿಡೆನ್ಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಕಮ್ ಟು ವಿಟ್ನೆಸ್ ಬಾಕ್ಸ್ ಅಂತ ಹೇಳಿಕ್ ಬರ್ತದ ಜಡ್ಜಸ್ ಅನ್ನ.
Order sheet is the final
That's what, this one.
record of what happened in the court.
Before KAT, did you file your reply?
Because that it was only heard on interim
Interim order,
prayer.
it became their.
Then court wanted to see the report. We said that court may look into it, but that.
The para 4 of the tribunal order, I just read it. The learned counsel for two KPSC authorities appeared submitted. Irregularities committed during the examination was brought to the notice of the KPSC. When the provisional list was published on 22/9, KPSC initiated into the allegations of constituting a subcommittee. While subcommittee was still in the process of completing the inquiry, final list dated so and so was published. Realizing that the inquiry report is still not completed against the fraud committed in examination with the appellant and other case, the respondent requested the R1 not to issue appointment based on the select list. Malad, the report is now placed before your lordship.
Now inquiry.
No,
report
the
has been
learned
submitted to
canon
respond
counsel
number
has
one.
informed.
We have to take appropriate. We have submitted this point.
They didn't say
Now,
that. The
now
report
what
is
they
ready.
mean, now is 22 to 2024.
That was appointment order.
No inquiry, no,
That is,
has been submitted. In fact, they have produced the letter also.
Then Malad, they
applicants-
say, R2 has submitted a report to the R1 who has to take appropriate view. He further submit that R1 has taken cognizance of letter 22 and the same is incorporated as condition number 12 so and so. As the applicants are fully aware of the condition, the appointment are they correct. The government advocate and so oppose the application. On perusal of the content so and so, it is revealed that the inquiry into allegations of fraud in OMR sheet has been fraud committed by the R2 and these notices were issued to the learned counsel, appellant brought to our judgment so and so. The factions of those are different accordingly on the grounds. There is no grounds for wrong reason. And the very members have interviewed us.
Sir, kindly keep on 13th to this order. Or the, not serious something for the applicant. Other EGA for R1, the same Prakash, other standing for this order, interim pay. Without for order, interim pay. In the meantime, other standing for this for R2, submits that he has produced the inquiry report. Produced the inquiry report as such that has been returned to the learned standing for them for R2 direction to him to submit the same to the government. Wherein government may submit the same on the next, on the report on the next day.
and where have you sought for the copy?
Yes. That was returned to the party.
ಅದನ್ನು ಬರೀತಿದ್ರು ಹಂಗಿದ್ರೆ.
ಬರ್ದಿಲ್ಲ.
ಅವ್ರು ಬರ್ದಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರ ಮೇಲೆ ಆಕ್ಷನ್ ತೊಗೊಳ್ರಿ ಹೋಗಿ.
ನಾನು ಕೇಳಿದ್ದೇನೆ. VC ಇಲ್ಲ, VC ಕೊಡ್ಲಿಕ್ಕೆ
ನಿಮ್ ಪ್ರೈಮರ್ ಫೇಸಿ ನಾನ್ ಕೇಳಿದ್ದೇನೆ ಅಂತಂದ್ರೆ ನೀವು ಹಂಗಲ್ಲ ಅದು. ಅಲ್ಲಿ ಪ್ಲೀಡಿಂಗ್ಸ್ ನಲ್ಲಿ ಫೌಂಡೇಶನ್ ಬೇಕು.
ರೀಡಿಂಗ್
ಫೌಂಡೇಶನ್.
ರಿಪೋರ್ಟ್ ಆಗೋದ್ರಿಂದ ಅವೇ ಹೇಳಿದ್ದಾರೆ.
ಅಂಡರ್ಸ್ಟುಡ್. ನಾಟ್ ಸೇಡ್.
ಇಲ್ಲಿ ಅವರು ರಿಪ್ಲೈ ಎಂಟೈರ್ ರಿಪೋರ್ಟ್ ದೇ ರಿಲೈ ಅಪಾನ್ ದಟ್ಸ್ ಆಲ್ ಅದರ್ವೈಸ್ ಅವರು ರಿಪ್ಲೈ ಮಾಡ್ತಿದ್ರು ನಾನು ಕೇಳೋದಾಗಿದೆ ರಿಪ್ಲೈ ಮಾಡಬೇಕು
ಹೇಳ್ತಾರೆ ಅದಕ್ಕೆ ಅವ್ರು ಉತ್ತರ ಕೊಟ್ಟಾರೆ. ಫಸ್ಟ್ ಪಿಟಿಷನ್ ಮೇಂಟೈನ್ ಆಗಲ್ಲ, ಅದಕ್ಕೆ ನಾವು ಮೇಂಟೈನೇಬಲ್ ಅಂದ್ರೆ ಮುಂದಿನ ಟ್ರಾವರ್ಸ್ ಮಾಡಲಿಲ್ಲ. ಈ ಪಿಟಿಷನ್ ಮೇಂಟೈನ್ ಆಗ್ತದೆ, ಬಟ್ ಅದರಲ್ಲಿ ಅವ್ರು ಕೇಳಿಲ್ಲ, ನಾವು ಅದಕ್ಕೆ ಉತ್ತರ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ.
Yesterday we issued, yesterday we were served the application seeking the document.
Now we are asking you, we'll take a decision whether to give it or not is another thing. Many repercussions are there, as Learned AG has pointed out, Mr. Rajgopal has pointed out. There are certain aspects. Really.
Notice is issued to us to produce the carbon copy of the OMR, which we have come up and have produced it. But in the whole instruction issued by the
ಅಲ್ಲ, ನಮ್ಗೆ ಒಂದು ತೋರಿಸಿ. ನಮ್ಗೆ while entrusting it to some special agency for investigation, you should be heard in the matter ಅಂತ ತೋರಿಸಿ.
Yes.
Suppose CBI, CID ಅಥವಾ PSI ರಿಕ್ರೂಟ್ ಮಾಡಿದಾರಲ್ಲ, ಅವ್ರ ಕಮಿಟಿಗೆ ಕೊಡಬೇಕು ಅನ್ನಂಗಿದ್ರೆ ನಾವು
committee format ಮಾಡು ಮೊದಲೇ
we are asking, we are articulating the question of law. Before entrusting the matter relating to recruitment scams, we are choosing the word relating to recruitment scams, the candidate should be heard in the matter. Give one single time.
That question is concerned, entrustment is concerned, without referring to the report because the committee heard, my lord can do that. We have no objection.
You have no objection.
I have no objection, but the report is concerned, based on the report.
ಅಲ್ಲ ಬಿಡಿ, you have said now, it's recorded now. You say that you have no objection for entrusting the matter for CBI inquiry, whichever inquiry.
Report.
ನಮ್ಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗ್ತದೆ ಅಲ್ಲಿ ಎನ್ಕ್ವೈರಿ ಒಳಗ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಿ ಏನ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋದು ಅವ್ರಿಗೆ ಬಿಟ್ಟಂತ ವಿಷಯ.
Report is concerned, we were heard because it is not a private document.
ಅದು ತೋರಿಸಿ ಅಂತ.
We have been heard.
No, show the law that court making up its mind to entrust the matter to CBI inquiry, it has to hear the possible or potential accused. Give that judgment.
The subcommittee report passed adverse comments on me, on us. Right? Whether subcommittee report should be accepted or not.
Accept ಮಾಡಲ್ಲ. Based on that, a clue ಅದು, it becomes clue. In investigation, nothing, ಇದು ಇಷ್ಟ ಇಟ್ಕೊಂಡಿದ್ರೆ ನಿಮ್ನೆ ಅದ್ರಾಗ ಹೀರೋ ಮೇಲೆ ಎಲ್ಲ ಕಲೆಕ್ಷನ್ ಮಾಡಬೇಕು.
It is not conclusive.
It is not, it is only a clue for investigation.
He has no, commission has no power to constitute subcommittee.
That's all.
It is for the government to do it.
Now, we have asked a question of law to you.
Yes, sir.
Both of you may answer.
May I assist me?
Yes.
I have furnished one judgment. That is. it is
Before
not-
entrusting the matter to the CBI investigation,
But on the other day, I made
potential accused should be heard in the matter. Which judgment says?
2022,
What is 20, which is the paragraph? Kindly read that.
blood 17 SCC 781 in volume
2022,
1.
Volume 17, SCC 721.
Yes. Paragraph 13.
Please read.
The duty of the judiciary to follow the principles of natural justice has been highlighted in Divine Treat Center versus State of Kerala. In this case, it has been held. The order directing the investigation on the basis of such vague and indefinite allegations undoubtedly is in the teeth of principles of natural justice. It was however submitted that the accused gets a right of hearing only after submission of the charge sheet.
Correct.
Before a charge sheet is framed or the accused is discharged, wide section 227 and 228, 239 and 240. The appellant is not an accused. Therefore, it was not entitled for any notice from the
Notice
High Court
anything, yes.
before passing the impugned order. We are concerned with the question as to whether the High Court could have passed a judicial order directing the investigation against the appellant and its activity without providing an.
No, we are not directing against you. Why do you assume? Why do you assume that we are directing investigation against you?
Just 1 minute. Like, no judicial order can ever be passed by any court without providing a reasonable opportunity of being heard
Correct.
to the person likely to be affected by such order, and particularly when such order results in drastic consequences affecting one's own reputation. In our view, the important order of the High Court directing inquiry into the allegation of which is not even a complaint has been lodged with the police is violative of principles of. There is one more judgment where in case of a tainted, if a complaint is against a particularized individual, then they are entitled to have it.
We are not saying that.
No, my lord, in fact, I took up the contentions, my lord, that there are two aspects. The KPSC manual, my lord, has got certain provisions so far as the OMR is concerned.
Yes.
But OMR, a phenomena was evolved in 1960. The KPSC manual has adopted the
Same model.
the same thing. Now, my lords, the certain provisions says how OMR is issued to the students, in the examination hall, how it has to be scanned, how.
No, that's another aspect. We will not, we
The
don't
tools-
want to
tools
enter
are
the
that-
domain of investigation.
No.
Be it CID, be it CBI, be it NIA, or be it a special investigation team, which in our wisdom we may evolve. We are not on that.
No, only two is a very important aspect of this. Now, once the OMR, my lord, is collected by them, and once it is scanned by them, the result has been out. My lord, there are international journals on technology, my lord. I collected, my lord, I filed it in the court. It says the scanning, my lord, is on 100%, there is an accuracy up to 99.909. Number one. Number two, what is the allegation, my lord, here is that if a Siddhareddy who files a complaint that they did not secure any other marks in earlier exam, and there is take out the CCTV footage and find out. My lord, based on the CCTV footage, it is not possible, and he did not pursue the complaint.
No, it's not just bipartite. It is not just like that. There is a government agreed. One thing we should appreciate the government also. We should be fair. Government immediately said, they asked for permission of the government to send it to FSL. Government said, send it to FSL.
My lord, FSL will not.
FSL report has come now.
No, my lord.
It has come.
That is why, my lord, I have a material, my lord, to substantiate. This is a case where scanning of OMR is also, my lord, the same machines are being used in the healthcare and various other cases. 100% accuracy.
Anyway, why you are bothered about if your clients are genuine? They will emerge colorful.
No, I stood the 95th rank.
You will be entitled to get the
And
appointment.
All India 5th rank.
Most welcome. Why are you apprehending that CBI will point towards you?
But what is the basis, my lord? Your
Yes,
lordship may
there is
give
a-
me 10, 15 minutes, my lord. I will make a submission.
But let us come to the point. Generally, we have constraint, we know. So those constraints you have to overcome because there is not even final order of the KAT.
That is how.
You have come here because interim relief is denied to you. That we know as students of law, more particularly the ardent students of Mr. Rajgopal is also smiling because he knows that. Therefore, that hurdle is there. That's a judicial statesmanship after all that is left to the court. Suppose if you are really most meritorious candidate who is entitled to a Nobel Prize of
No, I am not supposed.
why you should shy away? Whichever inquiry, most welcome. whichever inquiry. Bhagavat said no. Yes, do it. When you start resisting this idea of entrusting the matter to special investigation or such other agency, doubt starts lurking in the mind of the court.
My lord, may I make one
Regulatory,
submission?
so yeah.
May I make one submission? Initially, three
One
members.
second. Because we saw that they sent the letter asking for FSL. They said send it immediately. If government people were really involved, they would have said, why FSL? Not necessary. Immediately. They did not spend 1 minute on that. Straightway they say, send it to.
My lord, this
FSL.
is, I am sorry for using the word, searching a ghost in a dark room. I just, my lord, OM, in fact, I will take your lordship, the International Journal on Science and Technology were saying OMR is now recognized as 199.909% success.
Correct.
Accuracy.
ಅದನ್ನೇ
Now,
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಬಂದಾಗ ಇದನ್ನ ತೋರಿಸ್ಬಿಟ್ರೆ ಆತವ್ರು ಹಿಂಗಿದೆ ಅದು ನೀವು ಸುಳ್ಳೆ ನನ್ನ ಮೇಲೆ ಬೆನ್ನ ಹತ್ತಾ ಇದ್ದೀರಿ ಅಂತ ಅವ್ರು ಬಂದ್ರೆ ನಿಮ್ ಮುಂದ್ ಬರೋ ಪ್ರಶ್ನೆ ಇಲ್ಲಲ್ಲ. ಯು ಆರ್ ಮೋಸ್ಟ್ ಮೆರಿಟೋರಿಯಸ್ ಕ್ಯಾಂಡಿಡೇಟ್. ವೈ ಆರ್ ಯು?
just one submission. I'll just take your lordship because unless your lordship permits me.
No, you said that. We have great respect, admiration for your hard work, etc.
In fact, I have applied my mind, my lord, very extensively in this matter to assist your lordship. This is a clear case of OMR is regulated by KPSC manual. It has been scanned, result has been out. Now, to retrieve the scanning result, it is open to them to retrieve it and do it only with the permission of the court. With the permission of the court. Now, we have been appointed and we are working.
Correct.
There is a deadlock between the secretary and the chairman and the member. When we were appointed, only 9 people were there. That is how Shanta, Vasamani, and other 3 people were members of the committee. And those members, were agreed where a senior member has been presided over as an in charge. Therefore, chairman, 5 members were there out of 9. That is how the list got operated. Now, my respectful submission to your lordship says that if OMR is prescribed, in fact, I stated in my counter, rejoinder, that in IAS, All India Survey, in almost all the systems of examination now, 12 crores examination students have used this OMR. 7 point, in fact, this is an information given to the Lok Sabha. I have stated also, which is available in the book. Now, if OMR is to be suspected, that is how, I am instructed to submit your lordship based on this. Nobody can say OMR is fabricated or OMR is altered. If OMR is fabricated, OMR is altered, even in the CT scan, MRI, everything would be found to be incorrect data. So therefore, to say that OMR is fabricated, OMR is tampered, it is impossible unless.
There are 2 judgments of the apex court where they said OMR is tamperable.
Yes, my lord, I went through it, my lord. In the OMR paper, if a mark is put, some significant mark is put, my lord, or some data is put so that the paper can be identified in collusion with the agency, that is a different matter. That is not the case here. Here is a case where a man sends email along with the 600 objection. He did not pursue, he did not steps into the KPSC. And it is only the members who took up the matter and who interviewed us. In fact, I took up a contention, my lord, that the members who have interviewed us could not have been the members of the committee.
This argument is to resist investigation. What purpose you are arguing this? We should know. For what purpose? In this argument is directed against
Just now,
what
my lord,
proposal?
No, just now your lordship said Ghanshyam Das, 1962 Supreme Court.
Yes.
Where said an examiner was involved, in fact, not the student. A committee was
That time OMR was unknown to the people, at least in our state. All this idea emerged only thereafter, though it was available. There are judgments.
My lord,
said in
I
19
have furnished the latest judgment 2023 also in respect of environmental matter where a committee was constituted, a report was submitted. The my lord Justice Chandrachud said, no, the principles of natural demand the committee report has to be given. My lord, this
No, we
is-
are not asking investigation against you. That was a case where an individual investigation was directed. The police were directed to register the case against you. No, we are not doing it. We assure you. Police will decide.
my lord, I am only assisting your lordship that
No, we
they
have to know.
responded, they responded.
No, Mr.
Comes
Lakshmi
up
Narayana.
a plea.
Lakshmi Narayana,
I'm sorry.
kindly tell us, do you oppose entrustment of this investigation to an agency of some reputation? Some reputation.
May I make appeal to your lordship? On this issue, my lord, what I appeal to, my lord, without even consulting the others.
Consult to my video.
No, only both of us, my lord, we have to.
Our helpitru.
No,
The objection is
ಇಲ್ಲ,
not
ಇಲ್ಲ,
there.
ಇಲ್ಲ, ಅದು
Right before your lordship, under 227 power, brought up this court on Sachin Kumar case. This court, Supreme Court, confirmed by the same, right?
That's what. Correct.
Based that judgment, as far as investigation is concerned, my lord, certainly.
Court's power.
It is not permissible. Still, my lord thinks that investigation is done. I leave it to the court.
Permissible, not permissible.
That's what my lord Supreme Court says.
Why can't you?
227 power. And when examining the interim order of the tribunal, it will not act as a appellate authority. Not, it is restricted power, it is not arbitrary, that sort of lack of jurisdiction is there, that question can be examined.
Ordinarily, yes. Conventional view of the court is that one only. But this is a case which involves
On that, that's all, it's not judgment.
So ನಮ್ಗೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಕೋರ್ಟ್ ಮುಂದೆ ಎಲ್ಲ illegalities ಅಷ್ಟು if they dance here, we should just close our eyes, decide your list and go home. That perhaps is difficult to do. We will be doing injustice to the oath we have taken. Please.
That what is the power under 227 after Chandra Kumar's case?
Please. Odi, ಯಾವ್ದೊಂದು we have already read that judgment. That judgment.
2019-20, I think it's 143.
Yes.
Politician judgment not on.
Please send for CPI council also. Prasanna Kumari phone ಮಾಡಿ. Paragraph
Para 84.
84.
It is true that in L. Chandra Kumar, this court started. Tribunal constituted under 323A, 323B of the Constitution, the subject for the jurisdiction of High Court, within whose jurisdiction they were located, as noted by this court in HS Yadav Street. I not remember. Then, my lord, the power of the conferred on Article 27, however, Supreme is not affected. It is settled law that power of judicial
Is not appellate power, it's a supervisory power. Court has conventional constraints.
Yes, my lord will remember, in Sampath Kumar case, Justice Ramjay said that all orders of the tribunal are back in 87, are subject to revision of this court. Supreme Court said reverse that Sampath Kumar decision. Exactly 87 Supreme Court said no. That 97, all cases are flooded before Supreme Court. Supreme Court said.
L. Chandra Kumar.
L. Chandra Kumar. But I only know what is the limited power of the High Court. That is what I need to report
Yes.
because I am ready to face any inquiry because I have not done anything. I have got findings and rejoined. But on the face, Lord, it will show. In fact, the whole ticket instruction says, Lord, what is the illegality in OMR? It says, Lord, para 21. But I cannot even pass on OMR. 20 not rejoined by now.
Our Pop, one point he wants to make out. I'll come to you. Wait, we'll come to you.
But I'm sorry, I'm
Really, okay. Why do you?
Only
It's
with
your right to argue.
Yes,
Perhaps
yes.
it's your duty to argue. You are instructed. You are paid for making argument.
In
I'll
fact,
shine ಮಾಡಬಾರ್ದು. ಏನಿದೆ clear cut ಹೇಳಿ.
I have taken a,
Ultimately ನಾವೇನ್ ಮಾಡಕ್ಕದು, that's another thing.
in fact, when I compare to all other cases, in this case, I've taken a much pain, my lord, to assist your lordship.
We
That is-
always appreciated you
No.
because you burn midnight.
There are
We
two
accept.
aspects, there are two aspects.
ಎರಡು ಕ್ವಶನ್ ಹೇಳ್ತೇವೆ ನಾನು ಆರ್ಟಿಕ್ಯುಲೇಟೆಡ್ ಆಗಿ ಹೋಗೋಣ ಮೆಥಾಡಿಕಲಿ because perhaps your client who is more meritorious may agree with this proposition also. Number one, do you have objection to entrust the matter to the some agency of reputation? Answer is binary. You can give the reason. It can be yes or no. It cannot be anything in between. And you can reason now. Number two, is it your case that before entrusting it or deciding to entrust, give copy of the report, then take a decision, in which case your proposition falls. ಎರಡೇ ಹೇಳ್ತದೆ, ಬೇರೆ ಹೇಳಲ್ಲ ಅದಕ್ಕೆ.
Report,
Bhagavad
report
said,
ಕೊಟ್ಟು ನಮ್ಮ
Other question will not arise.
report ಕೊಟ್ಬಿಟ್ಟು ನಮ್ಮ my lord, as a senior, as a senior counsel, my lord, there is one thing, my lord, which I am appealing to your lordship. Whenever your lordship's conscience says, yes, there is a case to be looked into by CBI, my lord, we cannot come in the way, number one. Not in respect of this case. There should be a prima facie case that so-and-so has committed a blunder or violation of law. Now, in this case, my lord, that is why I take only 5-10 minutes. What is meant by OMR? OMR. I can understand if they have made an allegation that I colluded, not me, my lord, generally.
Candidates collude.
A has colluded with an agency because the examination, my lord, the examination, that is controller of examination of the KPSC, who is in charge of this OMR, printing, software feeding, and issuance of a OMR, each room 25, then getting back, then scanning, then they are sending it for evaluation. This is one thing. Originals are retained by them, they are the custodian. Once it is scanned, it is open for them to retrieve the information at any point of time. Not if I am only concerned about the tomorrow's minute, no one should say that so far as the OMR is concerned, on what basis the investigation is ordered or directed, only that area, I want to assist your lordship, because I know a little bit, in fact, I studied on this. The KPSC manual scanned everything. You are the custodian. Copy is retained by us. Copy is retained by us as per the instructions of the candidate, 21, up to the date at which the final list is published. 31/1/2024, the list has been published. Then 5/2/2024, We have been asked to go to the government for an appointment. We went there. Then the assistant secretary of the KPSC asked us, please come along with the copy of the OM. Everyone was produced except the 4 people, and the 4 people, they have got their explanation saying that while shifting the house, we have missed it. That is after the. There is no sanction if you don't retain the copy of the OMR. Either your examination is cancelled or there is no sanction at that point of time. I am told there must have been an amendment, Malad, now. That is a different aspect. Now, Malad, if a complaint in 3 lines it says, these people have secured a less marks. Please take the assistance of the CCTV footage and find out. The KPSC appoint the 3 members committee, then 5 members committee.
And one of them is retired district principal district judge.
Yes, yes. He's in a hurry to prepare a supply, the additional list because of so many reasons. We don't have a right to comment on that. Now, if the OMR is scanned, you are the custodian of the software. You are the custodian of the original OMR, and where the manipulation has taken place.
That should be investigated by the C. That should be investigated. Because we can't make allegation against you. Going by your argument. We can't prima facie say proceed against clients of Bhagwat, clients of Lakshmi Narayana like that at all.
Blood, if
We
you
want to know.
Blood, if your lordship, if this matter under your lordship's continuous supervision, and if it is general malady, if your lordship feels it, in fact, I too also have no objection. If it is to be particularized, then blood, I have got something to argue before your lordship after getting a report. That's my submission. If it is generally, we have no objection.
What you want to say is, suppose if it is a court monitored investigation, you have no objection.
If it is general, not against only 10 people.
ಎಲ್ಲರೂ ಯಾರು 10-12 ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಯಾರು ನಿಮ್ಮ ಮೇಲೆ ಹೋಗಕ್ಕೆ ಇಲ್ಲ if your client is very innocent prima facie they may not choose you to answer any question at all but ಅವರಿಗೆ ಗೊತ್ತಾಗ್ತದೆ ಯಾರು ಮಾಡಿರಬಹುದು ಯಾರು ಮಾಡಿರಲ್ಲ ನಾವ್ ಹೆಂಗ್ ಹೇಳಿಕ್ ಬರ್ತದೆ it is a domain of the agency concerned.
But ultimately the KPSC will become
option.
Ultimately the KPSC would going to become an accused. Because
you enjoy that.
Because I just read only 3-4 lines of OMRI. It is an international journal.
ಇಷ್ಟೊಂದು ಯಾಕೆ ನೀವು ಅಪೋಸ್ ಮಾಡ್ತಾ ಇದೀರಿ ಅಂತ ನಾನು ತಿಳಿತಾ ಇಲ್ಲ.
ಇಲ್ಲ ನಾನು ಆತರ ಇಲ್ಲ.
ಅಲ್ಲಲ್ಲ ಅಂದ್ರೆ ನೀವಲ್ಲ. Why candidates should oppose if they are clean? Why they should worry? ಅದು ಅಷ್ಟು ಸಿಂಪಲ್ ಇಲ್ಲ ಅನ್ನೋದು ಗೊತ್ತು ನನಗೆ. Police investigation, CBI investigation is a problematic thing. Everybody understands. It is not that I am very innocent and therefore CBI inquiry can be ordered against me. ಅನ್ನಲ್ಲ.
Without
some harassment.
ಸ್ವಲ್ಪ
ಅದು ನಾವು ಯಾವ್ದನ್ನ ನೋಡ್ಬೇಕು ಅದನ್ನ ಬಿಡ್ಬೇಕು ಅಂತ ಅವ್ರಿಗೆ
the report talks up about pinpoints only as against the 10 people. If the report is to be investigated, we have got a right to plead before your lordship. We are innocent. If your lordship feels that this is a recruitment to set right the things KPSC properly, your lordship may take it from us. That
ಅಂದ್ರೆ ಈಗ articulate ಮಾಡೋಣ ನಿಮ್ಮ submission ಅನ್ನು. If it is a court monitored investigation, not against any specific individual, particular individual, you welcome that move. ಏನು ಹೇಳಿ ಅಂದ್ರೆ ಹಂಗ ನೀವು ಎಸ್ ಆರ್ ನೋ ಅಂತ ಹೇಳ್ಬೇಕು ಎಲ್ಲರಿಗೂ ಗೊತ್ತಾಗ್ಬೇಕು ಬಿಕಾಸ್ ಪಬ್ಲಿಕ್ ಈಸ್ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಇನ್ ಡೂಯಿಂಗ್ ವೆದರ್ ಜಡ್ಜ್ಗಳು ಹಂಗೆ ಮಾತಾಡ್ಕೊಂಡು ಹಂಗೆ ಟೈಮ್ ಕಳೀತಾರೋ ಅಥವಾ ಏನೋ ಮಾಡ್ತಾರ ಅಂತ ಪೀಪಲ್
ಇಲ್ಲ ಆತರ
ಪಬ್ಲಿಕ್ ಈಸ್ ಇಂಟ್ರೆಸ್ಟೆಡ್.
As a senior counsel, without even taking instructions from the advocate on record of the clients, I would welcome it
That
Your lordship.
you have only objection to make it specific individual ಮಾಡೋದು ಬೇಡ.
ಬೇಡ.
ಏನ್ ನಿಜವಾಗಿ ರಿಪೋರ್ಟ್ ಇದೆ ಆ ರಿಪೋರ್ಟ್ ತರ್ಸ್ಕೊಂಡು ಏನ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋ ಮಾಡ್ತೀರಿ. ನೀವ್ಯಾರು? ಇಲ್ಲಿ who is this gentle lady standing here? Rajgopal. Be seated. It's not against you. Anyway, kindly be seated. Yes. ನಿಮ್ದೇನು ಉತ್ತರ ಅದಕ್ಕೆ ಆಯ್ತು.
Without reference to the, Lord, this report. Why? Because this committee is constituted foreign for OMR.
ಭಾಗವತ್ ಸ್ವಲ್ಪ ಕ್ರಿಮಿನಲ್ ಸೈಡು ಮಾಡಿರಿ ನೀವು. We have seen some of the reported judgments on criminal side. ಈ ರಿಪೋರ್ಟ್ ಅನ್ನು ನೋಡಬೇಡಿ ಅನ್ಕೊಂಡು ನಾವು ಬರೆಯಕ್ ಬರ್ತದ?
ಬರ್ತದೆ. ಯಾಕೆ ಬರ್ತದೆ ಕೇಳಿದ್ರೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂತ
ಆಯ್ತು ಬರೆದ್ವಿ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ. ಈ ರಿಪೋರ್ಟ್ ಜೆರಾಕ್ಸ್ ಇಟ್ಕೊಂಡು ಅವ್ರು ಏನೆಲ್ಲ ಮಾಡ್ತಾರೆ ಆಮೇಲೆ ನಾವು ರಿಪೋರ್ಟ್ ನೋಡಿಲ್ಲ ಅಂತ ಕೆಳಗೆ ಎಂಡಾರ್ಸ್ಮೆಂಟ್. ಹೌ ದಟ್ಸ್ ಗೋಯಿಂಗ್ ಟು ಹೆಲ್ಪ್ ಯು ಐದರ್ ವೇ.
ನಾನು ಹೇಳ್ತೇನೆ, ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡ್ತೇನೆ. Still my lord feels that report should be referred. I will
It is the domain of the
investigating.
It's the domain of the agency.
Agency too.
But at the same time,
If they start investigation, they have to take out all the relevant reports.
if the committee itself is not involved in this case, if the based on committee report, what should be
Very committee report ಅಂತ ಯಾಕೆ ಅನ್ಕೋತೀರಿ? So much material.
Malad, why I said generally, Lata Kumari,
Lalit Kumar.
Sorry, Lata Kumari, for the first time after the KPSC was established after the under the constitution, the first secretary gave a complaint. There is a corruption against the members and the chairman.
ಅದಕ್ಕೆ ನೋಡಿ ಆಯ್ತು ಅಂತ.
Pardon, Lord.
ಅದನ್ನೆಲ್ಲ ನೋಡ್ಕೊಂಡ್ಬಿಡೋಣ ಅಂತ ಈಗ.
ಅದಕ್ಕೆ 1/24 letter.
In fact, she writes.
Supports. Are you supporting court
Supports
sweep
your,
now?
this thing. That's
Are you- Are you supporting
Not that.
investigation?
Very committee members, again, at whom complaint is made, they are the committee members.
ಕರೆಕ್ಟ್ ಟ್ರುತ್ ಗೊತ್ತಾಗ್ತದ? ಈಗ ಇವ್ರು ಅವ್ರ ಮೇಲೆ ಹೇಳಿದ್ರು, ಅವ್ರು ಇವ್ರ ಮೇಲೆ ಹೇಳಿದ್ರು.
ಹೌದು.
ನಾವ್ ಹೆಂಗೆ ಟ್ರುತ್ ಕಂಡಿಡಿಯೋದು ಹೆಂಗಪ್ಪ?
Therefore, my lord has to say,
ಹಂಗಾಗಿ ನಾವು
committee-
ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡಕ್ಕಾಗ
ಆ ಸಬ್ ಕಮಿಟಿ ರಿಪೋರ್ಟ್ ಅಂತ ರೆಫರ್ ಮಾಡ್ತಾರೆ.
ಬಿಡಿ. ಸಬ್ ಕಮಿಟಿ
that part ಎಂತ-
ಏನೆಲ್ಲ ನೋಡ್ತಾರೆ. What should be 53 Supreme Court. It defined what is meant by investigation. It is left to the domain of the investigating agency.
55 minutes.
What
I'm
are
sorry.
55 Supreme?
55.
You are right. 55 Supreme Court. What all to be looked into by the investigating agency is left to the domain of the investigating agency. ನಾವು ನೀವು ಅದನ್ನ ನೋಡ್ಬೇಡ್ರಿ, ಇಂಥವ್ರು ನೋಡ್ಬೇಡ್ರಿ, 5 ರಿಪೋರ್ಟ್ ಇರೋರ್ನ ಮಾತ್ರ ಕಾನ್ಸಂಟ್ರೇಟ್ ಮಾಡಿ.
Without influence by the report, my lord, independently they should be
Without influencing by anything.
anything.
You hold
Yes.
investigation and come out with the truth ಅಂತ.
Yes.
Influence ಆಗ್ಬೇಡ್ರಿ.
Malad, since your lordship is passing a judicial order.
Correct.
Malad, the reference, Malad, of course, Malad, your lordships are not restricting the powers of the police.
Correct.
But I only said the areas of investigation, your lordships can indicate.
ಅದನ್ನ ನಾವ್ ಹೆಂಗದು ಏರಿಯಾ ಅಂದ್ರೆ ಈ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಏನೇನ್ ಆಗಿದೆ ಅನ್ಕೊಂಡು ಡಿಟೇಲ್ ಬರೆಯೋಣ. ಈಗ as already the tribunal itself has written actually, half of our order is there in the tribunal's order. Whether we agree with reasoning is another thing. But
ಇಲ್ಲ ಅವ್ರೇನು ಬರ್ದಿಲ್ಲ.
ಬಟ್ ಇವತ್ತಿದ್ರಲ್ಲ
ಅದೇ ನೋಡಿದ ಅದ ಏನಂತ
ಹೇಳಿದ್ರು. ಅದೇ ಅದ್ ಚೆನ್ನಾಗಿ ಬರ್ದಿಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ನೀವು ಇಲ್ಲಿ ಬಂದಿರಿ. ಈಗ ನಾವು ಸರಿಯಾಗಿ ಬರೀಬೇಕಷ್ಟೇ.
Whether sub-committee constitute to it, after final it is submitted.
Let truth should come out. Aste. That's all.
Truth somehow
Should come.
Mr.
About without being influenced by any of the reports.
ಅದು ಯಾಕೆ ಹಂಗೆ ಹೇಳ್ತೀರಿ?
ಹಂಗಲ್ಲ.
Why you are so much worried about the report? That is generating doubt in our life. We did not have doubt at all about things.
Exactly other petitioners, nobody else.
That-
That is what I am pointing out.
Ultimately,
If the report is.
something is written, Mr. Bhagwat, something is written here. Satyameva jayate,
Nobody can-
non-rutam. Bidi,
Lord, we are very confident.
that you are not done anything.
Yes.
Bidi,
number
you are
one.
protected by that.
Number two, Malad.
Yes.
So for us to say that there is a tampering of OMR, we have got a, with the assistance of CCTV.
Correct.
That OMR cannot be tampered by anybody unless a person colludes with the agency, that is the KPSC. That's the position. Malad. I have filed already, Malad, 2 lines, I'll just read.
Yes.
Only for
Yes.
assisting to your lordships.
All.
Whenever something OMR ಈ ತರ ಬಂದಾಗ ಸ್ವಲ್ಪ ತಮ್ಮ ಗಮನಕ್ಕಿರ್ಲಿ ಅಂತ.
ಕೊಡಿ.
I have already filed, Malad, the OMR.
Will
ಲಾಸ್ಟ್ ಥರ್ಸ್ಡೇನೆ ಫೈಲ್ ಮಾಡಿ.
ಬೇರೆ ಯಾರಾದ್ರೂ ಏನ್ರ ಹೇಳಿಕ್ಕಿದೆಯಾ? ಆಮೇಲೆ ನಮ್ಗೆ ಏರ್ ಮಾಡಿಲ್ಲ ಹಿಂಗೆಲ್ಲ ಅನ್ಬಾರ್ದು, ಯಾಕಂದ್ರೆ ನಿಮ್ಗೆ ಎಷ್ಟು ಬೇಕಷ್ಟು
file ಮಾಡಿ.
ರಿಲೆವೆಂಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕು. ಹಾ,
Like my lords are closing on
Right.
last.
ತಾವು ಅವ್ರು ಕೊಡ್ತಾರೋ ಇಲ್ವೋ ಅಂತ at least ಒಂದು ವಾರ
ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡಿರಲ್ಲ ಈಗ.
Report
ಇಲ್ಲಿ
date
ನೋಡೋಣ,
ಕೊಡ್ತಾರೆ.
ಕನ್ಸಿಡರ್.
Adjourned ಕೇಳಿ.
Sorry, if,
Application,
that's nothing to do on me.
legal document. It has been given to the courts, it has been given to the government. I can understand why it has not been given. Yes.
This is nothing
And
to
all
do.
names is appeared in the report. Should we not at least to say what the report is?
ಅವ್ರು ಬಿಡ್ಬೇಕಲ್ಲಿ, ನಾವೇನೇ ಇದ್ದೀವಿ.
ಅಲ್ಲ, ನಾನು ಮೆರಿಟ್ಸ್ ಏನು ಹೇಳ್ತಾ ಇಲ್ಲ.
They keep in their pocket.
ಅದೇ.
The only thing I'm saying, their apprehension that investigation will be against somebody is wrong, because though whatever may be the report, ultimately appointment order, ಎಲ್ಲರದ್ದು condition
Subject to
number
that
12
report.
ಅಂತ ಹೇಳಿದ, subject to outcome of the investigation ಅಂತ. Therefore, it will be,
ಚಾಲೆಂಜ್ ಮಾಡಿರಿ ನೀವು.
ಅಲ್ಲ, and after, that is, after 8 months of joining service, accepting that condition. 25th June 2024 is the order of appointment. They reported for duties on 1st or 2nd of July.
ಅಂದ್ರೆ ನೀವು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಗೆ ಯು ಆರ್ ಅಗ್ರಿಯಬಲ್ ಅಂತನಾ ಏನು?
ಅಲ್ಲಲ್ಲ, I am not, I am saying
What to what point your submission is addressing?
their apprehension that it will be against some people, if that is wrong ಅಂತ there is no.
ನಾವ್ ಯಾರನ್ನು ಐಡೆಂಟಿಫೈ ಮಾಡ್ತಾನೆ.
ಅವ್ರಿಗೆ ಯಾರನ್ನು, only one, on the last order sheet ತಾವು members of the subcommittee ಹೆಸರು ಬರೆಯುವಾಗ ಒಬ್ಬರ ಹೆಸರು ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ.
ಅಲ್ಲಿ
ಅದು serial number 3.
ಆರ್ಡರ್ ಡೇಟೆಡ್ so and so.
Order dated 24th March 2025.
Come on. By mistake of the court.
Dr. H.S. Nagendra ಅಂತ ಬರೆದಿದ್ದೀರಾ. It should read as
one person, namely Mr. H.S.
Dr.
Nagendra.
H.S. Nagendra. Narendra.
H.S. Narendra figures.
It should read as R. Girish.
Instead of Mr. R. Girish. Girish. First, this to be rectified, and that order should be read and referring to Mr. R. Girish and not to H.S. Narendra.
Particularly because my lords have appreciated the subcommittee, I wanted that let the credit go to the rightful claimant.
Correct. That's right. ಯಾಕಂದ್ರೆ at least subcommittee ಅವರು ಒಂದು ಕೆಲಸ ಮಾಡ್ಯಾರ. ಏನಾಗಿದೆ, ಯಾವ್ದು ನಿಜ ಯಾವ್ದು ತಪ್ಪು ನಮ್ಗೆ ಯಾರಿಗೂ ಗೊತ್ತಿಲ್ಲ. Ultimately, as they said, we do not know where the cat or mouse, or to use his terminology, ghost, whether there is or not, we do not know.
If the appreciation is given, Lord, what they will do, Lord?
What appreciation we have given? We have appreciated the way the matter is conducted. It does not exclude them from being subjected to investigation.
Allala, my lords have not said about the conclusion.
Can't say that. We do not know.
The court has appreciated them. Yes,
That will be good ground in the event you are indicted.
this will happen. This will happen.
Just is the appreciation about the work they have done.
That's what.
Sir, we do not know.
What is that?
Tomorrow. That's all.
Lordship may appreciate our argument, but case may be dismissed also, my lords.
Ultimately, if they are also involved.
We do not know. Well, it is not that they will get immunity from our words of appreciation.
ನಾನು IA ಮೇಲೆ
Prima facie.
And since
ಕೊಡಬೇಕು ಬೇಡ ಅಂತ. ID pass order IA.
ಮತ್ತೆ ಅವೆಲ್ಲ ಮೇಲೆ ಮಾಡ್ತೇವೆ ನಾವು. ಇದ್ರಾಗ ಈಗೀಗ ಮಾಡಕ್ಕಂತ ನೀವು ಡಿಕ್ಟೇಷನ್ ಕೊಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ಬಿಡಿ ಮತ್ತೆ. ನಮ್ಮ ತಿಳಿದಂಗೆ ಮಾಡ್ತೀವಿ. ನಿಮ್ ಹಿಯರ್ ಮಾಡೇವಪ್ಪ ನಮ್ಗೇನ್ ಇದ್ರಾಗೆ ನಮ್ಮವ್ರು ಯಾಕೆ ಕ್ಯಾಂಡಿಡೇಟು ಇಲ್ಲ. ನಾವೇಂಕು ಮತ್ತೊಂದ್ಸರಿ ಅಪಾಯಿಂಟ್ ಆಗಕ್ಕೂ ಬರಲ್ಲ. Don't worry about other things.
I am not.
Now, Mr. AG, one more, just we are exploring. This
Please.
is a thought aloud. We are thinking aloud.
Please,
Suppose ಅಕಸ್ಮಾತ್ ನಮ್ಗೆ ನೀವು ಸ್ಪೆಷಲ್ ಮಾಡಿ.
please, sorry, Manoj, I couldn't hear, Manoj. Special?
Suppose if there is a suggestion from whichever quarters that be, either from this side, that side, if that suggestion comes, that form an SIT.
Please, Manoj.
Because you are not furnishing the material, we asked you to give in how many
Yeah, it's
COD
ready, my lord.
inquiries, the
It's-
truth has come out ಅಂತ ಕೇಳಿದೀವಿ ನಾವು ಲಾಸ್ಟ್ 5
It's
years.
ready, my lord. It's there, ready, my lord.
ಯಾವ್ದು ಎಷ್ಟು ಬಂದವ್ ನಿಮ್ಮ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಟ್ರುತ್
ಅದರ affidavit ಅಲ್ಲಿ
ಎಷ್ಟ್ರಲ್ಲಿ
ಹಾಕಿದ್ದೀವಿ.
ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಆಗಿದೆ ಎಷ್ಟ್ರಲ್ಲಿ ಕನ್ವಿಕ್ಷನ್ ಆಗಿದೆ ಕೊಡಿ.
This one, Rashmi, can you
That
take
will
it?
establish the credibility of the institution, COD, CID, whichever.
Your Lordship, can you turn to
Charge sheet is filed.
page 35, my lord?
Page 35 of
Our additional affidavit, my lord,
ಕೊಡಿ.
which we are filing now, my lord.
ಎಷ್ಟು ಕೇಸ್ನಲ್ಲಿ ಕನ್ವಿಕ್ಷನ್ ಆಗಿದೆ, ಎಷ್ಟು ಕೇಸ್ನಲ್ಲಿ ಎಲ್ಲ ಕೇಸು ಎಕ್ವಿಟಲ್ ಮೇಲೆ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಮೇಲೆ ಹಾಕಿ.
Yes, my lord. Yes. Ma'am. Page 35, my lord.
35.
Additional update ಕೊಟ್ಟಿಲ್ಲ
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ
ಕಾಪಿ
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವ ತಾವು?
ಇದ್ರದ್ದು ಇದು ಯಾಕೆ ಹಂಗ್ ಮಾಡ್ತೀವಿ? ಎಲ್ಲ ಕೊಡ್ಬೇಕು ಅಷ್ಟು ಮುಚ್ಚಿಟ್ಕೊಳೋದಲ್ಲ. ಕೊಟ್ಟಿದ್ದೀವಿ.
Page 39, my lord. It starts at 35, at 39, my lord.
Thank you.
ಅವತ್ತು ಟೈಪ್
Your
ಜೆರಾಕ್ಸ್
Lordship, these are all referred to CID for investigation, my lord. Police Inspector Recruitment signed number of cases 17, charge sheet is 16, my lord. Malpractice in SDA recruitment examination 8, my lord, charge sheet filed in 8. Police constable recruitment scam 65, my lord, charge sheet filed in 49. High school teachers grade, my lord.
Mr. AG, learned AG,
I'm
come
sorry,
to base 36.
36, my lord.
You have filed charge sheet against in 16 cases.
Your Lordship, yes, my
Under
lord.
trial,
Can I request 39 for a moment, my lord?
39. No, one
Please,
doubt
that
was
will
arising.
just-
One
that
doubt
will-
was, we wanted to clarify one doubt.
Please, my lord.
One case with the SIT is under investigation.
Please, my lord.
Page 36, second line.
Please, my lord.
Who is that person? Still undergoing investigation. This
No,
is
that's
this was
answered
the
in
year
page 39. Can I request page 39, my lord?
39.
Yes, my lord.
39. Police
Just
sub-inspector scam.
Number of cases 7, my lord, charge
That
sheet.
you only have called it a scam before we said.
Allah, yella scam whether.
Yes, yes. Allah, you are very selective in using the language also. Wherever you felt it is a scam, you said scam. Wherever you felt that it is a case, you have said case. In the table.
Your Lordship's observation is.
Table, yes.
ಮ್ಯಾಗ್ನಿಟ್ಯೂಡ್ ಮೇಲೆ ಹೇಳಿದ್ದವರು.
Sometime truth trickles ಅಂತಾರಲ್ಲ.
ಹಂಗಲ್ಲ ಒಬ್ರ ಸ್ಕ್ಯಾಮ್ ಅಂತ ತುಂಬಾ ಜನ ಇನ್ವಾಲ್ವ್ ಆದ ಸ್ಕ್ಯಾಮ್.
That's what.
ಫಸ್ಟ್ 98 ಸ್ಕ್ಯಾಮ್ 98 ಅಲ್ಲಿ KS ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಸ್ಕ್ಯಾಮ್ ಇರಲಿಲ್ಲ.
One person ಯಾರ ಮೇಲೆ ಅದು ಸ್ಟಿಲ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ತಾ ಇರೋದು 36
That is regarding serial number 1, my lord, under investigation ಅಂತ ಇದೆಯಲ್ಲ. Serial number 1, my lord. Out of 17
investigation 1. Who is that person? 1.
I can find out and tell.
Yes, yeah, tell the name after all. Investigation is going on ಅಂತ ಅನ್ಕೊಂಡು ಹೇಳಿ ಯಾರು ಅಂತ.
ಹೇಳ್ತೀನಿ.
ಇನ್ನು ಉಳಿದವ್ರ ಮೇಲೆ 16 ಜನರ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿ ಇವ್ರ ಮೇಲೆ ಇನ್ನೂ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ತಾ ಇದೆ ಅಂದ್ರೆ ಏನು ಅಂತ.
ಅಲ್ಲ ಹೈಕೋರ್ಟ್ ಸ್ಟೇ ಮಾಡಿದ್ದಾರೆ
ಅದನ್ನೇ ಹೇಳಿದ್ರೆ.
Give me some time, I'll just get I'll answer, my lord. ಅದು insofar as the same thing in serial number 4, my lord, out of 3
recruitment. ಇದು ಸ್ಕ್ಯಾಮ್ ಅಲ್ಲ ಕೇಸು ಅಲ್ಲ. You have not mentioned anything. Actually, 8 persons out of a number of cases, these are 8 cases, 8 charge sheets have been filed.
Please, ma'am.
Charge sheet ಆದ್ಮೇಲೆ ಯಾವತ್ತು ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರಿ? ಅದಾದ್ಮೇಲೆ ಮುಂದೆ ಏನಾಗ್ತಾ ಇದೆ?
I'll find out.
ಅದು ಬೇಕಲ್ಲ ನಾವು.
I'll give that information also.
ಚಾರ್ಜ್ ಶೀಟ್ ಆದ್ಮೇಲೆ ಡಿಸ್ಚಾರ್ಜ್. ದೆನ್ ನೋಡಿ 3 ಬಿ ರಿಪೋರ್ಟ್ ಫೈಲ್ ಆಗಿದೆ. ಪೊಲೀಸ್ ಕಾನ್ಸ್ಟೇಬಲ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಸ್ಕ್ಯಾಮ್ 65 ಕೇಸಸ್ 49 ಕೇಸಸ್ ನಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿದೆ. ಅದಾ ಎಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿದೆ. 3 ಬಿ ರಿಪೋರ್ಟ್ ಫೈಲ್ ಆಗಿದೆ. 13 ಡಿಸ್ಪೋಸಲ್ ಅಂದ್ರೆ ಏನದು? ಮೀನ್ಸ್ ಡಿಸ್ಚಾರ್ಜ್, ಅಪಾಯಿಂಟ್ಮೆಂಟ್, ಏನದು ಡೀಟೇಲ್ಸ್ ಏನಿದೆ? 227, 228, 239 ಯಾವುದು ಅಂತ? ಅಥವಾ 226, 227 which?
Your page 36, my lobby, kindly see.
36.
Otherwise disposed of, local police had already.
The remaining Roman number 3, my lord, B, my lord. Charge sheet have been filed in 49 cases. In 3 cases, B final reports were submitted. The remaining 13 cases were otherwise disposed of. Local police have already filed charge sheet in 13 cases under they are not under active investigation. They say that in 13 cases also, Manos, disposition of local police have already filed charge sheet in these 13 cases and they are under trial separately, Manos. In view of the charge sheet having already filed, Manos, they have CID is not doing the investigation.
Come to page 36, Roman 3B.
Correct, Manoj. That is what I was reading, Manoj.
Remaining 13 cases were otherwise disposed of.
Being that, Your Lordship, local police had already filed charge sheet in these cases and they are under trial.
Even they are being tried.
Yes, Manoj.
They are not under active investigation in CID.
CID, because they have already filed charge sheet by the local police against these 13 people, Manoj.
High school teachers, grade 2, physical education teachers, grade in recruitment scam.
Please, Manoj.
Yes. These
In
cases
this charge-
from Vidhan Soda police station, Bangalore case were transferred to CID for investigation 2022. Charge sheet.
And there is
filed
stay in
one
the High
case.
Court and the
Stay.
third case is under in this case, 5 accused persons have obtained a stay order, stay on proceeding before the High Court of Karnataka, and prosecution sanction is awaited for 2 others. A total of 86 arrests were made across the above mentioned cases.
Prosecution sanction ಯಾವಾಗ ಕೇಳಿದ್ರಿ? ಡೀಟೇಲ್ಸ್ ಬೇಕಲ್ಲ ನಮಗೆ. ನಮ್ಮ ಕ್ರೆಡಿಬಿಲಿಟಿ ಬರೋದು ಹೆಂಗೆ ಏಜೆನ್ಸಿ ಮೇಲೆ? ಯಾವತ್ತು ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಮಾಡಕ್ ಸ್ಯಾಂಕ್ಷನ್ ಕೇಳಿದ್ರಿ? ಯಾವತ್ತು ಅವ್ರು ಕೊಟ್ರು? ಯಾಕೆ ಕೊಡ್ಲಿಲ್ಲ? ಲೆಟರ್ ಬರೋದಾಗಿದೆ. ಮುಂದೆ ಅದು ಬೇಕಲ್ಲ ನಮಗೆ. ಅದೆಲ್ಲಿದೆ? ನಮಗೆ you establish your credentials to us that CID can be believed, COD can be believed. You establish that credential by performance.
In fact, the officers, Manoj, having interacted, especially the CID, Manoj, they are one of the best officers, Manoj, and I'm not saying just to satisfy, independent of this, Manoj, they've generally been doing a very good job, Manoj. And I'll show it by what information which is being provided than making a general statement, Manoj.
Before this, my lord, 98 came. What happened? For KAS, not gazetted person. Charge sheet is filed. What happened?
98 ನಿಮ್ ಕೈಯಲ್ಲೇ ಐತೆ CID ಅಲ್ಲಿ?
ಅದು ಕ್ವಾಶ್ ಆಗಿದೆ. But I know, my lord, I appear.
ಮತ್ತೆ ಅವ್ರು ಕ್ವಾಶ್ ಅವ್ರೇನ್ ಮಾಡ್ತಾರೆ? ನೀವೇ ಕ್ವಾಶ್ ಮಾಡಿಸಿರ್ತೀರಿ ಯಾರಿಗಾರ
Department inquiry is quash. What is the charge sheet?
It follows. Investigation. Learned AG.
Please.
ಸ್ವಲ್ಪ ಎಲಾಬರೇಟ್ ಮಾಡಿ ಕೊಡ್ಬೇಕು. ಹಿಂಗ ನಾವು ಹಿಯರ್ ಮಾಡ್ಕೋತೀವಿ.
ಇಲ್ಲ, ಅರ್ಥ ಆಯ್ತು ಮೇಡಮ್. I'll just give further clarity as to every.
ನಮಗೆ ಇಷ್ಟು ಕೊಡ್ಬೇಕು. ಇಲ್ಲಿ ನೋಡಿ, ನೀವೇನ್ ಕೊಟ್ಟಿದಿರಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಯ್ತು ಅಂದ್ರೆ ಮುಗಿಲಿಲ್ಲ, ಟ್ರಯಲ್ ಸ್ಟಾರ್ಟ್ ಆಯ್ತು ಅಂತ ಹೇಳ್ತೀರಿ.
ಸ್ಟೇಜಸ್ ಕೊಡ್ಬೇಕು.
ಸ್ಟೇಜಸ್ ಕೊಡ್ಬೇಕು. ಯಾರಿಗೆ ಯಾವತ್ ಬೇಲ್ ಆಯ್ತು, ಯಾರು ಎಷ್ಟು ಸಾರಿ ಎಕ್ಸಂಪ್ಷನ್ ಆಗ್ತಾ ಇದ್ದಾರೆ, ಅವ್ರು ಬರ್ಲಿಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಟ್ರಯಲ್ ನಿಲ್ಲತ್ತೆ. So that we will furnish the inputs to the committee. ನಮ್ಮಲ್ಲಿ ಕಮಿಟಿ ಇದೆ, ಜಡ್ಜಸ್ ಅಪ್ರೈಸಲ್ ಕಮಿಟಿ. ಕನ್ಸರ್ನ್ ಜಡ್ಜ್ ಯಾರು, ಅವ್ರಿಗೆ ಕಮಿಟಿ ಅವ್ರಿಗೆ ಕೊಡ್ತೇವೆ ನಾವು, ಈ ರೀತಿ ರಿಪೋರ್ಟ್ ಇದೆ ನಮ್ಮ ಬಗ್ಗೆ, ಲುಕ್ ಇನ್ ಟು ದಿಸ್ ಆಲ್ಸೋ ವೈಲ್ ಗ್ರೇಡಿಂಗ್ ದೆಮ್ ಅಂತ ನಾವು ಹೇಳಿಕ್ ಬರ್ತದೆ.
I'll get all the information
for everybody.
I'll do that, Manoj. I'll do that, Manoj. I understand, Manoj, what the information is required for, Manoj. Kindly.
ಅದರಲ್ಲಿ ಯಾವ್ದಾದಿಗೆ ಯಾವ್ದು ಕ್ವಾಶ್ ಆಗಿದೆ, ಯಾವ್ದು ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿದೆ, ಯಾವ್ದ್ರಲ್ಲಿ ಸ್ಯಾಂಕ್ಷನ್ ಅನ್ನು ಕೇಳಿದ್ರಿ, ಯಾವತ್ ಕೇಳಿದ್ರಿ, ಯಾಕೆ ಬರ್ಲಿಲ್ಲ ಸ್ಯಾಂಕ್ಷನ್, ಮುಂದೆ ರಿಮೈಂಡರ್ ಯಾರಿಗೆ ಕಳಿಸಿದ್ರಿ ನೀವು, ಏನಾರ ಹಾಕೊಂಡು ಅದು ಮುಚ್ಚೋಗ್ಲಿಕ್ಕೆ ನಾವೆಲ್ಲ ಹಂಗೆಲ್ಲ ಬಿಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ನೀವು ಡೀಟೇಲ್ ಕೊಟ್ರೆ ನಾವು
ನಾಳೆ ಒಳಗಡೆ ಕೂಡ ತುಂಬಾ ಕಷ್ಟ ಆಗತ್ತೆ ಮೇಡಮ್, ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕಾಗ್ಬೋದು. ಮಂಡೇಗೆ ಹಾಕೊಳ್ಳಿ.
ಮಂಡೇ ಮಾತ್ರ ಜಾನು, ಮಂಡೇ ಇಸ್ ಅಗೇನ್ ಹಾಲಿಡೇ.
ಇಲ್ಲ
ಅಲ್ಲ, ನಾವೇನ್ ಖಾಲಿ ಕೊಡಲ್ಲ, ನಮ್ಗೆ ನೀವು ಆಯ್ತು ಹಾಕ್ತೇವೆ, ನಮ್ ಕೆಲಸ ನಾವು ಮಾಡ್ಕೋತಿರ್ತೀವಿ. ಇನ್ ದ ಮೀನ್ ವೈಲ್
only to file towards filing ಮಂಡೇ ತನಕ ಟೈಮ್ ಕೊಡಿ ಮೇಡಮ್.
ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಅದು ನೆಕ್ಸ್ಟ್ ಇಲ್ಲ, ಆಯ್ತು ಮಂಡೇ ಇದನ್ನ ಕೊಟ್ಬಿಡಿ ಅವರಿಗೆ. ಡೇಟಾ ಕೊಡಿ. ಆಯ್ತು, ನಿಮ್ದೇನಿಲ್ಲ ಅದು, ಅವ್ರದ್ದಷ್ಟೇ.
ಒಂದು ದಿನ ಲೇಟ್ ಆಗತ್ತೆ ನಾನು ನೋಡಿ.
For me also, my lord, 7th.
Your difficulty. ಆಯ್ತು, ಟ್ಯೂಸ್ಡೇ ಹಾಕ್ಬೋದಾ? ನೀವು ಹಾಕ್ಬೋದಾ ಟ್ಯೂಸ್ಡೇ?
ಯಾವತ್ತ
ನೋ ಪ್ರಾಬ್ಲಮ್. Heard again at length. First stop. Rejoinder filed by the petitioners to the objection statement of the respondents is noted.
We have not.
Additional statement of objections are also.
We have not filed rejoinder to the government, only KPS.
Rejoinder. Yes, all. Mr. Prasanna Kumar, we wanted to know one thing. To entrust to CBI, whether anybody needs to be heard, why it should, can have the right of audience at the stage of entrusting the matter to CBI? What are the parameters? Please, Mr. Rajgopal, yield him the mic. Yield him the mic.
Not the, I have not few of the judgments which I'll place it on record, not the compilation. Not the.
What is the law on the point?
No, the first my lord criteria is, the first my lord criteria is that the honorable court must come to conclusion that there is a prima facie case to be investigated. Number one. Number two, if the honorable court were to come to conclusion that higher officials in the state machinery are involved, then not apex court has said it is a fit case to transfer or refer the matter to CBI. But in the case on hand, but as I have been, I'm not observing since.
You
3
may
days.
not know that because no copy is given to you.
Oh, no, though no copy is given to me, but as I can understand is not that higher officials, there are allegations against some higher officials, not from the argument that I can make out. Not in the apex court says it may be a fit case. But these are the two major parameters. Not the apex court also has said the bar contained in section 5 and 6 of the Delhi Special Police Establishment Act
Will not act.
will not
in
act
the
so
way
far
of
as
High Court.
constitutional courts are concerned.
That's right. What is the extent of right of audience of the other side?
Apex court has time and again held the proposed accused need not be heard and they have absolute no right of audience. But also not, I'll place it on.
It is so ahead. Monday, kindly give us a short note of how the law has developed. Okay? So on these things.
Not
Sanction
friend is
itself
saying,
extent ಬರುತ್ತೆ.
17A permission to register FIR or investigate.
Because all the judgments about the non-requirement of state's consent was in respect of the Delhi Special Police Establishment Act. Under section 19, my lord, sanction is required irrespective, even the court has referred the matter for investigation.
Even then sanction is necessary.
Sanction to prosecute is required.
Sanction for prosecuting them.
Either section
not for
17 capital A,
17 capital
Not
A
for
and
17 capital A, permission to register FIR or commencement of investigation. Whether that can be given a go by the orders of the court, or whether there should be direction to the court to consider and do it. Well, that may have to be.
No, suppose if we want to direct investigation against the state officials,
Please.
which government will give sanction to us?
No, not that way, my lord. Now under section 17
17A.
capital A of the PCI, in the matters of exercise of discretion by the officials, prior previous approval of the state government or the concerned government is
Be required
required
by the officials.
by
That
the
is when the
Exercise of discretion by the government.
Yes, ma'am.
But this is not the government.
This is, no,
I think,
Even if the
I think
state-
Rangnath Mishra J. Malad done. 85
On that
Supreme
point.
Court is there.
Huh?
But while considering section 195 of CRPC, we should deal with a case where the complaint has to be given by the officer in charge of the particular court where not offense has taken place. Apex court has held. When higher courts pass such an order
Not
for
applicable
investigation,
ಅಂತ
this
hold ಮಾಡಿದ್ದಿದೆ.
becomes
ಎರಡು
redundant.
judgment ನಲ್ಲಿ ಇದೆ.
This becomes redundant. Therefore,
That makes no
on
sense.
17A, though there may not be any straight point, I think we can infer.
Read 17A ಕೊಡಮ್ ಕೊಡಿ. ಕೊಟ್ಟಾರ sir?
prevention of corruption.
17A ಕೊಡಿ. Does it include the court?
That is
My
not,
lord will have to
that is,
take care of passing the order.
Malad, that is
has
not
to be
applicable to the constitutional court.
That's what I
That is
read.
only applicable to the officers
Correct,
who wanted to register an FIR.
correct. That's how I read. The other court, I think Tripura, some latest judgment I read. I think West Bengal judgment also. West Bengal judgment
2010,
also,
2000.
where Apex Court set aside CBI investigation, saying that it should have been given to the COD itself. You can't doubt the state investigating agency.
Larger bench judgment,
That's
2010.
No, 2024.
17 capital A is introduced in the XODT.
Inquiry or inquiry or investigation of offences relatable to decision taken by public servant in discharge of official function. For them,
correct.
right? Does not. This side, where the alleged offence is related to decision taken by public servant, discharge of function without the previous case of personal. I think there are two judgments which have said that this is not applicable to constitutional clauses.
But this is
Anyway.
being examined for Supreme Court, not whether it should be struck down or not.
Other examine.
Still pending.
All, thank you so much. All right.
Interim-
Post it for, in the meanwhile, we start dictation, just notes and other things we shall prepare so that it becomes easy. We have to answer your question that without, you are entitled to report. We'll, on that also we'll consider.
Interim order.
Manoj, with regard
Interim order
to,
Monday.
yes,
with,
urgently for
AG.
Monday, Manoj?
Monday na? Tuesday ಅಂತ ಏನೋ ಹೇಳಿದ್ರಲ್ಲ?
Tuesday, please, Manoj.
Tuesday. Will it be all right?
Yeah, that's all right, Manoj.
Okay.
Your
Tuesday,
Lordship,
ನಮಗೂ ಬೇಕಲ್ಲ ಈಗ ನಾವು start working now. ಈಗ ಸ್ವಲ್ಪ
with
ಒಳ್ಳೆದಾಯ್ತು.
regard to whether to investigate CBI has the powers, see all that, I'll make my submission on Tuesday with regard to that, Manoj. Whether it matters to be referred to investigation. Now we have ourselves given to the CID, Manoj. We'll file additional affidavit as your Lordship pointed out. The question is, Manoj, CBI counsel saying that they will investigate the matter.
No,
in-
he did not say.
No, no.
Why did he?
On the legal position, saying that
Ah.
every time an I officer is prima facie, first as the Lordship pointed out, Manoj, saying that they've already decided there's an I officer presumption, and the state government is going to protect them, cannot be a ground to investigate unless there is any material before your Lordships.
Required that. That's what he said. in fact.
No, what my learned friend, as and when there is an.
He is not
Allah,
party. We requested him
Not him,
to
Manoj.
assist
I'm
us on
talking
the
about, he's
statement of
representing the
extempore.
CBI, Manoj. Mindset.
CBI only.
ಅಲ್ಲ CBI ಎಲ್ಲ ಸ್ಟೇಟ್ ಅಲ್ಲಿ ಎಲ್ಲೆಲ್ಲ ಐ ಆಫೀಸರ್ಸ್ ಇದೆ ನಾವೇ ಮಾಡ್ತೀವಿ ಅಂತ I'll show various cases where CBI has refused to do investigation, saying that we don't have the manpower, we will not do. If that is the stand, they cannot pick and choose where they want to come and they want to do.
No, they are not interested.
No, they are
We have to
interested.
hold
The
them
submission
and
is they are
bring them.
interested.
If at all we decide.
ಅಲ್ಲ
that
ಅವ್ರು
way-
ಹೇಳೋದ್ ನೋಡಿದ್ರೆ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಇದೆ, ಪ್ಲೀಸ್ ಕೈಂಡ್ಲಿ
No,
ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಕೊಡಿ
No,
ಅಂತ
no, no, Mr.
ಹೇಳ್ತಾ
Learned
ಇದ್ದಾರೆ
AG.
ಅವರು.
Please. We requested him. We asked him to make extempore statement of law. He said, this is the line of rulings. He has, and he also said whether officers are involved, not involved, I do not know because nobody has given the papers to me. After hearing, because you asked me to be present before the court, based on whatever I have heard, on that I am saying this. They are not, we can't say like that. It is not that because Apex Court also has criticized CBI. That also we know. It is not that we were not keeping the things abreast. We are keeping everything abreast. Okay, at least in 2-3 judgments, they have bitterly criticized CBI also. But we want to choose one of the bad things, which is less evilsome. We have to choose one of them. It's not that
One of the
reputation of any
Lordship,
investigating
kind
agency.
consideration here is, Manoj, one of the basic important aspect is, Manoj, what has happened in the KPSC is one aspect. What is that we have done at best, Manoj? It may be an error of decision to the extent we had two options of doing it, Manoj. One option was not appointing. Second option is to appoint with condition. That cannot be a matter of criminal investigation is my respectful submission for your lordship's kind consideration, my lords. Therefore, to say high officers in the state are involved, for which purpose CBI inquiry should be done, may not be correct is my.
Correct.
Your lordship,
Right.
at
Your
best,
submission merits consideration.
please, my lord, just kindly have it on Tuesday. I'll just put.
Very. Tuesday. For further more argument.
I'm sorry, my lord, I'm not
At
personally
2:30.
present.
No,
my
no,
lord.
no problem. No, problem. You are, we understand, we will be held up in some other court, maybe in Supreme Court also. No issue. Yes. No, we wanted to know how is your health now? Sorry.
No, that's the only reason.
God
my
was
lord.
there.
It's much better.
Please get well. Any other date you want?
No, Tuesday is
Sorry,
good. I'll
we
be
did
coming
not,
from Monday. my
no.
lord. I'll be coming from Monday.
You was not well. Sorry, we should have inquired.
No,
Because
no,
after
no,
all, we
not
are
that I
human
didn't want
beings.
to.
Case ಏನಾರ we are human beings first. ಮುಂದೆಲ್ಲ ಒಳ್ಳೆ- That's what. Very well, get well.
Grateful.
Get well soon.
Please,
Well.
In fact, Chief Justice Chandrachud used to make inquiry.
No,
He's a junior.
Yeah, we are all partners in this process. Yes. Interim order to continue. Continue. 13 is good.
ಆಚೆ ಈಚೆ ಆಗಿದ್ರೆ papers ಆಚೆ ಈಚೆ ಆಗಿದ್ರೆ ಮತ್ತೆ ಅಲ್ಲೇ ಹೋಗ್ಬಿಟ್ಟಿದೆ ಅನ್ಸುತ್ತೆ. ಅಷ್ಟರೊಳಗೆ
ಅವ್ರು ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಲ್ಲ ಇನ್ನೊಂದು ಫೈನಲ್ ಇರ್ಬೇಕು. ತಗೋತೀನಿ ಬಿಡಿ ಅಟ್ಲೀಸ್ಟ್ ಅದು ಇನ್ನೊಂದು ಫೈನಲ್. ಆಗ್ಲೇ ಅವ್ನು ನಮ್ಗೆ ಕರ್ಕೊಂಡು ಫೈಲ್ ಬೇಕು. Tuesday.